With your lordship's kind leave, my lord. Just 1 second, my lord. That auction matter cites auctions, my lord.
Which one?
Auction of sites, BDA, my lord. It's tomorrow. Your lordship is specifically directed for the matter to be listed today,
Give it at 2:30.
2:30. I'm grateful, my lord. My lord's matter was to be listed.
Being spoken to now. Oi. Monday. Monday. Oi. Huh? All right. 2:30. 2:30. Monday kodi. Huh? 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 ಏನು ವೆರಿ ಅರ್ಜೆಂಟ್? ನೀವು ಹೇಳಿದ ತಕ್ಷಣ ಅರ್ಜೆನ್ಸಿ ಅಲ್ಲ, ಕರೆಕ್ಟಾಗಿ ಹೇಳಿ ಏನು ಅಂತ. ಆಯ್ತು 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 ಆಯ್ತು. ಈಗ ಏನು ಮ್ಯಾಟ್ರ್ ಅದು? 24th ಅಲ್ಲಿದೆಯಾ? ಮಂಡೇ ಆಗ್ಬೋದಲ್ವಾ? ಮಂಡೇ ಬರುತ್ತೆ ಕೊಡಿ. 2:30 ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅನ್ಕೊಂಡೆ. What is the review there? No, I am conscious about what I have written. Anyway, kodi, we will dismiss it.
Service matter,
Wait. Not all together. Wait. Kodi, 21st bharat kodi.
My lord.
For end of the list, Lord, section 10 application is dismissed. Lord, I filed a suit for specific performance. Lord, the other party filed suit for ejectment. It is now posted for arguments, Lord, tomorrow. We have taken time, Lord, twice.
What is the time of the date of the suit? The year of the suit?
Lord, specific performance.
Yeah, year of this suit.
2012 specific performance. 2014, my lord, the ejectment. Lord, there was a direction, my lord, for trying the suit together.
What were you doing for 14 years, 12 years till filing?
Lord, it was going together.
Nothing.
Lord, change of that, my lord, the specific performance got dismissed. Now the suit for ejectment is
Monday.
Lord, please, my lord,
No, sir, Monday.
My lord's one service matter, my lord.
My lord's matter was supposed to be listed today, but it's not listed.
Supposed to be alla Monday bharutte, don't worry. Yes.
My lord.
Don't give the memo, it will be listed on Monday. Yes.
Guest lecturers, my lord.
2 days. Kodi.
2:30, my lord.
Just now I mentioned that the transfer matter without posting. It has been given back.
FR number ಎಲ್ಲಿದೆ?
FR number ಇವಾಗ ಫೈಲ್ ಮಾಡ್ತೀನಿ.
ಇಂತ ಮೆಮೊ ಕೊಟ್ರೆ ಟ್ರಾನ್ಸ್ಫರ್ ಅಲ್ಲ. I will ask you to post it to Gulbarga. Go and file it and come. Don't think you can throw any paper here.
My lord.
Yes.
2:30, my lord. Guest lecturers, my lord.
Kodi.
Please, my lord.
ಇನ್ನು ಫೈಲ್ ಮಾಡಿಲ್ಲ, giving a memo? First file and then give a memo. What practice is this?
Sorry, my lord, because
What sorry?
it's 10 o'clock, my lord. Now they are just
I will direct the government to transfer you to Gulbarga. ಮಂಡೇ ಇವತ್ತು ಬಂದಿಲ್ಲದೆ ಇರೋದೆಲ್ಲ ಮಂಡೇ ಬರುತ್ತೆ, ಖಂಡಿತವಾಗ್ಲೂ ಬರುತ್ತೆ. ಆಯ್ತಾ?
Date.
Yes.
Monday.
Yes, sir.
Wait, please.
Sorry, sir.
Lord, I am conscious.
Morning blues.
Yes, my lord, yeah. The date for the honorable judge always starts with something which we irritate him on.
Not irritate. Even before filing, if you move a memo, what is the stage?
And we are also partly the cause of irritation because we have held up your lordship's busy court.
That's my lord, right now, my lord,
That's precisely the reason why I have not got all the matters listed today and postponed it to Monday.
my lord, I admit the guilt.
Your
admit
lordship
the
have been
guilt.
so kind to us.
So that
My lord, yesterday I thought that my submissions were over and I have been able to convey, my lord, what is the case of the government.
yes, sir.
But my lord, there are certain issues which I would like to highlight.
Yes, sir.
And therefore, to recalibrating my submissions, my lord, I requested for
Oh,
today.
no issues.
The reason is this, my lord, and I'll be very candid with your lordships. What is the reason? Lord, after the Renault judgment and after advent of internet and its progress, which we have seen, there is no judgment of any Indian court which takes into consideration the progress made by internet, its pervasive impact on the society's thinking process, society's values, societal values, etc. No judgment has taken care of the algorithms which are used for the purpose of content curation and kind of, my lord, an editorial intervention indirectly, may not be human intervention, but by machine. And my lord, collection of metadata of individuals and their submission that now we are still not touchable. We cannot be touched. We can touch private information, personal information of individuals and curate our content, but we cannot be asked. Another question, my lord, which may, my lord, be a relevant factor is, your lordships have seen in the judgment of the Supreme Court of US that even US Supreme Court complains that they don't share their algorithms even with the Supreme Court of US.
Yes.
They are based in US. They are governed by laws of US. Third, similar safe harbor provisions with similar exceptions, exception to exceptions, exist in almost all jurisdictions in the world, where Lord, all intermediaries are following, and this is the only one social media intermediary, Lord, which has a problem and which is before the court.
Yes.
Now, your lordships may, my lord, take my written submissions,
Yes,
and
sir.
I will skip most of it.
Yes, yes, no problem.
My lord, when
No, you can go at your pace, sir. No
no, my
problem.
lord, when my lord, a person argues before the honorable judge for more than half an hour, but he knows, my lord, what to argue, what to skip, and arguing basic points before a particular judge
Yes.
is almost contemptuous. That means that you know that the judge would not understand. I know, my lord, your lordship's grasp is much faster than, my lord, our grasp. I'll leave that, my lord. Kindly come to page 30. I'll leave most of the part. I'll just highlight what are the broad propositions with which I would like to assist the court, my lord.
And I will definitely go through everything and then.
I am very sure about it. Therefore, with that assurance which
Yes,
I have
yes.
given to myself, my lord, I am skipping. My lord, kindly come to page 30, para 67,
Yes, sir.
just to take, my lord, the thread from where I left.
Yes, sir.
Further, the European Union's regulatory response has recently culminated in the Digital Services Act, effective 2024. The DSA retains the basic safe harbor for mere hosts, but adds significant due diligence obligations, especially for very large online platform. What we in our law say, substantial, not significant social media intermediary. It is, I'm thankful. It is submitted that under the DSA, platforms above a certain size must proactively assess systematic risk on their service, such as dissemination of illegal content, impacts on fundamental rights, electoral manipulation, etc., and put in place reasonable mitigation measures. It explicitly allows courts or authorities to issue orders to remove illegal content and even expect quick compliance. We're not posing here only for a minute. In one of my, my lord, one of the paragraphs of my judgment, my lord, I have said that Shreya Singhal does not lay down the correct law, to which the answer of the other side is legally absolutely a correct, right? That can never be argued before the Honorable High Court, because your lordships cannot say. But nonetheless, I have retained, my lord, that submission, so that eventually, my lord, I may request, my lord, a bench of larger combination to reconsider Shreya Singhal
There.
there.
Yes, yes.
Not here. I'll not argue that here. But, my lord, that's the reason. You are absolutely right that that cannot be argued here, and I'm not going to argue it here. But I have to place it, my lord, in the pleadings before the High Court, and we may request, my lord, the Honorable High Court to consider maybe in a 3-judge bench combination that what it was in 2014 and other factors, my lord, I'm not going into. Now, please come to page 31. My lord, these are the facts I have given
Yes.
as per the available documents with us. I'm not reading them. What it is, my lord? What is the compliance of X, the petitioner before your lordships, in other jurisdictions? In some of the jurisdictions, they have imposed fines, they have filed an appeal, they are censured. Some of the jurisdictions.
Stop, my learned friend. Manoj. I just want to make one point.
No, no, I'm coming to that. Please give me a minute.
Para
This-
69 is part of the written submissions,
Huh.
but they are not pleaded. So, I mean, if you just simply say, you have been censured by that court, I don't know what happened in that court. Then,
No,
my lord, if,
it is said appeal is also filed against the order in the
but
other
I,
column.
my lord, I don't know what order has been passed. I don't know what was the context.
That will see.
So, my lord, I just want to
You can
take
reply.
that fact, because to
You
make
can-
an insinuation against my client in a written submission on facts, my lord, all about Reno, subsequent development of the law, of course, my lord, learned solicitor is perfectly justified. But to make an insinuation against my client,
No, you can
That-
reply.
My lord, my learned friend is absolutely right. These are factual assertions.
Yes, yes.
And must come in the pleadings and not in the written submissions. But I have placed, my lord, only to show that there are intermediaries who are not complying with the guidelines, and my lord, forget X, to show to your lordships that there is a concern of every jurisdiction, every country is grappling. I have given instances of X, but I can give instances of, my lord, other intermediaries also, but I didn't want to burden that any deviation from, my lord, the exception to safe harbor, like, lord, taking care, due diligence, etc., is viewed very seriously now by almost all jurisdictions. I leave it at that, my lord. I am not reading it. Lord, now please come to, my lord, the head at page 33, and I'm not going to read this heading. My lord, all contents on the intermediaries is not relatable to
19.
Article 19(1)(a). My lord, all companies have their Twitter accounts, X accounts. My lord, now we are accustomed with the word Twitter. My lord, they propagate their, my lord, idea of their policies, their progress, etc., etc. These are all advertising Twitter accounts. Many of them would be advertising, and therefore, my lord, commercial speech is, my lord, very, very restrictively protected by 19(1)(a) rights, my lord. That's what I have said. Now directly come to, my lord. My lord, I have given the judgments. I'm not reading the judgments.
Yes.
Now, my lord, the next point. Let us see, my lord, on the brass facts of this case. What is under challenge is Rule 3(1)(d). Rule 3(1)(d), the last part. Last part says, whatever is unlawful, you are cautioned, you are not punished, you are not directed to take them. You are cautioned that this is unlawful. The remedy is not to challenge 3(1)(d). If they are aggrieved, they will have to challenge the law which makes it unlawful. I'll give an illustration. My lord, I'll just read, my lord, D1 once again, my lord.
Yes.
An intermediary on whose computer resource, I'm sorry, my lord.
Yes, sir. 3(1)(d).
Yes, my lord. Any intermediary on whose computer resource the information is stored, hosted, so and so, so and so.
Yes.
Kindly come to the last line. Or any information which is prohibited under any law for the time being in force. Suppose I'm giving an illustration in, say, Copyright Act or Trademark Act. There is a prohibition that nobody would use the trademark which is registered in my name. It's prohibited to use it by anyone else. So it would be something if, my lord, some Twitter user publishes my registered trademark or something which is a copyright of mine, my lord, on that in his Twitter account, and I caution him. What I do is I notify him, the Twitter, that this is prohibited under law, particular law. If they are aggrieved, they can say that that provision is unconstitutional. It can be published. Either user can say, or if they are aggrieved, they can say. But you can't shoot the messenger. You can't say that, no, don't even inform me what is prohibited by law. I'm putting a question to myself, my lord, can the government, by making statutory regulations, not have a provision to inform them that this is something which is prohibited by the law of the land? How can, my lord, I'm posing a question to myself, that become unconstitutional? You challenge that law. Suppose, my lord, there is a law that nobody would criticize the government of the day, hypothetical law, and somebody puts a post, my lord, criticizing the government of the day. They can very well challenge that law, but not 3(1)(d). 3(1)(d) is a generic provision. Anything which is contrary to law will have to be informed. But now, please come to page 42.
Yes.
And again, my lord, I'll skip what is not necessary, my lord.
Yes.
But, my lord, two judgments came immediately after the constitution came into force.
Yes.
One was Ramesh Thapar and another was Brij Bhushan. Well, Lord, what was the ratio of that judgment? If I were to say in one line, the ratio was that Article 19(2), which provides for reasonable restrictions, are to be strictly construed. There is no elasticity. And the parliament was acting, your lordships are aware, till, my lord, the first election took place.
Yes, yes.
The first parliament was also acting as constituent assembly. So first parliament, acting in its capacity as a constituent assembly, said that now because of these two judgments, and they discussed the judgments, both the judgments, they say that we will have to do something about it because there may be situations where a particular instance may not fall within strict four corners of the, my lord, contingencies given in 19(2). It may not be sovereignty of India. It may be something relating to that. It may not be public order, something relating to that. And therefore, my lord, I have given, my lord, the debate. Debate is 900 pages. So I have been selective, my lord, in giving the debates which is relevant for the present purpose.
Yes.
But please, my lord, come to what Prime Minister Nehru says. Two or three, my lord, I'll just read for my satisfaction.
Yes.
At page 44, the Prime Minister and Minister of External Affairs, we have come up here naturally because after the experience of a year and a half or so, we have learned much. We have found out some, if I may say so, errors in drafting or in possible interpretations to be put on what we have drafted. That is but natural. And the House will also remember. Then, my lord, kindly see the Dr. Ambedkar. I'll skip that. Your lordships can read it at leisure.
Yes.
Detention laws are something quite different because Ramesh Thapar, etc.,
Yes.
dealt with that. That is in nutshell, Sri Kamath, what a poor nut. Sri Kamath must have said something and everything was get recorded. And in the entire debate,
Yes.
Mr. Kamath and Dr. Ambedkar were opposing each other.
Yes. Yes.
And Mr. Kamath was a little more vocal about his personal
Views on that.
views on
Yes.
the individuals.
Yes.
The case for amending Article 19 of the Constitution. It is next important to consider why the Supreme Court and various state high courts have come to this conclusion. Why is it that they say that Parliament has no right to make a law in the interest of public order? But in the interest of was not the word in the original section.
Yes.
And that they are introducing. In the interest of public order or in the interest of preventing incitement to an offense? That is a very important question. And it is a question about which I am personally considerably disturbed. For this purpose, I must refer briefly to the rules, etc., my lord. Now, please come to, my lord, page 45. Only bold part.
Yes.
How has this happened? This has happened because US Supreme Court, although it was the first court in the world which was called upon to reconcile the fundamental rights of the citizens with the interest of the state, after a great deal of pioneering work, came upon two fixed principles of the Constitution. But Lord, kindly see how lucky we as Indians are. Lord, the formulation of the Constitution was in the hands of people like Dr. Ambedkar, who were not only aware of Indian scenario, but the global scenario, how Constitution is evolving everywhere. And, my lord, we got best of the legal minds, my lord, to this. He referred to police power, which is used, my lord, expression used in America. We say governmental regulation. Police power in America is equivalent to governmental regulation. Please see, my lord, in this context. Reconcile fundamental rights of the citizen with the interest of the state. After a great deal of pioneering work came upon two fixed principles of the Constitution. One is that every state possesses what is called in the United States police power of doctrine. No, it is governmental intervention or governmental regulation in the Indian context, which means that the state has a right to protect itself, whether the Constitution gives such a right expressly or not. They read implied power. The police power is an inherent thing, just as our courts have inherent powers in certain circumstances to do justice. It is a result of this doctrine of police power that the United States Supreme Court has been able to evolve certain limitations upon the fundamental rights of United States citizens. The second doctrine which the United States Supreme Court developed and which it applied for purposes of interpreting the Constitution is known as doctrine of implied powers. According to the decisions of the Supreme Court, if any particular authority has been given a certain power, then it must be presumed that it has got other powers to fulfill that power, and if those powers are not given expressly, then the Supreme Court of United States is prepared to presume that they are implied in the Constitution. They are trying, the Constituent Assembly is trying to make 19(2) contingencies elastic, which was read as static in Ramesh Thapar and Brijbhushan, that you cannot travel beyond these words. They say that no, we will have to sometimes to give meaning and effect to the provision itself, that we have to read it expansively. Now, your lordships may kindly, my lord, turn the page. Now, Lord, on the next page, the top line.
Yes.
Lord, now Dr. Ambedkar refers to those two judgments, Ramesh Thapar and Brijbhushan. The reason why the judges of the Supreme Court do not propose to adopt the doctrine of police power, that is governmental regulation to be presumed, is this. So far as I am able to understand, the Constitution has enumerated specifically the heads in clause 2 under which Parliament can lay restrictions on the fundamental rights as to the freedom of speech and expression, and that as Parliament has expressly laid down the heads under which these limitations should exist, they themselves now will not add to any of these heads which are mentioned in clause 2. That is sum and substance and the construction that you will find in the case of Thapar's judgment, which was delivered by Mr. Justice Patanjali Shastri. Now, please come to the next page again, Dr. Ambedkar.
Yes.
The point that I was trying to make to the House is that on account of the declaration by the Supreme Court that this Parliament has no capacity to make a law in certain heads under 19(2). The question before the House is, can we allow the situation to remain as it is, as created by the judgments, or we must endow Parliament with the authority to make a law? Can we make the heads elastic? My lord, thereafter, my lord, matter goes to the select committee, and my lord, select committee also says something. Please directly come to my lord now what Mr. Rajgopalachari says. My lord, first, my lord, page 48.
Yes.
Jawaharlal Nehru. See, Nehru continued to stress the importance of approaching the Constitution in a dynamic spirit. That it is an evolving document. It is not static. What was true in the year 49 may not be true in the year 2026. It's a living document. A constitution must be respected if there is to be any stability in the land. A constitution must not be made the plaything of some fickle thought or fickle fortune. That is true. At the same time, we have in India a strange habit of making gods of various things, adding them to our innumerable pantheon and having given them our theoretical worship, doing exactly the reverse. If we want to kill a thing, we deify it. If you want, you make a god out of it, and that thought goes. That is the habit of this country largely. So if you wish to kill this constitution, make it sacred and sacrosanct, certainly. But if you want it to be a dead thing, not a growing thing, a static, unwieldy, unchanging thing, then by all means do so, realizing that that is the best way of stabbing it in the front and in the back. Beautifully, that if you make it static, you stab the constitution from both the sides. Lord, now see Rajgopalachari, Lord, intervenes. One of Lord, the legendary stalwarts and my lord, a scholar in his own right. My lord, please come to page 50. I'll not read, my lord, the whole, but my lord, kindly come to page 49.
Yes.
How he explains. My lord, he is also fully conversant with the law and how laws are made. We were not, my lord, in the hands of only laymen. Well, if your lordships must have gone through constituent
Yes,
assembly
yes.
debates, even the laymen in the sense that they were not legally trained minds, they have also contributed immensely by
Yes.
their foresight that this is what may happen. Now, Dr. Rajgopalachari, last part, the highlighted part. An incitement to offense is not necessarily an abatement. An abatement has to be directed to a particular offense and it should be proved in a particular manner. But surely we do not want people to say on the one hand, there should be no black marketing, and on the other hand say, people should be allowed to write and freely circulate statements and expressions saying, we honor man who break this law and we want you to break the law so that the law itself may be changed. We do. So he's now dealing with the freedom of expression
Yes.
and the necessity to change or make elastic the heads under 19(2). We do not want that kind of contrary attitude with regard to crime. Let us pass laws with reference to crime with all care that we can. But having passed that law once, let us not stultify ourselves by saying that freedom of expression must be any man may circulate stuff inciting people to break that law and reduce it to nullity. Now, my lord, the bottom highlighted part of Dr. Rajgopalachari, this clause only permits legislature to take notice and take due measure to prevent such incitement to offense, and that is the reason behind this clause and not any intention to curb the freedom of speech. Freedom of speech, put most briefly, is a thing to be used and not to be abused. Of every natural right, there can be use as well as abuse, and governments and parliament and legislatures have to prevent abuse, and it is not interference with the freedom if we prevent that abuse. And when they say clause was making it elastic by adding the word in the interest of and incitement to offense. Well, that was also added. Now, your lordships may, my lord, kindly come to how
To end that, I think the para 105,
Yes.
what began as discussion is beautifully put, and then the discussion goes on.
yes, my lord. He
Now,
says
what is this right we are
right
discussing?
and
Discussing? The right we are discussing is natural right,
Yes.
right to freedom of expression. It is a natural right. No one can claim that natural right is like a right given in a clause of lease of an insurance policy to be enforced like Shylock's pound of flesh.
yes, my lord.
This is what he begins, and then
So, my lord, what he says, my lord, I skipped that. I read it. What it possibly he tries to say, and the beautiful philosophical content, that certain rights are natural rights. They are not conferred upon. My right not to be abused is my natural right.
Exactly.
It is recognized by the Constitution, not given by the Constitution. My right to privacy is my natural right. It is recognized under Article 21. It's not given by Article 21. He starts with that.
starts with that and explains why it
Explains,
is
my lord.
important that expressions are controlled.
And, my lord, why incitement to an offense is relevant, my lord.
Yes.
Now, your lordships may, my lord, come to, my lord, now, my lord, this constitutional amendment passes. And, my lord, the static heads, sovereignty and integrity of India, friendly relations, etc., including public order,
Yes.
now has one prefix, in the
Interest.
interest of. Now, my lord, how that expression in the interest of is, my lord, understood by our courts. I will read only one or two judgments, not read every judgment, my lord. But the first judgment after this amendment was Patna High Court judgment. And, my lord, that is, my lord, it may assist your lordships, my lord. That is,
Devi Soren.
yes, my lord. Kindly have a look at, my lord, page 52.
No, Devi Soren is quoted in VG Row.
Yes,
That is what is. here.
Yes, my lord. It is important in this context to bear in mind that the test of reasonableness, whenever prescribed, should be applied to each individual statute impugned, and no abstract standard of general pattern of reasonableness can be laid down as applicable to all cases. The nature of the right alleged to have been infringed, the underlying purpose of the restrictions imposed, the extent and urgency of the evil sought to be remedied thereby, that is where the nature of the medium comes in the context of these facts, my lord. That what is to be remedied and urgency for remedying it, because it spreads like wildfire across the globe, should all enter into the judicial verdict. In evaluating such elusive factors and forming their own conception of what is reasonable in all circumstances of a given case, it is inevitable that the social philosophy and the scales of values of the judges participating in the decision should play an important part, and the limit to their interference with legislative judgment in such cases can only be dictated by their sense of responsibility and self-restraint, and the sobering reflection that the Constitution is meant not only for people of their way of thinking, but for all, and that the majority of the elected representatives of the people have, in authorizing imposition of the restrictions, considered them to be reasonable. That is also one of the consideration for the court while exercising power of judicial review. But in 1952, but thereafter, the first judgment of the Constitution bench is Ramji Lal. I'll read only highlighted part on page 53 and nothing more.
Yes.
In the first place, EL is typo, it's clause. Clause 2 of Article 19 protects a law imposing reasonable restrictions on the exercise of the right to freedom of speech and expression in the interest of public order. So they put it under the inverted comma, that this is now an inserted clause, which is much wider than for maintenance of public order. If therefore certain activities have a tendency to cause public disorder, a law penalizing such activities as an offense cannot but be held to be a law imposing a reasonable restriction, even if it is a penal law. This is not a penal law. This is not even an injunction. This is only a caution. This is only lifting a conditional exemption, that you are exempted subject to conditions.
There it was 295A interpreted.
Now,
Yes.
Activities cannot be held to be a law imposing in the interest of public order, although in some cases those activities may not actually lead to a breach of peace or public order. Lord, this was a challenge to section 295A of the Indian Penal Code, that eventually your act may not result into the actual public order, but even if the action is relatable to it, if action is taken in the interest of public order, it will have to be justified, it will have to be, Lord, upheld. Lord, now please turn the page over, my lord, and Virendra versus State of Punjab, again a constitution bench, my lord. This was case of a newspaper.
Yes.
And the Punjab Act was under challenge as violative of 19(1)(a). Please see, my lord, para 114, only the bold part. The powerful influence of newspapers for good or evil on the minds of readers, the wide sweep of their reach, the modern facilities for their swift circulation to territories distant and near, must all enter into the judicial verdict, and the reasonableness of restrictions imposed upon the press has to be tested against this background. My lord, this is the judgment of the year 57, where they say that even the newspaper has a wide reach. Now, my lord, it's uncomparable. Then second highlighted part, our social interest ordinarily demands the free propagation and interchange of views, but circumstances may arise when the social interest in public order may require a reasonable subordination of social interest in free speech and expression to the needs of our social interest in public order. Lord, this is again a constitution bench judgment with regard to a media, with regard to Article 19(1)(a), right, and analyzing the reasonableness of the restriction. My lord, then, my lord,
No, next 4 lines also is very good.
yes, my lord.
Our
Our constitution recognizes this necessity and has attempted to strike a balance between the two social interests, competing
Yes,
interests. It permits the imposition of a reasonable restrictions on the freedom of speech and expression in the interest of public order, and on the freedom of carrying on trade or business in the interest of general public. my lord, then your lordships may, my lord, see the next judgment is, my lord, Fagera prison. My lord, this was an oral speech. My lord, I'll come directly to page 56
Yes.
and the top, my lord,
Yes.
bold part.
Yes.
This observation also indicates that public order is equated with public peace and safety. Presumably, in an attempt to get over the effect of these two decisions, the expression public order was inserted in Article 19(2) of the Constitution by the Constitution First Amendment Act 1951 with a view to bring it offences involving breach of purely local significance within the scope of permissible restrictions under Clause 2 of Article 19. After the said amendment, this court explained the scope of Ramesh Thapar and state of Bihar, in state of Bihar. That case was concerned with the constitutional validity of Section 41A of the Indian Press Emergency Powers Act. It deals with the words or signs or visible representations which incite or to encourage or tend to incite or to encourage the commission of any offense of murder or any cognizable offense involving violence. Then, my lord, para 11 of that judgment. But in India, under Article 19(2), the wide concept of public order is split up under different heads.
Yes.
It enables imposition of reasonable restrictions on the exercise of the right of freedom of speech and expression in the interest of security of state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. All the grounds mentioned, Lord, before this, there was a confusion that in the interest of applies to the next head only, not to all heads. For the first time, Lord, the Constitution bench clarifies this. All the grounds mentioned therein can be brought under the general head public order in its most comprehensive sense. But the juxtaposition of different grounds indicate that though sometimes they tend to overlap, they must be ordinarily intended to exclude each other. Public order is therefore something which is demarcated from others. Well, then para 18. The foregoing discussion yields the following results. 1. Public order is synonymous with public safety and tranquility. Tranquility concept is brought for the first time. That public order is not that people would start with swords and lathis in hand. Tranquility of the public also can be damaged in various forms. It is the absence of disorder involving breaches of local significance in contradistinction to national upheavals such as revolution, civil strife, war affecting the security of the state. And second, there must be proximate and reasonable nexus between the speech and the public order. Now, my lord, come to American judgments on restricting free speech cannot be relied upon. Madhu Limaye, Babulal Parathe, etc., etc. I will not read them.
In fact, public order and public tranquility, they differentiate in Madhu Limaye and say public tranquility as defined in American jurisprudence would not be helpful here.
Yes, my lord. Madhu Limaye is 7 judge.
Yes, 7.
It's a 7-judge bench judgment, my lord. And my lord, I have quoted the relevant part.
Yes.
But my lord, there is one thing in Babulal Parathe. I want to just cite it, my lord.
Yes.
Please see Babulal Parathe, my lord. It's a constitution bench, 5 judges.
Yes.
Para 23.
Yes.
Argument that the test of determining criminality in advance is unreasonable is apparently founded upon the doctrine enumerated in Shank case, that previous restraints on the exercise of fundamental rights are permitted. Your lordships would recall,
Yes.
Shreya Singhal judgment
Shank.
relies on this Shank judgment, my lord, that shouting fire in the
Yes.
5-judge bench has specifically said that this does not apply to Indian scenario, and confirmed by the 7-judge bench in Madhu Limaye. But Shreya Singhal, my lord, this will have to be argued before the Honorable Supreme Court. But Shreya Singhal relies upon a judgment which is held to be not applicable in the Indian context by 5-judge bench, confirmed by the 7-judge bench. Lord, now kindly come to page 61. para 10,
Yes.
Lord of Lord, this
Ram
is
Leela
Ram
Maidan.
Leela Maidan incident, my lord. Para 10 only, my lord, I'll read. The fundamental right enshrined in the Constitution itself being made subject to reasonable restrictions, the laws so enacted to specify certain restrictions on the right to freedom of speech and expression have to be construed meaningfully and with the constitutional object in mind, not mechanically. Freedom of speech and expression, untouchable. Don't touch it. Now, my lord, I'll skip that, my lord.
In fact,
my
Shank
lord,
is again quoted and
yes, my lord, the race star, my lord, that
para 8, they say, not
yes,
an absolute right, but
yes,
that's the
yes,
difference between our constitution and American jurisprudence.
absolutely. My lord, these are all judgments on this proposition that American judgments on freedom of speech and expression can never be relied upon while defining the contours of Article 19(1)(a) read with 19(2) in the Indian context. All these judgments, my lord, going up to page 66 are those judgments, my lord.
Yes.
My lord, last one is Arup Bhuyan, 2023, 8 SCC.
Yes.
There again, my lord, Benderberg was, my lord, cited before a two-judge bench. Lord, we requested and the matter was placed before the honorable three-judge bench.
Yes.
And the three-judge bench, my lord, declared two-judge bench judgment to be not a good law on the ground that Bendenberg, which is already held to be not applicable, is the basis of that judgment. Somewhat similar, my lord, which I would, my lord, if permitted, would wish to argue before the Supreme Court for Shreya Singhal. But I leave it at that. My lord, now chilling effect argument. Now, what has happened is, please appreciate, my lord, Twitter, by their own admission or by their own case before your lordship, is that we are not having any speech. We do not have any expression. We do not have any view. We are only a platform. We offer a platform where others express their freedom of their views, opinions, expressions, etc. Lord, I am posing a question to myself. If that is their foundation in the petition, that I am only a platform, I am only a notice board, then how would they be able to invoke Article 19(1)(a)? It's not their freedom of speech and expression which is violated, though they brought somebody, my lord, as intervener, but he is an intervener, not a challenger. But, my lord, I am not, my lord, leaving at that. I can, my lord, say that therefore the 19(1)(a) is not available to them and therefore your lordships may not go into. But this is an opportunity where I would request your lordships to go into, while holding that they have no right. But please examine our validity of our law. But to come out of this argument, they say chilling effect. Now, chilling effect, my lord, is a word coined for a different purpose, but used at a drop of the hat when you have no other argument. And the chilling effect is this, that I am a platform. I give platform to others to express their ideas. If others know that my view is likely to be taken down under 3(1)(d), there would be a deterrent effect in them in
Kindly excuse me for a minute. Sorry. Excuse me.
in posting something. So Tushar Mehta will be afraid of posting on the ground that government may inform Twitter that this is unlawful under 3(1)(d).
That's the chilling effect.
That's chilling effect on me. And
Yes.
therefore, they are representing those who are being chilled by 3(1)(d).
Who would upload?
To
into the-
upload.
Upload, yes.
My lord, first, Lord, this chilling effect is now dealt with by a three-judge bench. Shreya Singhal is a two-judge bench judgment. After referring to Shreya Singhal, after referring to the chilling effect, my lord, I had an occasion to, my lord, assist the court in this judgment.
Anuradha Bas.
Anuradha Bhasin, my lord, which was an internet ban in Jammu and
Yes,
Kashmir.
Jammu and Kashmir.
Please have a look at, my lord, only one paragraph. It's a three-judge bench judgment, my lord,
Yes.
at the cost of repetition. The widening of the chilling effect doctrine has always been viewed with judicial skepticism. At this juncture, we may note the decision in Larid versus Statham, that is US Supreme Court, wherein the respondents brought an action against the authorities to injunct them from conducting surveillance of lawful and peaceful civilian political activity based on the chilling effect doctrine. The United States Supreme Court, in its majority decision, dismissed the plea of the respondent on the ground of lack of evidence to establish such a claim. That chilling effect must not be pleaded, that there is a probable, there is a hypothetical chilling effect. Supreme Court of United States says allegations of a subjective chill are not an adequate substitute for a claim of specific present objective harm or a threat of specific future harm. Now our court says, my lord, in Anuradha Pasim,
Yes.
therefore to say that the aforesaid restrictions were unconstitutional because it has a chilling effect on the freedom of press generally is to say virtually nothing at all, or is saying something that is purely speculative unless evidence is brought before the court to enable it to give a clear finding which has not been placed. That this is how there is a chilling effect. There were 100 people who wanted to upload, but they said we are not uploading because we are afraid. Thereafter, my lord, the court goes on, my lord, to analyze how in that case, for example, Anuradha Basin was, my lord, owner and editor of one newspaper. So she said internet ban has a chilling effect, etc., etc. The court said that you have not even given people similarly situated like you are also equally chilled. There are several newspapers published from Jammu and Kashmir. Even that is not done. So chilling effect is not, my lord, an all-in-all solution in 19(1)(a) rights, my lord. My lord, then, my lord, Larid versus Tatum, my lord, which is cited by our court, my lord, with and accepted. Lord, please have a look at page 68. And this is the last decision on this subject, my lord.
Yes.
I will not trouble
Yes,
your
sir,
lordship
yes.
further. My lord, it's quoted. I will not read it, my lord. I can go, my lord, further. My lord, rest of the judgments are on the same line, and therefore I am not, my lord, reading. Kindly directly come to page 74. My lord, I have said that in Cricket Association of Bengal, I would wish to assist your lordships with the minority, not minority, concurring view of Justice B.P. Jeevan Reddy. It's a concurring view. So it is equally, my lord, I will not say binding, my lord, but it is equally having the force of law under Article 141. My lord, in majority, I have read, my lord, when I
Yes.
read Cricket Association,
Yes.
but this is concurring view of Justice B.P. Jeevan Reddy.
Hearing view always goes with the majority view.
Yes,
It is always to be read along with the majority.
it's a majority.
Yes,
view.
it's
It
a
is a
different-
law of the land. Concurrence is always a law
Yes.
of the land. And it has a binding effect.
Yes.
Because sometimes the honorable judges concur on a different point.
Yes.
They come to a same conclusion, but with
On different
another
reasons,
route, another
different
argument.
reasons.
Even those arguments
Yes.
which are accepted is a binding law under 141. Kindly have a look at, my lord. This is, my lord, really illuminating judgment, my lord. Page 70,
5.
no, my lord, not 75, page 78,
Yes, sir.
para 187.
Yes.
This is really, my lord, illuminating view, and you may assist your lordships, my lord, subject
Yes,
to your
yes.
lordships, my lord, being persuaded. A look at the grounds in clause 2 of Article 19, in the interest of which a law can be made placing reasonable restrictions upon the freedom of speech and expression, goes to show that they are all conceived in the national interest as well as in the interest of the society. You know, this was television and freedom of expression under 19(1)(a) being curtailed in the medium of television. Kindly bear that in mind, because the court said that medium is different and different medium makes the difference when we evaluate 19(1). The first question of grounds, that is the sovereignty and integrity of India, the security of the state, friendly relations with foreign state and public order are grounds referable to national interest, whereas the second set of grounds, that is decency, morality, contempt of court, defamation and incitement to offense, are conceived in the interest of the society. The interconnection and the interdependence of freedom of speech and the stability of society is undeniable. They indeed contribute to and promote each other. Freedom of speech and expression in a democracy ensures that the change desired by the people, whether in political, economic, or social sphere, is brought about peacefully and through law. That change desired by the people can be brought about in an orderly, legal, and peaceful manner is by itself an assurance of stability and an insurance against violent upheavals, which are the hallmark of societies ruled by dictatorships, which do not permit this freedom. Lord, kindly come to 188.
Yes.
It is for this reason that our founding fathers, while guaranteeing the freedom of speech and expression, provided simultaneously that the said right cannot be so exercised so as to endanger the interest of the nation or the interest of the society. Lord, now it's not just public order, it can be even interest of the society. As the case may be, this is not merely in the interest of nation and society, but equally in the interest of freedom of speech and expression itself. The reason being the mutual relevance and interdependence aforesaid. Reference may also be made in this connection to the decision of US Supreme Court in so and so, referred to herein above, wherein it has been held that to deny a station license because the public interest requires it to be, it is not a denial of free speech. It is significant that this was so said with reference to First Amendment to United States Constitution, which guarantees the freedom of speech and expression in absolute terms. Your lordships are aware, there are nothing like 19.2. There, those freedoms are absolute, no reasonable restrictions conceived or contemplated in United States. The reason is obvious. The right cannot rise above the national interest and the interest of society, which is but another name for interest of general public. It is true that 19.2 does not use the word national interest, interest of society, or public interest, but as pointed out herein above, the several grounds mentioned in clause 2 are ultimately referable to interest of the nation and of the society. So now the elasticity, I'm sorry,
Yes.
the elasticity in the heads under 19.2, which was conceived in the First Amendment, is applied. That it is not static. In the interest of means it falls, brings within its sweep several things. And it will have to be widely construed.
Yes.
Now, please come to, my lord, page 81. My lord, Puttu Swami judgment.
Huh.
I'm sorry, my lord, the judgment, this very judgment, but last part, my lord.
Yes, para 199.
199.
Yes.
All the constitutional courts whose opinions have been referred to herein above, herein before, have taken the uniform view that in the interest of ensuring plurality of opinions, views, ideas, and ideologies, the broadcasting media cannot be allowed to be under the monopoly of anyone, be it monopoly of government or of individual, etc., etc. Only, my lord, highlighted part. This again is the implicit command of Article 19(1)(a). This medium should promote the public interest by providing information, knowledge, and entertainment of good quality in a balanced way. Now, my lord, Puttu Swami, it is, my lord, customary to cite in every case whether, my lord, when you want to show that you are a great constitutional lawyer, my lord, in every case, you start with either earlier Keshwanand Bharti and now Puttu Swami. I'm not, my lord, citing Puttu Swami. Your lordships are, my lord, aware of it.
Yes.
Lord, but I'm reading, my lord, Kaushal Kishore.
Yes.
It's a constitution bench. But I always avoid citing Puttu Swami unless it is really on the point. But otherwise, in all constitutional benches I have seen, or even in regular court, regular matters, some of our constitutional experts, they start with earlier Keshwanand Bharti, and now they have Puttu Swami. I see Golaknath. Yes, yes, it starts with Golaknath and Shankari Prasad and everything, and then
now the advocate on record's favorite judgment is this. Puttu Swami.
Puttu Swami.
For everything he comes up with that.
Must be from NLU. I have seen, my lord, all NLU grades. They are brilliant people.
Yes,
my lord,
yes.
They are much more informed, much more focused. Lord, this generation is definitely much better than our generation.
Yes,
but
yes.
Lord, they are taught to be constitutional lawyers and not lawyers. So they start with, my lord.
And the challenge for lawyers like us, my lord, is to keep pace with them.
Yes, well, yes, my lord, it's a challenge. My lord, now Kaushal Kishore, my lord, again a concurring opinion.
Yes.
Please see, my lord. Per contra, in respect of speech and expression which constitutes an exchange of ideas, including dissent or disagreement, and such ideas are expressed in a manner compatible with the ethos cultivated in a civilized society, the duty of the state to abstain from interference is high. Similar, my lord, then para 193.4. It is evident from the above illustrations the extent of protection of speech would depend on whether such speech would constitute a propagation of ideas or would have any social value. If the answer to the said question is in the affirmative, such speech would be protected under Article 19(1)(a). If the answer is in the negative, such speech would be protected under Article 9, would not be protected under Article 19(1)(a). In respect of speech that does not form the content of Article 19(1)(a), the state has no duty to abstain from interference having regard to Article 19(2) of the Constitution and only the grounds mentioned therein. So, my lord, unlawful thing is not a speech at all. So, there is no question of, my lord, curtailing it.
Every
So, 10 your
citizen
lordships can, my lord, read it, my lord. Now, my lord, history of safe harbor provisions. I'll very briefly, my lord, I'll not take your lordships through.
every citizen of India must consciously.
My lord, there are two
restrain their
judgments which
speech.
which we found yesterday.
Yes.
But therefore, they say, my lord, never give overnight to a lawyer, my lord, and he comes out with something new. But this only says that reasonable restriction is elastic and dynamic and must meet with the demands of time. It's not static. That public order means something should happen in some area that people should start rioting. That's not the case, my lord. My lord, there are 6 judgments. My lord, there are 6 judgments. I'm not going to read any of them.
Yes.
And I have, my lord, relevant paragraphs. I will give it to your lordships because some judgments are very lengthy.
Yes.
And I think we can give it. My lord, I will, my lord, along with this, my lord,
Yes.
I'll give the relevant paragraphs. So
That is not there.
your lordships,
That- yes,
well, I have the
Yes.
Xerox copy.
Yes.
It says, my lord, reasonable restrictions should be elastic. Lord, very fundamentally, why would the Constitution use the word reasonable restrictions? Why would it not say that restrictions? The word existence of the word restriction would itself mean that there is an elasticity given to the Parliament that you can decide the reasonableness depending upon the menace or situation you are dealing with, and according to the reasonableness conceived by the Parliament, of course subject to judicial review, you can mold the section. So it's not that public order means public order. It should be reasonably construed, elastically construed, and it will have to be construed to achieve the object which it seeks to achieve. Well, these are the
Yes.
6 judgments, and I'm not
I'll look into it.
reading.
All on.
The point is, if rights are dynamic, even the restrictions will have to be dynamic. For example, Article 21(a) initially was read in the static sense. It was, my lord, adopted from Japan verbatim. In Japan also that is being, my lord, evolved. India also it is evolved. Now everything is covered: right to dignity, right to bodily integrity, right to food, right to education, right to environment, everything. If right can expand, so will have to the restrictions with reasonableness. So when we say 19(1)(a), 19(2) also will have to have that expansive meaning.
So the submission is that they go hand in hand.
Yes,
Yes.
they will have to.
Have to.
Right and duty go in hand in hand.
Yes.
Right and reasonableness of restriction
Also go hand in.
will have to go in. It cannot be argued that 19(1)(a) will continue to expand, but 19(2) will
Restrictions
be
will not.
static.
Then it will lose its dynamism.
Dynamism. That constitution becomes static, not a living document. Now, my lord, next point, and I'll not, my lord, trouble your lordships in detail. I'll just broadly say why I have put this, my lord. My lord, we researched on this, my lord, that in print media, there was no safe harbor. There was a strict liability. Strict liability means you are responsible. In electronic media also, there was none and there is none. There is no there is no protection. Lord, when internet started evolving, several electronic related issues started cropping up. The first judgment which came, which I'll not read, I have cited it, my lord, was with respect to somebody posting a my lord, something which was protected under the Copyright Act.
Copyright.
It was, my lord, some Playboy images were,
Yes.
my lord, posted in a intermediary called Bulletin Board Systems, BBC. One Frenna, my lord, was the owner.
Yes.
He said that I have physically checked everything and I have thereafter removed it. How am I responsible? But that was a regime of strict liability, and therefore he was held liable that because it is in on your platform, you are responsible. I'm not reading it, my lord. Strict liability principle was evolved. Now, my lord, evolution was that all intermediaries around the world in their respective governments, respective parliaments, etc., they started making a representation that, look, our medium is different. We are only providing a platform, and rightly so. They are only providing a platform. They are manipulating the curating the content, that apart, but their basic job is to provide a platform.
The platform, yes.
So they said that let us have a midway approach. Don't make us responsible with strict liability that because something is posted or hosted in my platform, I am responsible. Make it conditional, and this is important, make it conditional upon my actual knowledge and still not acting. That was a very sensible middle way. That if somebody informs me that there is something unlawful which is capable of being challenged before the court, and I don't do anything, then I am responsible. Otherwise, I have lakhs and crores and millions of posts, I cannot check. Though they do check. There are algorithms available. There is a check available. There are filters available. But they choose not to filter certain things if they are getting more hits. And I'm not saying about only Twitter. This is true about any intermediary where, my lord, their revenue model is built upon more hits and therefore more generation of revenue. So, my lord, now, my lord, for the first time, the United States Supreme Court at page 90.
That's an Clinton administration.
Yeah, yes.
1993.
93, my lord, yes. Came out that all right, this middle way.
Strict liability.
No strict liability, but if you are informed and you have the actual knowledge, then you are liable. If you are not aware, then you are not liable. That was a midway. So it was on their request, the intermediary's request, that actual knowledge will hold us liable. That this entire regime was developed. Now please come to page 90. I'm not reading it, but this is, my lord, section 230 of the Communications Decency Act, where your lordships would find at page 91, protection for good Samaritan blocking and screening of offensive material. That is the head. And they were exempted because somebody has informed you. And this was, please remember, this was an era where even a private person can inform.
Yes, yes.
Actual knowledge was necessary, which is now,
interpreted
that actual knowledge means court order, not a private individual. Now, my lord, please come to page 93, para 179. Lord, this would be relevant because other jurisdictions have also followed, my lord, this. Thus, from the above discussion, it can be seen that though initially intermediaries were made strictly liable for any unlawful material available on their platform, but sensing advantages of internet in the field of educational, e-commerce and informational resources, and considering high utility of intermediaries in providing a forum for true diversity of political discourse, unique opportunities for cultural development, and myriad avenues for intellectual activity, they were provided with an immunity or safe harbor, provided they observed the scheme of taking down the unlawful material available on their platform upon receiving the actual knowledge of it. And this principle, that no complete strict liability, no exemption which is complete, there would be no strict liability. If you are informed and you do not nothing, then strict liability. If you are informed and you take steps or choose not to take steps, then, Lord, please come to page 94. Lord, this is,
Yes.
Lord, US Congress, page
Yes.
94, principle 6 and unnumbered paragraph 3. The title is Limited Liability of Service Providers for Internet Content. Let's subparagraph 3.
Yes.
In cases where the functions of the service provider are wider and they store content emanating from other parties, member states may hold them co-responsible if they do not act expeditiously to remove or disable access to information or services as soon as they become aware, as defined by national law, of their illegal nature in the event of claim for damages of facts or circumstances revealing the illegality of the activity or information.
Yes.
So protect them if they are not aware. Then, my lord, rest I may not read. Please come to page 97. How, my lord, notice is to be given on actual knowledge, Lord, as per the US provision.
Yes.
Lord, I'm not reading it, but there is a provision how, my lord, they were given notices. Now, my lord, difficult. Now the position is this: intermediaries rightly came before all respective governments of the countries globally that our nature of the medium is different, and therefore we need some kind of a protection. At the same time, the government interest is also to ensure that we do not host anything which is unlawful. So, middle path which was found globally was that if you are informed and if you do not do anything, then you are not responsible. Now what happened, my lord? Having got that safe harbor, now 79 is what? 79(1) says you are protected for any third party information, subject to 1 and 2,
Yes.
subject to 2 and 3, and 2 and 3 in substance says that if you are informed, if you do not follow the guidelines, then 1 will be lost. Subsection 1 harbor will be lost. First, they tried to challenge 79, 2 and 3 before the Supreme Court. Supreme Court did not interfere.
Yes.
Your lordships have
Yes,
seen.
yes.
Merely read it down to mean that actual knowledge means not from private parties,
From the court.
from the court, but government's power of notifying about the unlawfulness was retained, though, my lord, that was not presented before your lordships. Now, my lord, a step further, that now even the guidelines under 2, which are, my lord, guidelines for the purpose of what is the word used, due diligence, that is also required to be set aside, because though I have no freedom of speech and expression, it's not my right, but there would be a chilling effect. What is the material? What is the chilling effect? It's a speculation. It's a presumption. It's a probability of chilling effect. To what extent? To how many persons? In what subject? What genre? And in some genres, for example, pornography, if there is a chilling effect, it should be chilling. It is intended. Now, your lordships may kindly turn to page 100, and I'm not going to read this, but
Yes.
your lordships may get substantial assistance, my lord, from
Of all the, on different regimes.
on different regimes, my lord. Kindly only see the title, the country, the safe harbor regime. What is equivalent to 79?
Yes.
Then similarity to India's safe harbor regime.
Yes.
We have compared other countries' safe harbor regime with 79. And last is status of compliance by intermediaries. My learned friend would say, my lord, that last column is a statement of fact.
Yes.
But my lord, this is what we have gathered from. But my lord, interesting part is in United States, except sharing the algorithms, every this social media intermediary, they are by and large compliant, including Lord, X. So wherever Lord, the government wants to implement, they are okay with it. But in
Algorithms,
India,
they
they have problems, Lord, constitutional challenges, this, that. Not they means only, Lord,
Intermediaries.
all intermediaries.
Yeah, all
Lord, I'm
intermediaries.
not on X or something. Well, the difficulty is, Lord, I find it, Lord, really amusing. They say Article 14. Article 14 is arbitrariness. Lord, definitely, doubtlessly, admittedly, this company is American company. They, Lord, the office bearers are also sitting in America.
Yes.
Lord, can my company of my country go to US and file a petition saying that the government policy is arbitrary?
Yes.
I leave it at that.
Yes.
Why not?
But another, you don't have Locus, you will be thrown out on Locus. Even X is thrown out on Locus by this honorable court. And considering their conduct, I quoted that, considering the conduct of X, Lord, the cost of 50 lakhs is imposed, which is reduced by the division men to 25 lakhs. But I'm not, Lord, on that. Lord, then, Lord, there was a argument that 769A and 79 are overlapping. So that argument is inherently wrong on two grounds. 69A is a penal provision. 79A merely puts them to caution that if this is not done, maybe your safe harbor will be lost. You may have to face civil or criminal consequences. Second, Lord, my learned friend Lord pointed out a chart. What are the grounds available under 69A and what are the grounds available under 79? Look, there are more grounds available under the 79. Look, there are several instances in the real life of internet usage which the nation or the government comes across, which may not fall strictly either under section 69A or they are of such a nature that the harshest step of blocking it under 69A may perhaps be disproportionate. For example, my lord, as I have informed your lordships, my lord, and I don't think, my lord, I should show that, my lord, but we have created an AI generated video.
Yes.
That your lordship sitting on this bench in your lordship's voice are saying something against the nation. It will not fall in any of the categories under 69A. Nonetheless, it is unlawful. It's not even impersonation. Impersonation is my going somewhere and saying that I am Justice Nagaprasanna and I need some favor or some good treatment. So that's not impersonation.
AI generated
yes,
act which is unlawful straight away.
There are several acts which will not fall within 69A, or they may not need the harshest treatment, which is the consequence. 69A is not just taking down. It's a criminal prosecution,
Yes,
2 years imprisonment.
Yes.
So the legislative scheme is, there is a concept of least intrusive measures by the legislation. That there may be harsh measures and there may be least intrusive measures. So the legislature gives an option of least intrusive measure. Don't ask them, don't block them, don't criminally prosecute them.
Caution them.
Caution them that you can continue, take your business call.
But this is unlawful.
But this is unlawful according to us. You can say it is lawful. But then safe harbor will not be available. When the court of this country is approached by a citizen of this country, you will not be able to say that I can't be touched because of 79. Because you are in breach of 79, 2 and 3. Then you will have to defend. You may succeed also. The court may say that no, government was wrong. It is perfectly lawful. Suppose the government in a given case, my lord, gives a caution notice to them, which they take, my lord, a considered view that no, this is not unlawful, we would continue. It's a freedom of speech and expression. They may succeed. Yes. Lord, then, Lord, so the distinction, my lord, I have pointed out.
Yes.
Page 113, my lord, I have given what is the purpose, standard, and consequences of 69A. I'm not troubling your lordships with that, my lord. I have given, my lord, everything. My lord, then 79, my lord, I have given competing rights. My lord,
Yes.
the honorable courts have developed a theory that each fundamental right do not exist or operate in separate silos.
Yes.
My fundamental right to do something might come in conflict with my learned senior's fundamental right of my not doing it. Suppose my fundamental right of free speech and expression might hamper his right of privacy, his right of dignity, if I say something which is undignified. So there is always competing fundamental rights, 14, 19, 21, other rights, etc. And therefore, a jurisprudence is developed, which I am, Lord, very respectfully relying upon, that you will have to balance the competing fundamental rights to achieve the constitutional goal. And that is what, my lord, I am citing only one judgment of Subramaniam Swamy, where he challenged, my lords, 499 and 500, the definition of defamation, where, my lord, this law was discussed in detail.
Now there, for the first time, impact doctrine was.
Yeah, yes, I'm grateful. I'm grateful. My lord, please come to page 117.
1-1.
117. My lord, this is a judgment post Shreya Singhal.
Yes. Yes.
So Shreya Singhal did not have the advantage of assistance of this judgment, my lord.
Yes.
Lord, be that as it may, the aforesaid authorities clearly lay down that the freedom of speech and expression is a highly treasured value under the Constitution, and voice of dissent or disagreement has to be respected and regarded and not to be scuttled as unpalatable criticism. Emphasis has been laid on the fact that dissonant and discordant expressions are to be treated as viewpoints with objectivity, and such expression of views and ideas being necessary for growth of democracy are to be zealously protected. Notwithstanding the expansive and sweeping ambit of freedom of speech, as all rights, right to freedom of speech and expression is not absolute. It is subject to imposition of reasonable restrictions. Then, my lord, what is reasonable restriction? Chintaman Rao, my lord, one of the leading
Yes.
judgment is considered, your lordships are aware. Lord, kindly come to the next, my lord. I have made bold, my lord, the same thing, my lord, which my lords were pleased to indicate, para 130, only bold part.
Yes.
The impact doctrine or the principle of inevitable effect or inevitable consequence stands in contradistinction to abuse or misuse of a legislation or a statutory provision depending upon the circumstances of the case. The prevailing conditions of the time and the principles of proportionality of restraint are to be kept in mind by the court while adjudging the constitutionality of a provision, regard being had to the nature of the right. Look, this is least intrusive. Proportionately, this is the minimum we could have done. That is 3(1)(d).
Yes.
Then, my lord, 137, the bold part.
Yes.
One fundamental right of a person may have to coexist in harmony with the exercise of another fundamental right by others, and also with reasonable and valid exercise of power by the state in light of the directive principles in the interest of social welfare as a whole. The country's duty is to strike a balance between competing claims of different interests. My lord, thereafter, my lord, the same is followed in Sahara, India.
Yes. Yes.
My lord, I'm not reading, but kindly, my lord, treat it as read so that your
Yes.
lordships get, my lord. But
No, I'll
please
go
come
through
to
it.
page 122. Lord, this is something, my lord, I found that I may, my lord, even at the cost of repetition, your lordship must have read several times. I must, my lord, place for your lordship's consideration. My apologies.
No, no.
195.
Yes.
Somewhere, my lord, 5 or 6 line from the top. Thus, we are unable to accept.
Yes.
Does your
Yes.
lordship say?
Yes.
That provisions relating to criminal defamation are not saved by doctrine of proportionality because it determines a limit which is not impermissible within the criteria of reasonable restriction. It has been held in DC Saxena versus so-and-so, though in a different context, that if maintenance of democracy is the foundation for free speech society equally is entitled to regulate freedom of speech or expression by democratic action. The reason is obvious, that is, that society accepts free speech and expression and also puts limits on the rights of the majority. Interest of the people involved in the acts of expression should be looked at not only from the perspective of the speaker, but also the place at which he speaks, the scenario, the audience, the reaction of the publication, the purpose of the speech, and the place and forum in which the citizen exercises his freedom of speech and expression. The court had further observed that the state has legitimate interest, therefore, to regulate the freedom of speech and expression, which liberty represents the limits of the duty of restraint on speech or expression, not to utter defamatory or libelous speech or expression. There is a correlative duty not to interfere with the liberties of others. Each is entitled to dignity of person and of the reputation. Nobody has a right to denigrate others' right to person or reputation. There is a distinction between social interest and a nation of and the notion of the majority. The legislature has exercised the legislative wisdom, and it is inappropriate to say that it expresses the notion of the majority. They said that what is parliament? Ultimately, majority has said something. They said no, it is reflecting the will of the people, and therefore should not be interfered very loosely. Now, my lord, I'll just give the headings of my note and I'll not read it. I know, my lord, it would be too naive on my part to read it before this bench. So therefore, Rule 3(1)(d) is constitutionally sound. Lord, I have given the reasons. Lord, my learned friend relied upon Kunal Kamra. Lord, I'll just take 5 minutes on that.
Fact check, that's all.
What was that, Lord? Lord, I'll just, Lord, give an example. Suppose I tweet that from Monday onwards, the Prime Minister is going to declare what was that? Corona lockdown, which is completely wrong. Suppose somebody were to tweet that from Monday onwards, the Chief Minister of Karnataka is going to distribute 20 kg of rice and 20 kg of pulse per person from the fair price shops. There would be a huge queue, etc., etc. Now, what is the remedy with the government? We don't want to curtail anybody's freedom of speech and expression. So we created a fact check unit. It would check such facts either on its own or being brought to the notice. The consequence was interesting, which, my lord, of course, unfortunately did not find favor. The consequence was that if it is Twitter or a Facebook, we will intimate them that this is fake.
Actually wrong.
Factually wrong. This is fake. You need not take down. You just mention at the foot that according to the government, this is not factually true. Just, my lord, a disclaimer. It doesn't hamper anybody's freedom of speech and expression. You can say that from tomorrow onwards, this is going to happen, which is completely imaginary. Don't take it down, but put it that, but that, my lord, was also, my lord, found to be, at least by 2 judges, 1 judge, my lord. But I'm not, my lord, going into that debate or discussion.
That's 3(1)(b)(5).
Yes, my lord. So, my lord, it is completely on a different fact situation. It was a fact check unit. Here, my lord, there is a statutory regulation in place where we are using the least restrictive method of just cautioning them. Then, my lord, another head is 3(1)(d) is a valid exercise of the power of delegated legislation.
Yes.
My lord, I am not reading it.
Yes.
Then suitably tailored with adequate safeguards. Now, please see this, my lord, 239. This may be relevant. It's
Yes.
not, my lord, an arbitrary provision that we intimate them and expose them to litigation, etc. There is a methodology. My lord, this is a method, my lord, where both of us will have to cooperate with each other. They are also ultimately, my lord, as, my lord, in Facebook case of Supreme Court, my lord, Ajit Mohan, the Supreme Court says that very candidly and very, my lord, boldly, that India is a marketplace for all of you by sheer population. So you can't ignore us. So better you follow the laws of the land. And law of the land merely tells you that we are cautioning you. You engage with us if you have any problem. And this is, my lord, the procedure which is contemplated. The process of removing or disabling access to unlawful information on the Sahyog portal will involve the following steps. Now, what is Sahyog portal? I'll just broadly say. I don't think my learned friend also, this is my presumption, not to dilute his submission. He was very serious. But what happens is, if your lordships have seen the scheme of 79 and the rules, Lord, they receive the intermediaries, it can be any intermediary, they receive a notice from, they are supposed to receive a notice from an authorized government agency. Now, they do not know who is authorized across the country.
Metro engineer.
Pardon?
Engineer of the metro.
That's
Yes, yes, he is an authorized. I'm
under
not
the
apologetic about it. He is a designated authority. Because railways has a potential of great public disorder. So it's not a matter of laughing that a railway engineer is a designated authority. I'm not apologetic about it. There are several people. It's not necessary that only police people are supposed to be designated authorities. There are several departments where
the act permits anybody to be made designated
the
authority.
difficulty is this kind of, my lord, 3(1)D situations arise in, say, consumer affairs department. It may arise in finance ministry.
There should be some
railway
authority
ministry.
to
So some authority will have
issue
to
a
be,
notice to take down.
Lord, some authority will have to be designated in each ministry at each level. Lord, what used to happen was that anybody used to write a letter. Some police station in Kolkata or some police station in Bombay would send a letter to, say, Facebook that delete this, there is a criminal action, it's very serious, and you take it down. Now, they did not know that this is authorized or not authorized. Now, even if, my lord, my designated authority is authorized, I would have I had no means of knowing whether, what is their response, whether they have complied with or they have, suppose it's a 69A order, they have to comply with,
Yes.
there is no choice. If it is a 3(1)D order, they have to take a call not to obey or not to comply or to comply. So compliance was not known to us. The intermediaries therefore came to the government.
One portal.
That you have a portal where if it is uploaded on that portal,
Compliance will also be uploaded. on
now
that.
we would know, the intermediaries would know that the person who is authorized has issued this notice.
Yes.
And somebody, not somebody. And the government will also know about the compliance.
Compliance.
So it is merely an administrative mechanism for smooth of governmental business and business of the intermediaries. And Twitter is not even, has chosen not to join that portal. Rest of them have joined the portal. Portal is working.
So it is a portal for implementation in harmony.
Harmony and in the interest of the intermediaries, that a person who is not authorized may not engage with them. And they come to know from an authorized source that this direction or a request or a caution is coming from a person who is statutorily authorized. And instead of receiving 10 notices from all across the country, you get it only at one place. You have to open only one site daily, and you know that there is something which is sent to me. So it is, my lord, an administrative convenience. This is called ease of doing business by the government business, by the intermediaries, their business. I don't see, my lord, what objection can there be? They say there is no statutory backing. There need not be. There are several things, my lord, which we do. There is no statutory backing. My lord, we have, my lord, for example, a website for the grid, my lord, this litigation, for litigation, etc. There is no law, data grid. It's an administrative decision just for ease of doing business that anybody can click, anybody can go on that site and find out what the position is. You don't need statutory backing or some source of power through a parliamentary law or a legislative law to create something administratively for smooth functioning of the government. That is all. Now, please see, my lord, how the process works. In 69A and 31D.
Yes.
69A has separate rules, my lord,
Yes.
because of the harsh consequences. This is penal in nature, etc. The process of removing or disabling access to unlawful information on the Sahyog portal will involve the following steps. The nodal officers of authorized agency issue notices through the portal to the intermediaries. On receipt of notices, the intermediaries will respond to the notices and inform the action taken. The intermediaries can remove or disable the unlawful information. The intermediaries, if required, can seek additional information on the notices. The intermediaries can raise a request for non-compliance citing appropriate reasons. This is also optional. They need not give reasons also. If the authorized agency agrees with the reasons, the request will be closed. If the authorized agency disagrees with the intermediary's reasons for non-compliance, can record their further reasons and request for compliance. If the intermediaries comply with the request after further remarks, the request be closed. If the intermediary refuses compliance, there is a provision for issuing show cause notice to the intermediary for non-compliance. If the intermediary replies, the authorized agency may accept or not to accept the explanation. If accepted, the request will close. If not, the authorized agency may proceed to take action under Rule 7 of Information Technology Intermediary Guidelines and Digital Media Rules. Please see that rule. That means your safe harbor goes. Because 3 cannot be a toothless provision. It has to have some consequence.
Yes.
Therefore, Rule 7, which is not in challenge, says that if you do not follow Rule 3, then your safe harbor goes. Then, my lord, page 129, 31D does not contravene the principles of separation of power. My lord, this argument, my lord, may not, my lord, invest your lordship's time much, my lord. There is nothing like separation of power, my lord.
Yes.
When we are dealing with an intermediary, which is a defined term under the statute, my lord, it's not that every time the government will have to go and get a judgment from the court whether this is unlawful or not. Particularly in context of the very nature of this medium, where virality is the key. You have to act swiftly as a government. So you cannot say that you have to wait till some court decides.
No, that's what I was asking. If a post is made again derogatory to some person and you have to go to the rigmarole of all procedure, the post damage is done.
My lord, suppose, my lord, there is a post.
That is why, my lord, we have Rule 8. That
The
is
rule
why
eight-
we
rule
have in
eight
69A.
in
It is
2011.
There are many things
So it
which,
is not as if it is
No,
remediless.
that's what I asked and held.
That's all right.
Lord, only a
I
minute.
just want to
Only a
clarify
minute,
that
my lord,
position.
give me a minute. Where is that Nirmala Sitharaman's post? I'll show 2 posts.
Just one.
And
before
I'll request my
friend-
learned friend to tell
And
me.
at 239, which was relied upon, is a submission that is being made before your lordships. It is not in the rules. None of what has been stated in para 239 is found in the statute.
We'll make a note of it.
Please ignore it. my lord. Well, I don't want to join issues on that. my lord,
Yes,
because,
yes.
my lord, I'll just show, my
No,
lord.
no, I
two-
just started, when they were arguing, I just asked, saying if you have to follow the rigmarole of entire procedure, then the damage is done by the post being on that platform
Yes,
for all
yes,
time.
That is why
And Rule 8 is
But
what
now
was
in
said.
this context, my lord, Shreya Singhal rejects my argument about the medium. Thereafter, I have shown, my lord, the evolution of law based upon the internet as a medium and particularly with reference to social media, intermediaries. My lord, please allow me to show one paragraph from Shreya Singhal, my lord.
Yes, sir.
Which is that, Shreya? My lord, I had cited this, my lord.
Huh.
What's your difference between mediums?
It's in your submission.
So sorry to digress, but
It is in the judgment.
I thought what I asked.
I quote verbatim this one.
No, sorry to digress the arguments.
No, absolutely not. My lord. I'm on almost at the end, my lord.
Yes, yes.
And I will be, my lord, my lord, page 830, Shreya Singhal, my lord.
Yes.
Now, my lord, this will have to have a fresh look, these arguments, in view of the law which has evolved from Shreya Singhal onwards.
That's
even
your,
in the United States.
that's your submissions.
Yes,
Yes,
and the
Parathird.
court records, court says this, my lord. It was argued by the learned additional solicitor general that a relaxed standard of reasonableness of restriction should apply, regard being had to the fact that the medium of speech, being the internet, differs from other mediums on several grounds. To appreciate the width and scope of this submission, we are setting out his submissions, written submissions verbatim.
But,
In the context of Reno, the court had only Reno in mind.
yes.
The breach of print media is restricted to one state or at the most one country, while internet has no boundaries and its reach is global. The recipient of free speech and expression used in a print media can only be literate persons, while internet can be accessed by literate and illiterate both, since one click is needed to download an objectionable post or a video. In case of television serials, except live shows and movies, there is a pre-permitted, I'm sorry, you're lost.
Pre-censorship, yes.
Pre-censorship, which ensures right of viewers not to receive any information which is dangerous to or not in conformity with social interest. While in case of internet, no such pre-censorship, we are not seeking pre-censorship, is possible. I'm just saying what is the difference between the mediums, and each individual is publisher, printer, producer, director, and broadcaster. I can make my own reel in whatever manner I want and I can upload it. I am the producer, I am the director,
Yes,
I am
sir.
the hero, I am the script writer, I am everything. Similarly, I can create a magazine, and there are many magazines which are running like this. By the medium of internet, rumors having a serious potential of creating a serious social disorder can be spread to trillions of people without any check, which is not possible in case of other mediums. In case of mediums like print media, television and films, it is broadly not possible to invade privacy of unwilling persons. While in case of an internet, it is very easy to invade upon the privacy of any individual and thereby violating his right under Article 21. By its very nature, in the mediums like newspaper, magazine, television, or a movie, it is not possible to sexually harass someone, outrage the modesty of anyone, use unacceptable filthy language, and evoke communal frenzy, which would lead to serious social disorder. While in case of an internet, it is easily possible to do so by mere click of a button without any geographical limitation, and almost in all cases while ensuring anonymity of the offender. I can open my account. I'll show. We have opened one account in the name of Supreme Court of Karnataka, and Twitter has opened that account, and it is a verified account by Twitter, Supreme Court of Karnataka. Now I can post anything in that, and lakhs and lakhs of people who view that will say Supreme Court of Karnataka has said. Therefore, I say anonymity. I can remain anonymous, or pseudonymous, and I'll show that. This is the Twitter page of Supreme Court of Karnataka, which is verified by Twitter. Just to show, we have not used it, because otherwise it comes in public domain.
Yes, yes.
We have not used it. We have not sent any
Created
message
it.
from this. This is just to show that there exists an account, and within 5 minutes.
I have objection to this, my lord, because this is not to be put against me without even being put on record, so that I can say, has it gone through my scrutiny process? What is the extent of scrutiny I can do? This, my lord, my learned friend was very fair when he started.
It's not circulated is what is said.
No, my lord,
Sir, I can answer your
that
question.
cannot be done across the bar, passing on to your lordship.
No,
Don't
sir,
worry about it.
only one
Be
thing.
done. And my learned friend was very fair when he said, I am not arguing on prejudice point. But I think, Lord, what is
No,
being
this
sought
is
to be
not
done
a
is only
prejudice
that.
point. This is the
Without even putting it on
extent of
record, I don't
damage.
have an opportunity.
Lord,
But this
treat
is not fair.
treat this as a Facebook account. I could have created a Facebook account.
My lord, whatever,
You never have been able to
I am
answer.
not on what is created, how it is created, who created it, and what is the role I have to play. I am only saying, let me, if it is to be relied upon as part even of a council submission, I am entitled, I think, my lord, I am right in saying that, to have an art. How am I going to do it?
No, that is only an illustration.
Not that
I
illustration
am
may be.
giving an illustration.
That illustration, you
May be wrong.
can be rest assured those illustrations will not prejudice the mind.
No,
Yes.
Lord, suppose I would have created a similar.
I don't know, my lord.
Facebook account, Lord, I would have created a Facebook account in the name of Supreme Court of Karnataka. Would he have objected that I do not know how we verified, how was it verified, how was it registered? Lord, incidentally, it
No,
happened to be a
your
Twitter account.
submission is creation of such things in an intermediary is easy.
That's all, my lord.
That's the
It's very
submission.
easy.
That's
and
all the
that-
submission.
Nothing new, my lord, even with respect to the press, your lordships will recall an incident. In fact, my lord, it happened in this court. And this court took suo motu cognizance and issued contempt.
2002.
Yes. The lord,
Anonymity, my lord, the point
Happens.
of law is
Now, in that proton mail matter also, where he was not there, anonymity was the problem there.
yes.
You shoot mails after mails which contain pornographic material to all and sundry of a particular organization, of those organization members, all are morph pictures. And it's so derogatory, so horrendous, the anonymity is claimed.
My lord, another problem, and I wanted to avoid
in fact,
arguing this.
anonymity was claimed even in that 2002 incident.
Correct. That
Where,
was
my lord,
print media.
I don't know whether my learned friend knows.
I'm aware of proton.
Print-
That is my
No,
lord
not
said.
proton, sir. I'm talking about the old incident that happened where it was
That's all
said.
right. Let's not take about that incident.
Or, I respect, my lord, I
Yes.
respect.
Lord, as a matter of fact,
Yes.
my lord, why this debate will be academic? I'll tell your lordship the reason why. My lord, suppose there is a 69A order or non-compliance of 1D order. Prosecution, I'll lodge a prosecution if I am affected party. Lord, I'll prosecute whom? There is nobody in India.
Anonymity.
No.
No,
The
that's
Twitter
what-
has nobody in India. The people stay in
That's it.
America.
That's exactly what happened with
No, sir,
proton.
there's a chief technology officer in India,
So-
nominated.
So in case of non-compliance, he would be the accused.
I don't know. Depending upon the law.
That's
My
all
learned
right.
friend, I thought very fairly gave the name that he represents Twitter. There is no.
No,
authorized-
when my learned, this is only to say, when my learned said there's nobody in India, no.
There is some
But
grievance.
maybe
representatives are
prosecuted,
there.
I don't know.
There is some grievance redressal officer, but there is no officer in the context of a criminal prosecution. And it's a foreign company and everybody is
Yes,
in
it's
America.
foreign.
That's all. It's, now come to my lord 8. By the very nature of the medium, the width and reach of internet is manifold as against newspaper and films. The said mediums have inbuilt limitations. That is, a person will have to borrow a newspaper and or will have to go to a theater to watch a movie. For television also, one needs at least a room where a television is placed and can only watch those channels which he has subscribed, and that too only at a time where it is being telecast. While in case of an internet, a person abusing the internet can commit an offense at any place at the time of his choice and maintaining his anonymity in almost all cases. In case of other mediums, it is impossible to maintain anonymity, as a result of which speech, idea, opinions, or films having serious potential of creating a social disorder never gets generated, since its origin is bound to be known. While in case of an internet, mostly its abuse take place under the garb of anonymity. In case of other mediums like newspapers, television, or films, the approach is always institutionalized approach governed by industry-specific ethical norms of self-conduct. Each newspaper, magazine, movie production house, or TV channel will have its own institutionalized policy in-house, which would generally obviate any possibility of the medium being abused. As against that, the use of internet is solely based upon individualistic approach of each individual who is using the internet, without any check, balance, or regulatory ethical norms for exercising freedom of speech and expression. In the era limited to print media and cinematograph, or even in case of publication through airwaves, the chances of abuse of freedom of expression was less due to inherent infrastructural and logistical constraints. In case of said mediums, it was almost impossible for an individual to create and publish an abusive content and make it available to trillions of people. Whereas the present internet age, the said infrastructural and logistical constraints have disappeared, as any individual using even a smart mobile phone or a portable computer device can create and publish abusive material on its own without seeking help of anyone else and make it available. Now, my lords, last submission, my lord. Lord, my learned friend argued that what is contrary to law as used in 3(1)D is vague. I don't think, my lord, that needs, my lord, a specific answer for the reason that what is either not permitted by law or what is prohibited by law covers it.
Yes.
Beyond that, it need not be defined, but at page 130, I have given, my lord, one judgment where it says that some of the definitions are not capable of being defined. My lord, please see the bold portion only.
Yes.
At page 131, the impossibility of framing a definition with mathematical precision cannot either justify the use of vague expressions or the total failure to frame any definition at all, which can furnish by its inclusiveness at least a safe guideline for understanding the meaning of the expression used by the legislature. But the point to note is that there are expressions which inherently comprehend such an infinite variety of situations that definitions, instead of lending to them a definite meaning, can only succeed either in robbing them of their intended amplitude. It's counterproductive to define it, or in making it necessary to frame further definitions of the terms defined. The defense of India, security of states, etc.
Under any law, time being in force. That is
Yes,
what
Lord.
3(1)D
And
says.
we have made it for retaining the amplitude. It is kept open-ended when anybody can understand either prohibited by law or not permitted by law. That is against the law. My lord, then no reading down, my lord, is made out. And my lord, please come to page 135. This is my last point, my lord, and I'll stop.
Maintainability.
Yes, my lord. My lord, when the government of India is before the Constitutional Court, we should not adopt a knee-jerk approach that decide the question of maintainability first. Then only we will answer on merits. Because it is the duty of the government, my lord, as a representative of citizens, to satisfy the judicial conscience of the Constitutional Court or any court for that matter. And therefore, I addressed everything on merits. But now I come to a very fundamental objection, which I have as a preliminary objection, that X has no locus standi to file the present writ petition, my lord, under Article 226 of the Constitution of India. My lord, at least claiming 19(1)A rights or 14 rights. My lord, please come to, my lord, page 135, ground A.
Yes.
That the writ jurisdiction of this honorable court has been invoked by the petitioner, which is an out-and-out foreign commercial entity. The affidavit to the present petition is sworn outside the territory of India by a foreign national who is purportedly acting on behalf of the petitioner. The petitioner has a mere status of intermediary as defined under the IT Act and no more. It is neither the citizen of India nor a natural person. Thus, the protection of Article 19, including right to disseminate information of speech or other citizens, or that of Article 14 and 21, is not available to it for the purpose of clothing it with locus to move the instant writ petition. It is for the individual citizens of the country to ventilate their fundamental rights before this honorable court. Petitioner being a mere foreign artificial juristic entity, both Article 32 and 226 are not available to it for the purpose of the present petition. My lord, thereafter, my lord, locus of the petitioner, your lordships may only see, my lord, page 138, para 269. My lord, this honorable court has already dealt with their locus in a writ petition. And my lord, please see 269, X Corporation versus Union of India. With a judgment dated 30th June 23, this honorable court clearly held that Article 19 and 21 are not available to the petitioner. It was held as under. Lord, I maintain Article 21 also would not apply to a juristic person, much less a foreign body. It is intended for individuals. A foreigner who is not a citizen of India is protected by 21. If he is a natural person. but not a juristic person. Look, corporation by its very nature, right to 21 is right to life and liberty. Someone which can be wound up, even as per law, cannot claim right to life as a fundamental right. As simple as that. Petition has been structured, this is your lot, this court saying.
Yes.
Petition has been structured inter alia on the provisions of Article 14 of the Constitution as extensively construed by the apex court. Precedent by precedent, para 11, page 10 of petitioner's rejoinder reads, petitioner is canvassing rights under Article 14, 19 and 21 only to limited extent. Petitioner is mainly urging violation of statutory rights. Please pause here for a minute. Look, this was the reason why they, while filing the petition, confined to statutory rights to make it maintainable. Thereafter, after my reply, they rightly found
Amended.
that unless they challenge the regulation rules, it would be difficult for them to maintain. Therefore, an amendment comes, and therefore Article 19, etc. comes. Even otherwise, it cannot claim protection of Article 19(1)(a) because it is not a citizen. Then court quotes the judgment, and Article 21 because it is not a natural person. It also cannot espouse the arguable cause of Twitter account holders in absence of enabling provision of law, unlike trade unions espousing the cause of workmen under the provisions of the Trade Union Act and Industrial Disputes Act. It is submitted, however, this honorable court held that said petition is maintainable in view of the fact that Article 226 also allows ventilating statutory rights, and since petitioner was ventilating statutory rights, the petition is maintainable. Here, argument after argument was based on fundamental rights, constitutional rights. Now, please see, the petitioner company is not only threatened of losing its protection available under Section 79(1), but also penal action for violation of mandatory provisions of the Act and website blocking rules. In view of the above discussion, this court is of the considered view that petitioner has locus standi to tap the writ jurisdiction of this court for the redressal of its arguable grievance, but not challenging the rule. After holding the said petition to be maintainable, the honorable court analyzed the conduct of the petitioner, which clearly evinced non-compliance by the petitioner and therefore declined to entertain the petition. Maintainability is different, and your lordship's discretion to entertain it is different. The non-compliance with Section 69A orders has the potential to make the tweet more viral and spread to other platforms as well. One can imagine the damage potential when such objectionable tweets are allowed to be disseminated despite interdiction. The damage potential is directly proportional to the delay brooked in the compliance of such orders. Petitioner has demonstrably adopted a tactical approach to delay compliance, and that shows its intent to remain non-compliant to Indian law. No plausible explanation is offered for the delay in approaching the Constitutional Court either. Petitioner has abruptly complied with Section 69A orders a bit before coming to court, though second respondent had issued compliance requirement notice way back on so-and-so threatening. It needs to be mentioned that Section 69A(3) provides for specific penal consequences in case of non-compliance of directions issued under Section 69A of the Act. The penalty prescribed under Section 69A(3) for the offence of non-compliance of the order is imprisonment for a term which may extend to 7 years and or fine. Even that did not deter the recalcitrant petitioner. The central government in its discretion did not choose to prosecute the petitioner for the offence in question. It hardly needs to be reiterated that constitutional courts do not come to the aid of litigants whose hands are soiled or who are indolent. In the above circumstances, this petition, being devoid of merits, is liable to be dismissed with exemplary cost, and accordingly it is. Petitioner is levied with an exemplary cost of ₹50 lakhs only, payable to the Karnataka State Legal so-and-so. My lord, in appeal, this was, my lord, reduced
25
to
lakhs.
25 lakhs, my lord. My lord, thereafter, my lord, I have quoted judgment after judgment, my lord,
Yes.
that,
But one clarification, sir.
yes, my lord.
Article 19, yes, is citizen centric. 21 again is
Natural.
not natural person, or not the company or whatever. Article 14 is all pervasive.
My lord, Article 14, my lord, it is a possible view. When
Yes.
I'm assisting your lordships, I may not, my lord, be constrained with the facts of a particular
Correct,
case. But my lord, in my view, a foreign company trying to do business in India may perhaps not have the locus to say that the policy is arbitrary. Because you have chosen to come here and abide by the law of the land. The law cannot be challenged as arbitrary after coming into it. My lord,
That's
they can incorporate an Indian subsidiary. Look, when petitioner wants the locus standi and a right to be heard, let them say that in the event of their failure under 69A or their failure under Rule 3(1)D, who will be the person who will be liable for prosecution? Let them say, my lord. At least that is what is expected of a petitioner who is invoking a discretionary, equitable jurisdiction of the High Court under Article 226. Let them say. There are no stakes in India. Even grievance redressal officer was appointed after years, after our repeated demands, that my subscriber in India wants to raise a grievance, to whom it is to be raised. You must have someone in India. Thereafter that happened. This is not a forum where I urge my grievances against individual intermediaries. But at least if they want a hearing, let them say, in the event of 69A non-compliance or 3(1)D non-compliance, who will be the person who will face prosecution? Lord, the judgments, my lord, are Charanjit Lal Chaudhary.
Yes.
My lord, all judgments are aware, my your lordships are aware.
Yes.
Lord, only the most recent is H. My lord, that is INSAN, Indian Social Action Forum.
Yes.
So this was some NGO. The court says the NGOs have no right. You are not a natural person. You have no right under 19(1)A. Lord, I have also given, my lord, these case law in detail, Lord, from subsequent page onwards.
Yes.
My lord, I am not reiterating.
Yes.
My lord, Sahyog portal, I have already
Already
pointed
yes.
out, my lord. These are my respectful submissions. Lord, these are my respectful submissions.
Yes.
Lord, I'll just place 2 page, my lord. Just encap. So I have already argued, so I'm not reading it, my lord.
Yes.
But the same thing which I argued today, I have just, my lord, recalibrated and placed it for the propositions of nothing on facts. My lord, the laws compilation, my lord, for your lordship's ready reference, though I have quoted the relevant parts, but I'll place it, my lord, with the court master,
Yes.
so that if your lordships would like to go through it, your lordships can go through.
Can I
Lord,
request one thing to both of you, in sense?
Yes,
Because the documents, I think, run into several thousands of
yes, your
pages.
lordships are right.
If you can give a soft copy of what all you have placed
We shall do that.
in a pen drive or whatever.
We shall do that.
That
Lord,
would
what
be
we
helpful
do,
for,
we'll not coordinate,
Yes.
but their documentation can have P21, P22, etc.
that's
We would have
if you-
R21,
yes,
R22,
yes.
so that your lordships can
Yes, we will.
differentiate.
If you
That
can.
we will.
Not for
at the end,
That will
cutting and
coordinate
putting
with
it.
each other.
no, after you finish your rejoinder submissions, if
yes.
this is done, it will be helpful.
We will do that.
Yes.
Well, Lord,
Because
it is
so
real.
many papers are there.
It was really a privilege assisting your
No, no,
lordship.
it is,
My lord, when the honorable
enlightening.
court thinks before, my lord, you can utter a word, but you have to be very careful also, and it's a pleasure. It was really, my lord, a
And from
privilege.
my side, my lord, I want to say something. My lord, normally, my lord, we pay to acquire knowledge. But now, my lord, I am paid to acquire knowledge.
No, lads.
I said is illuminating and
Of course.
enlightening.
Lord,
Of course.
Lord, I have learned a lot from my learned senior, Lord, and I've said that to him also outside the court.
Yes.
I'm really grateful for his compliments, my lord. I'm grateful to your lordship.
Yes.
Like,
My lord, I just to end, my lord, on a good note, that account has been suspended.
Which account?
That
Supreme Court of Karnataka.
we got information. My lord, we are a responsible business house. All that I want to say is only that.
So my oral submission was treated as 3(1)(d)
Coming from you.
and
No, no, give.
they acted on it. That's what we want.
Acted on now?
And yes,
I think it
Right
was
now?
No, I think it was done now. I
No,
don't
no,
know
right
when it was
now,
done.
right
I don't know
now.
when it was done. But anyway, my lord.
That is
My lord,
why we call
if something,
Sahyog.
my lord,
That
if
is why-
something comes from my learned friend, I have no difficulty, my lord, my learned
No,
friend with
that's why.
agency of the government.
Allah, this is Sahyog, cooperation.
So therefore, my lord, when the AI
It was not
judge-
even a verified, my instructions are, it was not even a verified account. It is some stray stuff, somebody put it. And it has been, no, the statement made was that it has gone through our filtration process.
Lord, now, Lord, we,
That
so
is
far
not
as
true.
your lordship's AI generated was concerned, I said you send it to me. But he said, no, I cannot send it. The moment it goes from A to B,
Yes, it becomes circulation.
viral.
Yes.
So
yes,
it has remained in the storage of my officer, but I'm not showing it to my learned, my lords, my lord. But it says, the lordships are sitting here. Your lordships are speaking in your lordship's voice, which is available in the
Yeah, and the net,
public
yes.
domain.
Domain.
And your lordships are saying something which your lordships would never even think of saying. That is, my lord, the danger. And that is why, my lord, new problems would need
New solutions.
statutory solutions, my lord, which should be least intrusive. No, that is the respectful submission. Obliged. Yes.
Yeah, when will you?
When were you in the office?
Tuesday, Monday or Tuesday. I think by next week I want to finish it off.
My lord, can it be little more time? My lord, I have to, as I said,
Next Friday?
As I said a little earlier, my lord, I have to cope up with my learned friends
No.
who are so well versed in the subject. I
No,
have
I'm
to catch
not
up, my
well-versed
lord.
with any
I have to
subject.
catch up.
No, 25th.
My lord, can I?
1 week.
25th. My lord,
That should be enough.
yes,
But
25th.
just on the lighter side, when my learned senior friend says I am well versed with the subject, I must confess that I am the least tech savvy person in my team. I can't operate most of the
But
systems
I
or
don't
what-
think, my lord, my learned friend has been engaged to because she is either tech savvy or not tech savvy.
I'm not tech
He has been engaged, my lord, because of his erudition in law.
Yes.
I'm grateful.
Yes.
Grateful.
So we'll take it on 25th.
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 Whatever
Your
time your
lordships-
lordship indicates, my
And
lord.
lordships-
25th.
And I would request some time, so if we can have the same facility that your lordships have
10
now given,
10 a.m.
10 o'clock, my lord, so that it will get over, my lord, that day.
my
I'm going to take
lordships,
some time.
may
I'm going to take some time.
Pardon my personal presence.
No problem.
I'll
On the
listen
week-
to my learned
on the
friend, my
VC.
lord, virtually.
Yes, yes.
Of course,
So,
my lord.
no, you take
Friday is it?
No, you take your time. No problem.
Let's.
You take your time. I'll take it on 25th. But we should try to finish it on 25th.
I will,
So that-
my lord, I assure your lordships, my lord, I'll do my very best and try to.
On the lighter
Try
side,
to.
I completed by 12 o'clock.
Ah, yes.
There is a real life incident of Justice Blackstone. He used to know, he was known for his ready wit. Before the argument start, he stated that within what time your submissions would be over. The counsel says, my lord, 20 minutes. And his question was, that is okay, but would you stop thereafter? Generally, we do not stop even after our submissions are over.
In fact, my lord, there's another incident that happened, my lord, in Madras High Court during those days when there were English judges. My lord, the English judge, my lord, the said in his very stylish accent, "How long, Mr. Counsel, will you take?" and looked at the clock. And the counsel, my lord, in his typical Tamilian accent, said, "My lord, your lordships are looking at the clock. Please look at the calendar."
How many days I will take?
Yes, yes,
It's just a lighter way.
absolutely. Obliged, Your Lordship.
Grateful,
Yes.
my lord, great.
Thank you. 25th. 25th. Yes, that's all. Please do whatever. Yes. 25th. But 25th, sir, try to
Yeah.
finish it.
Yeah, I understand. I understand. In fact,
We'll-
what I'll do, my lord, is
we'll close it
my,
on 25th.
to put my submissions written, the rejoinder submissions in writing, so that, my lord, when I take your lordships through that, I will be brief
That's
and
what
to
the
the point.
SG sir has done now.
Yes,
He's
exactly.
elaborate. He has taken me
Yes,
through.
my lord, yes.
So
In
if
fact,
you-
we have given our
Yes, you
submissions,
also
initial
given-
submissions
yes,
also.
yes, it's there.
So this will be
You
additional.
took me through that only, where
Yes,
make
my lord, I will-
submissions
I
and
will.
elaborating it,
I will,
amplifying
I
it.
will,
Same thing.
I will.
So 25th we'll try to close.
Great.
it. Well, I'll make the same arrangement of 10 a.m.
Yes, my lord, we'll be here.
Yes.
We'll be here.
And take the other councils later after this.
Well,
All right.
yes. Grateful. Grateful.
ಇನ್ನ ಫೈಲ್ ಆಗಿಲ್ಲ ಅಲ್ಲ?
ರವಿಶಂಕರ್ ಸರ್.
Lordships,
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ನಿಮ್ದ?
please. Lords, in that, PDA has served the counter, my lords, only day before yesterday. Lords, yesterday I went through it, it requires a rejoinder because they have made some factual assertions. I may be accommodated to 22nd or 23rd, not 22nd or 24th. 23rd, there is some.
24th.
24th, my lords.
We have some urgency. BDA has no role
Urgency?
to play.
Only BDA has got the role to play. It is the order under challenges of the BDA.
BDA, according to us, blood, has no role to play. They are claiming blood in respect of my land. Several proceedings have taken place. All proceedings have come to an end where it has been held that they have no right over the property. The petitioner number one is a trust. That is a non-existing trust. They challenge the development layout plan which is given in our favor. There is an order of status quo. There has been earlier land reforms.
Status quo was granted after hearing, my lords.
Land reforms order is there.
After a very detailed hearing, my lords,
civil
they
court
first gave an
proceedings are
undertaking
there.
that they will not do anything over the property.
No, that is not only one
And
day.
after that, my lords, after that, the matter was fully heard. My lords, then this honorable court wanted to treat this matter as part heard. My lords, the request was made by the coordinate bench, Then the request was made that it may not be treated as part heard because the court had
Both
expressed.
requests were made.
My lords, yes,
I don't know.
the court wanted to say that I treat this as part heard, but
Both requests were made to do and not to do.
Lords, that was, no, to do there was no request, but not to do there was a request. Lord, that is when
not
this
an
honorable
issue,
court
but
passed an
well,
order of
let us
status
need
quo.
not digress on other issues. The
That's-
issue is.
No, to say that there is an order of
question
status
no,
quo
no,
is
you-
after
you have to
hearing them.
argue.
ಅಲ್ಲ,
Matter has to be argued, matter is before the court. We are not choosing any bench.
we'll take it on 23rd. 4 ದಿವಸದಲ್ಲಿ ಏನಾಗುತ್ತೆ?
24th.
24th we should finish it.
Please. Lords, I have made a compilation of all the necessary documents. I'll serve the copies on
ಅಥವಾ
them.
ನೀವು
Lords.
ಇದು because if it's
Along with the synopsis.
no, if it has history, please file a synopsis.
Lords, I have filed it, Lords.
ನಿಮ್ದು ಆಗಿದೆಯಾ ಸರ್?
Hey, synopsis ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, if it has a history, please file
Yes,
synopsis.
yes, our synopsis is also ready.
ಅದು 23rd ಮುಂಚೆ ಇದ್ರೆ I can read and come. It'll ease.
Can I just suggest one thing? Just prepared one synopsis in just about 4 or 5 points, we will encapsulate whatever we want to say.
Whatever you want.
Yes.
What, if there is a synopsis, please
There is
give it.
already one ready one. There is already one.
Lords, I have filed the synopsis on 15th April 2025.
ನೀವು ಮಾಡಿದ್ದೀರಾ?
Yes.
ಸರಿ ಬಿಡಿ. Fine, then 24th, sir.
Same stage.
ಇದಾವ್ರದಾ?
Same
ಆಯ್ತು.
stage. ಎಲ್ಲಿ ಮೇಡಮ್ ಯಾರಿಲ್ಲ?
ತೊಗೊಳ್ಳಿ. ಅವ್ರಿಗೆ ಕಾಪೀಸ್ ಕೊಡಂಗಿದ್ರೆ ಕೊಟ್ಬಿಡಿ. ಕೊಟ್ಟಿದ್ದೀರಾ? ನೆನಪು?
Preliminary hearing.
ಕೊಡಿ.
They heard the learned senior counsel, D.R. Ravi Shankar, appearing for the petitioner, the learned senior counsel Ashok Harnalli and learned senior counsel Vikram Holigol appearing for the respondents. The learned senior counsel D.R. Ravi Shankar submits that the objection so filed by the BDA,
PDA.
by the BDA would necessarily require a rejoinder to be placed before the court to set the facts right. In the light of the said submission, list the matter on 24th as the learned counsel for the respondents are pleading urgency in the matter in the light of the interim order subsisting. Therefore, rejoinder, if any, by the next date, i.e. list on 20, that is 24th, list on 24th in preliminary hearing.
Please.
Interim order subsisting will continue till the next date.
Preliminary hearing, 3.
That signature which I had shown, my lords, in order to
There,
circumvent.
why Anil?
Why Anil? Now
There is Anil.
ಅವರು ಪ್ರದೀಪ್ ಎಲ್ಲ ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಂಗಿತ್ತು ನಾನು.
ಸಿಗ್ನೇಚರ್ ಅಲ್ಲ, ಇನ್ನೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ರಲ್ಲ.
ಹೌದು, ಅದು ಅಲ್ಲ, ಅವ್ರು ಇನ್ನೊಂದು ಕೊಟ್ರು, ಅದು ಅಲ್ಲ.
ರಿಸೀವೇ ಮಾಡ್ಕೊಂಡಿಲ್ಲ.
ಹೌದು.
Let's interim order ಇದೆಯಾ?
Interim order is not
ಏನಿಲ್ಲ.
there, my lords.
What is that you have sought now? Compensation?
Lords, we have sought for quashing, my lords, because no award is passed till date. Property is not utilized, it's still.
So you are still in possession?
Yes.
ಪ್ರದೀಪ್ ಕುಮಾರ್ ಬರ್ಲಿ, ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಲಾ?
Please, my lords. Pass.
4.
Respondent said, last time ತಾವು synopsis file ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರೆ.
ಎಲ್ಲಿ ಇವರು ಆನಂದ್ ನಾಗರಾಜ್ ಹೆಗಡೆ ಕೊಡಿ. Counsel for the respondent files a synopsis. The same in terms of the earlier order, same is taken on record, less the matter on 1st August. Yes. Interim order subsisting would continue till the next date of hearing. Next.
Fine.
Respondent only seeking a week's time. Then
Consideration of interim prior antade.
there is already stay, my lords. On the last occasion, on the last occasion, my lords, had
Exploring possibilities. Registry, IA 1 of 2025. An order has already been passed on IA 1 of 2025. The registry is there, so and so disposed on Madi. In that light, the IA stands disposed. Learned counsel for the settlement agilva.
No.
List on 1st August.
Great.
The possibilities of settlement may still be explored by the parties to the list. Next.
Great.
6.
The petitioner. The party was present before the trial court.
Present,
Yes, my lord. Now grievances all ನೋಡ್ಕೊಂಡು petition close
ಇದಾಯ್ತಲ್ಲ ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ.
Yes, my lord.
ಬಂದಿಲ್ಲ ಅಂತ ತಾನು ನೀವು ಬಂದಿರೋದಿಲ್ಲಿ.
ಅಲ್ಲ ಅವರು
ಅವ್ರದ್ದು ಗೊತ್ತಾಯ್ತು, ವಾರಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. The petitioner is before this court seeking the following prayer.
My lord, I may be permitted to make one change, my lord. The date was entered by oversight, my lord. That is the office objection. I will do it during the course.
All right. This court, owing to the submission of the counsel for the petitioner on 16/7/2025, had passed the following order. In the light of the said order, it transpires that the petitioner has appeared before the executing court on 17/7/2025. In that light, 2025, in the light of the appearance of the petitioner, the warrant of arrest hanging on his head shall stand dissolved. The petitioner shall appear before the concerned court. The learned counsel for the petitioner undertakes that the petitioner would appear before the concerned court on all dates except the all dates or whenever necessary. In the event the petitioner would not appear, the concerned court is at liberty to pass necessary orders in accordance with law. With the aforesaid observation, the petition stands disposed.
Much obliged. Office objection, I'll comply.
7.
ಏನ್ ಡೇಟ್ ಅದು?
ಅದು
ಅದಕ್ಕೆ ಯಾಕೆ ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ?
much ob-
ಇದ್ದಾಗ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ, ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ ಕಂಪ್ಲೈ ಮಾಡ್ತೀನಿ.
My lord, for the petitioner, my lord. Lord, on the previous occasion, my lord had noted.
7.
Hold on, 7, my lord.
I appear for the contesting respondent.
Yes, sir.
It have been filed, my lord, and they have to argue for admission. There's 14 years
Ready.
delay
My lord,
in challenging the compromise petition filed before the trial court, my lord. And they are alleging fraud.
ಅಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಲೋಕ ಅದಾಲತ್.
Lok Adalat.
ಲೋಕ ಅದಾಲತ್ ಆದ್ರೆ ಇಲ್ಲೇ.
Yes,
My lord,
and there's no dispute about it, but they're
Lord,
alleging it is fraud. Fraud has been played by the.
ಆಯ್ತು, ಒಂದು ನಿಮಿಷ ಮಾಡಿ, ರೆಡಿನಾ?
Lord, ಅವರೊಂದು they have filed an affidavit under writ proceedings rule number 21, my lord. I may be short accommodation next week, matter may be taken up, my lord. I will.
ಇಂಟರ್ ಮಾಡ್ರಿ ಇಲ್ಲಲ್ಲ.
No,
ಇಲ್ಲ,
interim
interim
Just on 30th at the request of the council appearing for the petitioner.
Please.
Much obliged.
Next.
8.
Much obliged.
Yes, Aditya.
Please, my lord, this is the issue on the execution. My lords, I place case law now. None of their arguments hold, and I've submitted the citations. One thing I must point out, my lord, while resisting the jurisdiction of the commercial court in Bangalore, they filed their 34 before Bangalore after losing the award. That 34 is dismissed. They filed a section 37 before this honorable court last year in August. They keep that pending in objections. They neither let the execution go on in Thane. And when I file execution proceedings here, while the petition is pending, they dispose of assets. My lord, there's an urgent need that they disclose. I have placed 2 citations on record which cites the Supreme Court judgments which sets the issue to rest. My lords may just have the compilation.
Yes.
And for ease, my lord, what I've also done is I've prepared a short synopsis and a note.
Yes.
With my lord's permission, I'm just handing this over.
Sir,
So it is a list of dates followed by the propositions. I will straight go to the propositions, my lord, which starts on My lords may take it that they've not succeeded in the award. The 34 has been dismissed, 37 pending for a year. They have not moved it. There's no stay. Please take page 4, my lord.
Yes.
I've set out 7 points.
Yes.
The first point on their objection to Bangalore as a jurisdiction, now it's no longer res integra, because in this very fact, my lords have passed an order saying that Bangalore is where the jurisdiction
So it's
sits.
between the same parties.
Same parties, exact same. In this case itself, they had resisted at this time of the initiation. Second point, my lord, under 36(1) of the Arbitration Act, 36(1) makes a reference to court, saying that you can go to any court, which the Honorable Supreme Court in Sundaram Finance has interpreted to say that you will go to the jurisdictional court and any other court in the country where they have assets. They make an argument saying that no, you should go only where I have assets. Very simple, my lord. That argument won't hold if you just take the example of an international commercial arbitration. A party is not in India, where else can you go? You only have to go to the court with jurisdiction. Point 3, my lord. The page over. The respondents have filed their own, all their petitions in challenge to the arbitration is before this honorable court's jurisdiction. 4, my lord, I've quoted the judgment in Motorola.
Yes, yes.
Notwithstanding, they cannot be allowed, they withdraw and they take away surrender leased offices when the execution is pending. On a proposition of law, I would suggest once jurisdiction is conferred, it cannot be destroyed and taken away, especially through malicious acts. 5th,
I've heard Dhyan Chinnappa already. Dhyan Chinnappa had appeared, right?
Yes.
Yes.
My lords, one submission, my lords, with regard to the surrender of lease, if it may be seen, my lords, I'll point it out.
Yes.
Page number 206, my lord. The lease has been surrendered because the lessor wanted the property, my lords. On
Correct.
page number 208.
Surrendering of lease,
Yes.
will answer. So
That
you are bound by the lease, so you have surrendered.
Yes, my lords, we surrendered it because the lessor has asked us for the property back so that he can dispose it of as per their required terms. My lords, one submission that I have is, my lords, the petitioner is a former employee of the respondent herein, my lords. So she is well aware of the assets of the petitioner that were existing in Bangalore at the time, my lords. The property being the said property which has now been disposed of in the lease, my lords. Now, my lords, it's my submission is that, my lords, under as per section 136 of CPC, my lords, even if the arrest has to be made, suppose I do not comply with the order, I am not saying I am not going to comply. In the event that I do not comply, my lords, the matter has to be, the arrest warrant has to be sent back there, my lord. To avoid all of this and to holistically look at the matter, my lords, it makes more sense to have this application filed there.
I'm not
even if the application is to be
means-
allowed here, my lords, it can be allowed only for the limited scope to disclose my assets as existing before this honorable court.
That is all I'm asking for. There's nothing, there's no arrest. Right?
Existing within
He
the
was Bangalore to Thane.
Thane to Bangalore.
Allah. Thane has now come to Bangalore because of him. You are saying it should go to Thane.
No, there are two things I'm saying.
Yes.
I'll place the proposition before your lordships. I understand your lordships have expressed that possibly they are right. But I think your lordship must look at it from a slightly
So it's
different
only
point.
a prima
facie.
facie. That's all it.
Prima facie. Of course, until your lordship decides, I know, my lord, until the last word is said, there's no decision taken. My lord,
It's only an interaction.
yes,
Yes.
I'm going to make my submissions, my lord. When an arbitral award is made, unlike, my lord, when a court decides in a normal civil proceeding, you have to file the execution in the same court, and then you can transfer it. The decree, my lord, at that point in time can be transferred simultaneously to various courts, because there may be different properties in different jurisdictions, so each court will exercise jurisdiction. But in arbitration, you don't have to come to the court where the award was made. You can straight away go to a court which has the properties. And therefore, there is no need.
So your submission is today there are no properties here.
No, I'm coming to the next point. The point, my lord, is not that. They can come here as well. They could have come here first. Where you go first is in my humble submission.
Oh, they have gone to Thane first.
They went to Thane first. They didn't come here first. They went to Thane first. They filed an execution there. They say Thane courts are not good. They're delaying matters too much. We are delaying it. Therefore, courts are delaying it. Therefore, they came here. That's the answer given, my lord. And last time also, your lordship recollect. When I said Thane, they said, oh, they're taking time to file objections. They're not filing objections. There is no, nothing that's happening in
That
Thane.
be utilized for jurisdiction purpose.
That can't be utilized for jurisdiction. That is one. But anyway, my lord, let us assume they can come here as well. Going to a court first has some significance. To which court you go, because the argument advanced and the judgments which they've placed before my lord says, this could be a pre-execution stage. Order 21, Rule 41 is a pre-execution stage in the sense that you are collecting information to decide where to go to, which becomes relevant from the point of view which court you go to first.
He's already gone to Thane.
That's what I'm saying. He's gone to Thane. If he wants to ask that question as to where your assets are, he must ask that court first. If he asks that court first, because he says it's pre-execution, it is really not execution, but it is pre-execution. If it is pre-execution, the court where you go first, you ask the question. There you get, let's say, details. I have properties in Bangalore. You can then say, I don't want any transfer. You keep this petition here. Or there's no properties in Thane. You keep this petition here. I'll go file an independent petition in Bangalore, independent in Goa and Delhi or wherever. Otherwise, please see the scenario that they're trying to create. They can then say, I will simply go to Mizoram and file an application there and then say, now disclose assets where you are, because I happen to be there. It can't be. There has to be some nexus to jurisdiction, which is why I'm respectfully saying, in a case of this kind where you're saying Order 21, Rule 41 is pre-execution and you've already gone to Thane, that is the first court you must ask the question. And then you can go to various courts. You cannot come to court because this court you feel is more convenient for whatever other reasons that you may have, and then say, now give me information as to where your assets are.
What other reasons?
Beg your pardon?
What other reasons?
The other reason is lawyers.
It's fair.
There can't be any other better reason. That's the best reason that can be to invoke jurisdiction. As a matter of fact, lordships know. In Delhi, the intellectual property practice was such that wherever there may be violation, they will bring it to Delhi. Somewhere you find jurisdiction because you want it to be in Delhi. Then of course court said you can't come here and then send them to different courts. That's how it ultimately, as lawyers, our duty is to try and get as much work to Karnataka courts.
Oh, that's good. Yes.
Therefore, the point I'm only making is this: while you could have come to Bangalore directly and filed the first execution here, the fact that you've gone to Thane first and filed the petition there will only mean that pre-execution prayer which you could have made could only have been made in Thane. And not having made there and having chosen not to make it
2141 should have been filed
made there first, because you said you don't know the assets. But the fact, my lord, is they know the assets. In the Thane execution petition, they've obviously identified assets and they've proceeded. But they think that is going to get delayed, therefore they will come to Bangalore. That can't be a justification to come to Bangalore. Therefore, the court's finding that there has to be some jurisdictional element, and here the asset which was there does not exist anymore. And the garnishee against whom you proceeded says, I am not liable to pay any amount to the judgment debtor, has resulted in a situation where the court does not exercise any further jurisdiction. And therefore, my lord, my submission is that the Thane court alone will be the court where they can make this application.
This point also I put down in the submission as to, because the same question came up before the Delhi High Court in the first judgment in my compilation. The court there was dealing with an issue as to whether you should go to Delhi. This is the judgment in Gujarat Hotels.
No, correct. In that case, the petitioner there had already chosen.
Yes, they had gone to Rajasthan. They had also filed before Delhi. And in para number 22, the High Court quotes two judgments in Premlata Agarwal of 1970 Supreme Court, SBI versus Indexport 1992 Supreme Court, to say that those rigors that we apply to suits don't apply to executions. You can go to as many courts simultaneously as possible because the interest is you reach the assets. And the exception in arbitration cases, which Sundaram Finance and associate contractors have been reconciled, is to say that you have the option of going where the assets are. You have the option going where they reside or registered. You have the option of always going to the seat court because that is the principal court. This is what has come out in these judgments. I've culled out those paragraphs and I've placed it.
All right. Ashal.
So deeply obliged.
Heard so and so reserved. Enter ಮಾಡಿದ್ಯಾ?
We requested the trial court to keep the proceedings continued. Let me give it continued.
To keep the proceedings pending, no, that's
ಹೇಳಿದ್ದೀರಾ?
Ide. Let can be continued. So deeply obliged.
Yes. Next.
9.
This is the partial compromise. Second response. Partial compromise.
Pasovara.
Partial compromise matter.
Yes, partial compromise. Yes. ಇನ್ನೇನಿದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆಯಾ? ಆಯ್ತಾ?
ಇಲ್ಲ ಆಗ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಅವ್ರದ್ದಾಗಿದೆ.
Yes, I have a submissions, my lord. The petition is directed against the rejection of compromise petition. Lord, we oppose the compromise for the reason the list on hand for rectification of SLD is it covered under section 26 of the Specific Relief Act. Lord, the merit of the suit may not be required for the decision making in the writ petition. Lord, we jointly opposed the suit in a common written statement. There are 3 defendants, 1 plaintiff. Lord, in the year 1998, there was a sale deed. Then 2004, my lord, it was a rectification deed to that sale deed. Then, my lord, in the year 2013, that is after lapse of nearly 2010, my lord, after lapse of 6 years, my lord, the suit is filed. So far as law is, procedural law is concerned, my lord is very well aware, the trial court, while accepting the compromise petition, must satisfy. Though the compromise is lawful, it doesn't mean that, my lord, it is deserves to be accepted. The satisfaction of the court is very element. To have a satisfaction, the nature of the property, nature of the lease, and nature of the relief sought for, all those things has to be looked into. As I brought to your lordship notice, in the case on hand, that is for rectification. But in the merit, your honor, and as per the section 26, my lord, there must be a fraud or by a mistake. In the entire reading of the plaint, there is no such element. Moreover, it is also barred by limitation, so far as merit is concerned. But compromise, your honor, if we read the compromise, it is not stated what should be rectified. Moreover, because of he has given a cite to the respondent 1 and 2, my lord, the compromise may be accepted. But what type of compromise, which should be rectified, which boundary to be rectified?
ನಿಮಗೆ ಬೇಕಾಗಿದ್ದ ಸೈಟ್ ಕೊಡ್ಲಿಲ್ವಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಆಕ್ಚುಲಿ ನಾನು ನಮ್ಮ ಬ್ರದರು ಹೇಳಿದ್ರು, ಈಗ 2 ಸೈಟ್ ನಾವು ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ವಿ, 2 ಸೈಟ್ ಕೊಡಿ ಅಂತ. ಇದು ಪ್ರಾಪರ್ಟಿ ಬೇರೆ ಇದೆ ಸ್ವಾಮಿ, ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದು, ನಾವು ಸ್ವಾಧೀನದಲ್ಲಿ ಇದ್ದೀವಿ. ಈಗ ಅವ್ರು ಕೊಡೋದಿದ್ರೆ ತಾವು ಮಾಡಿಸಿದ್ರೆ ನಾವು ಈಗಲೂ ರೆಡಿ ಇದ್ದೀವಿ.
He wants 2 sites.
That is what my brother last time has.
What was the earlier compromise?
The present compromise, my lords, is I'm giving 1 site to all of them, 3 of them.
1 site to all of them.
1 site each.
Why do you want 2?
But actually ಏನಾಗಿದೆ, they are not strangers, my lord. These are all our blood relatives.
Correct.
Severe co-partners. ಈಗ ನಮಗೆ ತುಂಬಾ ಪ್ರಾಪರ್ಟಿ ಲಾಸ್ ಆಗತ್ತೆ, ಇವರು ಅವರು ಸ್ವಲ್ಪ ಕಲ್ಯೂಷನ್ ಆಗಿದ್ದಾರೆ. ಅಟ್ಲೀಸ್ಟ್ ಇನ್ ಸ್ವಲ್ಪ ಏನಾದ್ರು ಮಾಡಿ ಕೊಟ್ರೆ ನಾವು ವಿ ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್.
ಸ್ವಲ್ಪ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿಕೊಟ್ರೆ
ಹಾಗಲ್ಲ ಸ್ವಾಮಿ, ಅಡ್ಜಸ್ಟ್ ಅಂತ ವರ್ಡ್ ಯೂಸ್ ಮಾಡೋದು ಬೇಡ ಈ ಕೋರ್ಟ್ ನಲ್ಲಿ.
ಬೇರೆ ಕಡೆ ಮಾಡ್ಬೋದಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ನಾವು ದಯಮಾಡಿ ಅಲ್ಲಿ ಏನಾದ್ರೂ ಪ್ರಾಕ್ಟಿಕಲ್ ಆಗಿ ಮಾಡಿದ್ರೆ ನಮ್ದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. ಈಗ ನಮಗೆ ಸ್ವಲ್ಪ ಅನ್ಯಾಯ ಆಗಿದೆ, ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೊಡಿ ಅಂತ ನಮ್ ಡಿಮ್ಯಾಂಡ್ ಅಷ್ಟೇ. ಹಾಗಾಗಿ ಅವ್ರು ಕೊಡೋದಾದ್ರೆ ಇಲ್ಲಾಂದ್ರೆ ಏನಾಗ್ತಿದೆ ಸ್ವಾಮಿ, ಇಲ್ಲಿ ಇವಾಗ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Can you sit and settle?
I have, the only issue is this, I am willing to sit.
Legally will answer. I'm not telling I will not answer. But if by a dialogue it can be solved.
I am willing to sit and talk. Because for me, at the end of the day, I am unable to.
ಆಗ್ಲಿ ಸ್ವಾಮಿ, ನಾನು ನಮ್ಮ ಬ್ರದರ್ಗೆ ಹೇಳಿದೆ, ಮಾಡಿಸಿ, ನಂದೇನು ಅಭ್ಯಂತರ ಇಲ್ಲ, ಸ್ವಲ್ಪ ವಯಾ ಮೀಡಿಯಾ ಮಾಡಿಸಿ ನೋಡಿ ಅಂತ.
ನಿಮ್ ಬ್ರದರ್ಗೆ ಅಂದ್ರೆ
ಅದು ಇವ್ರು ನಮ್ಮ ಬ್ರದರ್ ಸ್ವಾಮಿ.
ಪೆಟಿಷನರ್ ನಿಮ್ ಬ್ರದರ್ ತಾನೆ, ಅದಕ್ಕೆ
ಅದು ಸರಿ, ಲಿಟಿಗೇಂಟ್ಸ್ ಅಲ್ಲಿ ಬ್ರದರ್, ಪ್ರೊಫೆಷನಲ್ ನನ್ನ ಬ್ರದರ್ ಅಂತ ಹೇಳಿ ಸ್ವಾಮಿ. ಅವ್ರು ಮಾಡಿಸೋದಾದ್ರೆ ಏನು ತೊಂದರೆ ಇಲ್ಲ, ಬಟ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಸ್ಟಾಪ್ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ.
ಅವ್ರು ಮಾಡಿಸೋದಲ್ಲ, both of you should sit and
yes my lord, I am very cooperative. My party is also present.
Seriously?
Yes. Seriously, honestly, heartily, my lord.
All right, yes.
What I told senior also was, now 1 and 2 have agreed. If I am giving him something higher, the 1 and 2 now will come and say, you give me higher than what you're giving to him. So my compromise with 1 and 2 will now go if I give him something higher than what he's
my
getting.
brother has expressed last date of my lord.
Now you spend the weekend for that. I'll take it on Tuesday.
Please.
All right. If nothing is arrived at by Tuesday, even if I give you 3 months, you will not arrive. So I will decide it on merits.
Please.
In the meantime, my lord, let there be
weekend alone construction
ಅಲ್ಲ ಸ್ವಾಮಿ, ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಪ್ರತಿ ಇವನ್ ಟುಡೇ ಐ ವಿಲ್ ಶೋ ದಿ ಫೋಟೋಗ್ರಾಫ್. ಯುವರ್ ಲಾಸ್ಟ್ ಮೇ ಕೈಂಡ್ಲಿ
ಪಿಲ್ಲರ್ ಹಾಕಿದಾರಾ?
ಪಿಲ್ಲರ್ ಹಾಕಿ ಮೋಲ್ಡ್ ಹಾಕಕ್ ಮಟ್ಟಕ್ಕೆ ಬರ್ತಾ ಇದೆ. ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನವರು ಇಲ್ಲಿ ಸ್ಟೇ ಆರ್ಡರ್ ಇರೋದ್ರಿಂದ ನಾವು ಮಾಡೋಲ್ಲ ಅಂತ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಾನು ಆರ್ಡರ್ ಪಡಿಸಿದ್ದೀನಿ.
ಇಲ್ಲೇನ್ ಸ್ಟೇ ಆಗಿದೆ?
ಇಲ್ಲಿ ಎಂಟೈರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇಸ್ ಸ್ಟೇಡ್ ಮಿಲಾಟ್. ನೌ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಸ್ ನಾಟ್ ಟೇಕಿಂಗ್ ಅಪ್ ಅವರ್ ಅಪ್ಲಿಕೇಶನ್, ಇಂಜಂಕ್ಷನ್ ಅಪ್ಲಿಕೇಶನ್.
ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್.
ಹೌದು ಸ್ವಾಮಿ.
ಈಗ
ಬೇಕಾದ್ರೆ ಸ್ಟಾಪ್ ಮಾಡಿ ಸದ್ಯಕ್ಕೆ, ಆಮೇಲೆ ಏನೋ ಮಾಡಿ ಸ್ವಾಮಿ.
ಒಂದೇ ನಿಮಿಷ
ಆಯ್ತು ಸ್ವಾಮಿ.
ವೀಕೆಂಡ್ ರೆಸ್ಟ್ ತಗೊಳ್ಳಿ. I'll take it on Tuesday.
No. I took instructions on the submission. It's being built on my portion of land, not on the 14 guntas which is disputed in the property. If your lordship sees the plaint, my lord, it's a
No, I will
sketch.
only clarify that construction shall not take place other than what his land is.
Your lordship may just see para 30, page 38, my lords.
But according to us, he is
Hello.
constructing in our property. Because there is a serious dispute.
Our illa ಈಗ ಇನ್ನು ಕಾಂಪ್ರಮೈಸ್ ಆದ್ಮೇಲೆ your property. ಅಲ್ಲಿವರೆಗೂ our ಇಲ್ಲ. You are asking for that property now, you say ಅದನ್ನ ಇನ್ನು ಕೊಟ್ಟೋಕ್ ಮುಂಚೆನೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಬಾರದು. Our property ಆಗೋದು ಆಮೇಲೆ.
ಆದ ನಂತರ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇರೋದು ಮೆಲಾಟ್, ಇದು ಆದ ನಂತರ ಕಾಂಪ್ರಮೈಸ್ ಆದ ನಂತರ ಮಾಡ್ತಿರೋದು, ಮೊದಲೆಲ್ಲ ಏನೂ ಆಗ್ಲಿಲ್ಲ. ಏನೋ ಒಂದ್ ಸ್ವಲ್ಪ ನಂದೇನ್ ತೊಂದರೆ ಇಲ್ಲ ಸ್ವಾಮಿ, ಈಗ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಹೋದ್ರೆ ಈಗ ನನಗೆ ಅನ್ಯಾಯ ಆಗತ್ತೆ ಸ್ವಾಮಿ, ದಯಮಾಡಿ.
ಈಗ ನಿಮಗ್ ಬಂದ್ರೆ ಅದು ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಏರಿಯಾನೇ ಸಿಕ್ಬಿಡುತ್ತೆ.
ಅಲ್ಲ ಇಲ್ಲಿ ಸೂಟ್ ಹಾಕಿರೋದು ಅವರು ರೆಕ್ಟಿಫಿಕೇಶನ್ ಸ್ವಾಮಿ, ನಾನು ಹಾಕ್ಲಿಲ್ಲ. ನನ್ ಜಾಗ ಸೇರ್ಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಈ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿ ಆದ್ಮೇಲೆ ಈಗ ಸೇಲ್ ಮಾಡಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡ್ತಿದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರ
don't render everybody's right fait accompli. So on Tuesday morning I'll take this. Till then don't construct.
I'll tell orally, tell my client.
Orally ashtane, don't worry. I will not also pass an order, and if he again complains that you use the weekend to take it to a next level.
From today I'll tell him nothing to be done.
Yes.
ಆಯ್ತು ಸ್ವಾಮಿ.
Your brother has told, don't worry. Yes. List the matter on Tuesday in preliminary hearing.
Yes.
Interim order subsisting will continue to the next date.
Obliged.
Yes.
10.
Non-filing of wakalat.
Appearing for the petitioner, my lord. My senior is engaged in another court hall. Can I humbly request for the matter to be adjourned?
Application
617.
670. But suit is filed, my lord, and
Not read the papers? Then.
Lord, during the pendency of the suit, my lord, purchaser pendente lite is impleaded. He claims, my lord, to have purchased the property.
After institution or before institution?
After institution.
Partition suit?
No, suit for specific performance. Specific performance.
Specific performance ಅಲ್ಲಿ third party ಅಲ್ಲಿಂದ ಬರುತ್ತೆ.
ಅಲ್ಲ, ಅವ್ರು ಬಂದು ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅವರೇ ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. They would take, my lord, a sale deed during the pendency of the suit. I brought about, my lord, an amendment to show how it is not a bona fide sale and that sale deed will not bind my rights.
What has happened? The amendment is rejected.
Allowed. Because, my lord, if there is a sale deed, my lord, during the pendency of the suit.
We'll see, we'll answer it. Yes. Pass over, madam.
Some other day it can be taken.
We'll take it on 23rd. 23rd. Yes. At the request of the council appearing for the petitioner, list the matter on 23rd. Yes, next.
11.
Appearing for respondent.
Yes. And I filed an application for granting of TI, my lord. The defendant is the sole defendant, he is a stranger, my lord. He is no way concerned our property.
1 minute. First appellate court ಹೋಗಾಯ್ತಾ?
ಆಗಿಲ್ಲ.
TI is rejected.
TI rejected.
Concurrent finding.
Concurrent finding.
ಹೇಳಿ sir.
ಅಲ್ಲ, my lord. We are the title owner of the property, my lord.
Stay ಇದೆಯಾ ಇಲ್ಲಿ?
ಇಲ್ಲ sir.
ಇಲ್ಲ, ಇದರಲ್ಲಿ
ಪೆಂಡಿಂಗ್ ಇದೆ. ಒಂದು ನಿಮಿಷ ಆದ್ಮೇಲೆ ನೀವು ಹೇಳ್ರಿ.
A coordinate bench has granted status quo. ಹೇಳಿ.
We are the title owner of the property, my lord. The RTC which are produced by me, my name has been reflected in all RTC. Even 2023 RTC, my name has been reflected. The contention is to relate to MR number. He hand in glove with the revenue authorities, created that MR numbers and objected my possession.
How did you come in possession?
But I am the possession because by
how did you come in possession?
By virtue of sale deed, my lord.
Where is the sale?
I produced the sale deed. You will ask, please see.
Wait, ನಿಮಗೆ ಬರ್ತೀನಿ.
Page 78, my lord. Page 78. 1906ನೇ ಇಸ್ವಿನಲ್ಲಿ ನಮ್ಮ ತಂದೆ ಕೊಂಡ್ಕೊಂಡಿದ್ದಾರೆ.
1906ನೇ
ಇಸ್ವಿನಲ್ಲಿ my lord, ಈ ಪ್ರಾಪರ್ಟಿ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ 30 acres. ಇದರಲ್ಲಿ ಸರ್ಟನ್ ಪೋರ್ಷನ್ ಅಕ್ವೈರ್ಡ್ ಬೈ ದಿ ನ್ಯಾಷನಲ್ ಹೈವೇ ಅಥಾರಿಟೀಸ್. ಅದರಲ್ಲೇ ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಲ್ಲ ಮಾಡಿ ಆ ಪ್ರಾಪರ್ಟಿಗೆ ಸಂಬಂಧಪಟ್ಟದ್ದು ಯು ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಲಿಟ್ಲ್ ಬಿಟ್ ಇರಬಹುದಂಗೋ ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟದ್ದು ಅದ್ರ ಇದರಲ್ಲಿ ಸರ್ಟನ್ ಪೋರ್ಷನ್ ಇವ್ರು ನಮ್ಗೆ ಬಂದು ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ ನಮ್ಮ ಪೋರ್ಷನ್ಗೆ.
ಈಗೇನ್ ಸೂಟ್ ಫಾರ್ ವಾಟ್?
ಸೂಟ್ ಫಾರ್ ಬೇರ್ ಇಂಜಂಕ್ಷನ್ ಮೇಲೆ.
ಇಂಜಂಕ್ಷನ್
Therefore, I filed an IA for grant of.
Who are you, sir?
I am the purchaser of the lands.
When?
Under
Page.
2 sale deeds, I have purchased the land.
Page. ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೇನೆ. ಇದಕ್ಕೆ ಹಾಕಿಲ್ಲ. ಇದರಲ್ಲಿ ಐಎದಲ್ಲಿ ಹಾಕಿದ್ದೇನೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಂಡ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್.
When did you purchase, sir?
In 1984 and 2009 through a registered sale deed. That has, my mutation has been challenged by him in the Assistant Commissioner Chitraduga.
ಏನಾಯ್ತದು?
ಅದರಲ್ಲಿ ಎಲ್ಲ they have observed. He cannot question the sale deed.
You purchased it from whom?
That is fine.
It waits.
Ekantaya and Chellamma. They were also purchased from previous vendors. That land, entire land has been sold. He is not the owner. He is not in possession. Your Lordship kindly see the
ಅಲ್ಲ ಇಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬಿಡಿ, ಹಾಕಿ ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನಿದೆ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಅಲ್ಲ ಏಕಾಂತಯ್ಯ ಈಸ್ ಆಲ್ಸೋ ಸ್ಟ್ರೇಂಜರ್ ಮೇಲೆ ಇವರು ಈ ಟೈಟಲ್ ಓನರ್ಸ್ ಇದ್ರಲ್ಲ ಮೇಲೆ ದೇ ಆರ್ ಡಿಪ್ರೆಸ್ಡ್ ಕ್ಲಾಸ್ ಪೀಪಲ್ಸ್ ಮೇಲೆ ದೇ ಆರ್ ರಿಸೈಡಿಂಗ್ ಸಮ್ವೇರ್ ಇನ್ ವಿಲೇಜ್, ನಾಟ್ ದಿ ಹಿರಿಯೂರ್. They are encroaching my land and created certain documents and they are contesting that we are the purchaser. Who is the purchaser? They don't know. ಅವ್ರು ಹಾಕ್ಲಿ ಸ್ವಾಮಿ ಮಲೆ ಅಲ್ಲಿವರೆಗೂ ಇವ್ ಲಾಶಿಪ್
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿ ಅಲ್ಲ, ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಸ್ಟೇಟಸ್ ಕೋ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಅದ್ರ ಮೇಲೆ ಏನು ಆರ್ಡರ್ ಕೊಡಲ್ಲ
ಅಲ್ಲ ಮಲೆ. ಈಗ ಏನಿಲ್ಲ, ಒಂದು ಡೇಟ್ ಕೊಡ್ಬೋದು ಇವ್
ಅದು ಖಂಡಿತ ಕೊಡ್ತೀವಿ.
ಡೇಟ್ ನೆಕ್ಸ್ಟ್
learned counsel for the respondent defendant is seeks 2 weeks time to file statement of objections. According to him, the petitioners are not in possession and have no right to disturb the possession of the defendants who are in possession pursuant to two registered sale deeds of the year 1984 and 1984 and 2009 respectively. List the matter on 30th. Objections, if any, by then the interim order of status quo subsisting would continue till the next date of hearing. Yes, next.
12 I appear for the petitioner. I had filed an application to delete myself under order 1 rule 10.
Why?
On the ground that I had no privity of contract with the plaintiff.
Commercial premises yardu?
If I may explain, my lord, I am a company defendant number 2.
Yes.
I engage in the work of interiors, structural glazing, etc. A project comes to me. In order to execute that project, I engage the services of defendant number 1. Defendant number 1. So I raise a purchase order in favor of him. He raises an invoice. I make payment. This transaction is complete. To execute the work, defendant number 1 entrusts the work to the plaintiff. Plaintiff completes that work. Defendant number 1, my lord, fails to pay to the plaintiff. Defendant number 1 has made partial payments. He has issued certain checks. Checks have bounced.
So there's a dispute between him and
plaintiff and defendant number 1, not me. He himself admits that I have already cleared the amount in respect of defendant number 1. And now the issue is, my lord, defendant number 1 is placed ex parte.
No. Defendant number 1 is placed ex
parte.
Yeah,
so the entire case is on me, my lord. I am defending the suit. There is an order passed by this court, interim order, staying the proceedings.
Yes,
now
sir.
they have appeared.
He is the main contractor.
Main contractor. All right, you file your objection.
And yes.
File your objections.
Yes, I will file.
The learned counsel appear. Sister ತೋರಿಸಿದಾರಾ? AC Patil ಅಲ್ಲಲ್ಲ, Maling Bhatt. You are Maling Bhatt. Learned counsel M. Maling Bhatt seeks 2 weeks time to file statement of objections. Objections, if any, by the 30th. Interim order subsisting will continue to the next date of hearing.
Grateful.
10 days time ಅಂತ ಮಾಡಿ. ಅದು 2 weeks ಆಗಲ್ಲ ಅಲ್ಲಿ. Next. ಮುರಳಿ ಬಾಬು.
Permitted to rejoinder to the objection statement. I am permitted to file rejoinder to the objection statement. And also complaints of the legible copy of the annexure B.
Sixth August. Yeah. Rejoinder copy ಕೊಟ್ರಾ? ಏನ್ ಬೇಡವಾ?
I have read through it, my lords. It only is disputing as regards the boundaries and his total land.
That does not go to the core of saying what is the challenge to the acquisition as such. My lords, my respectful submission would be, if he is entitled to a larger extent of land, let him make out before an appropriate authority. That is, well, award is being passed.
Again, Madidira, sir. Yes, sir.
My lords, one more subtle issue.
Admittedly.
He has, in 2024, he has asked for compensation. Now he cannot approbate and reprobate and challenge the acquisition. 2023-22 is the final notification. 24, he himself asks for compensation. Now he has challenged it.
This is not my application, my lord. Signature is, my lord, this not belongs to me. Lordship, may kindly see signature in my affidavit of color. This is, my lord, the created document by the.
Created who, by whom?
They have
By
created.
KDB.
Lordship, may kindly see the document.
All right, really. Yes, sir. What is the grounds of challenge, sir?
Not grounds of challenge is not. Lordship, Annex A, Lordship, may kindly see. The total extent of the land, the survey number 67, has 6 acres. Out of which, my lord, the 3 acres, 4 guntas is a karab.
ಏನು acquisition notification ಏನಿಲ್ಲ ಇದರಲ್ಲಿ?
ಅಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಅಲ್ಲ ರಿಟ್ ಪಿಟಿಷನ್ ಇತ್ತಾನೆ?
Annexure B is the.
Annexure B na?
B, Annexure A, the Annexure B is the preliminary notification.
ಓ ಇದಿಲ್ಲಿ
28-1.
ಹಾ
ಅದು legible copy produce ಮಾಡಿದ್ದೀರಿ ಇವತ್ತು.
ಆಯ್ತಾಯ್ತು ಹೇಳಿ.
The total extent 6 acres, 3 acres 4 guntas is the karab, A karab, 23 guntas is the B karab. The remaining land is 2 acres 13 guntas belongs to our family. We are the owners of the family, 2 acres 13 guntas. Let out of which, let I am the owner of the 23 guntas, let the entry number in the Pani, RTC, my name is shown. The last kind is Annexure B. At page number 16, item number 59. Initially, out of 67, 3 acres 27 guntas acquired by the KDP, out of which it is classified as 2 acres 16 guntas the Karab land, government land. 1 acre 11 guntas is the Hidwali land, belongs to the family of the petitioner here. Thereafter, Lord, issued notice to the petitioner herein, Annexure C. Let the annexure, the hearing date fixed in the said notice 28/1/2019.
28/1/2019.
Let next Annexure D. ಪ್ರಕರಣವನ್ನು ಕೂಗಿಸಲಾಯಿತು, ಖಾತೆದಾರ ಹಾಜರು, ದ್ರಾಕ್ಷಿ ಬೆಳೆ ಇರೋದ್ರಿಂದ
Annexure D na?
Annexure D.
19, page number 19.
ದ್ರಾಕ್ಷಿ ಇರೋದ್ರಿಂದ ಇದು ಬರುದಿಲ್ಲ, ಅಕ್ವಿಸಿಷನ್ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡ್ತಾರೆ. ಆಮೇಲೆ 24/1/22 ಅಲ್ಲಿ ಮತ್ತೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಒಂದು ಇದು ಮಾಡಿಕೊಂಡು ಮತ್ತೆ ಪ್ರಕರಣವನ್ನು ಕೂಗಿಸಲಾಯಿತು, ಖಾತೆದಾರರು ಹಾಜರು, ಭೂ ಸ್ವಾಧೀನಕ್ಕೆ ಒಪ್ಪಿಗೆ ಇರುವುದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಮೇಂಟೈನ್ ಮಾಡಿ.
24/1/22 ನಾ?
24/1/22
ದ್ರಾಕ್ಷಿ ಬೆಳೆದ್ರಿಂದ ಭೂ ಸ್ವಾಧೀನಕ್ಕೆ ಒಳಪಡುವುದಿಲ್ಲ ಅದಕ್ಕೆ.
ಹೌದು,
ಅದೇನಿದು
ಅದೇ ಆದೇಶಕ್ಕೆ ಕಾಯ್ದಿರಿಸಿದೆ.
ಆದೇಶಕ್ಕೆ ಕಾಯ್ದಿರಿಸಿದೆ, ಆರ್ಡರ್ಗೆ.
ಏನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿಲ್ಲ.
28(3) order is
passed.
Where is the 28(3) order?
We have not affixed it in the pleadings, sir, but nevertheless.
Where is the 28(3) order?
After that 28(4) notification is issued.
Sir, 28(3) you have inserted this 24/1/22. ಅದಕ್ಕೆ ಮುಂಚೆ ಏನಿದೆ? ಕೆಳಗಡೆ ಪ್ರೊಸೀಡಿಂಗ್ ನಿಮ್ದೇ ಅಲ್ವಾ?
Please, my lord, there's a detailed separate order.
Where is it?
I'll produce it, my lord.
Why you have not produced with the objections?
ಅಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಕೂಡ ತಾವು ಒಂದ್ಸಲ ಅನೆಕ್ಸರ್ ನೋಡ್ಬೋದು ಸರ್. ಅನೆಕ್ಸರ್
that contention was not taken as regards.
That's all right, sir.
Annexure, last me kindly listen that the annexure.
ಎಲ್ಲ ರೆಸ್ಪಾಂಡ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲ,
ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ
ಹಾ.
annexure R8.
R8
ಹೌದು, 8/7/25 ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರೆ.
ಒಂದು ನಿಮಿಷ.
Award proceedings.
ಅದರಲ್ಲಿ ನನಗೆ ನೋಟಿಸ್ ಕೊಡಲ್ಲ, ಪಿಟಿಷನರ್ ನೋಟಿಸ್ ಕೊಡಲ್ಲ. ನಮ್ಮ ಬ್ರದರ್ ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಅಂತ ಹೇಳಿ ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಒಳಪಟ್ಟಿರುವುದಿಲ್ಲ ಅಂತ ನಾವು ತಿಳಿಸಿರ್ತೀವಿ. ದಿಸ್ ಲ್ಯಾಂಡ್ ಈಸ್ ನಾಟ್ ಅಕ್ವೈರ್ಡ್ ಬೈ ದಿ KDB.
Which whose land?
ಅದ ನಮ್ಮ ಒಂದ್ ಎಕರೆ 11 ಗುಂಟೆ ಮಾತ್ರ ಅಕ್ವೈರ್ ಆಗಿರೋದು. ಟೋಟಲ್ 2 acres 13 ಗುಂಟಾಸ್ ಇರೋದು ನಮ್ದು ಓನರ್ಶಿಪ್. ಅದರಲ್ಲಿ ಈಸ್ಟರ್ನ್ ಸೈಡು ಇಬ್ಬರಿಗೆ ಬಂದಿದೆ ಅಣ್ಣ ತಮ್ಮಂದ್ರಿಗೆ, ವೆಸ್ಟರ್ನ್ ಸೈಡ್ ಆಫ್ ದಿ ರೋಡ್ ಇಬ್ಬರಿಗೆ ಬಂದಿದೆ. ಆ ವೆಸ್ಟರ್ನ್ ಸೈಡ್ ಇದರಲ್ಲಿ ಅವರು ಇವ್ರು ಇರೋದು ಸಮೀರ್ ಭಗವಂತಪ್ಪ.
ಅದು ಯಾರು ನನಗೆ
ಅಲ್ಲ, ಒನ್ ಆಫ್ ದಿ మన ಚಿಕ್ಕಪ್ಪನವರು ಇವರಿಗೆ
Identification of property, my lords. In 1
ಅದರಲ್ಲಿ-
acre
So that's
11
all that I am not on that. Once having said that orders would be passed, why did you hold proceedings
No, no,
again?
my lords.
24/122, why did you again hold proceedings? There is something cut off here. ಒಪ್ಪಿಗೆ ಭೂಸ್ವಾಧೀನ ಏನದು
ಒಪ್ಪಿಗೆ ಇರುವುದಿಲ್ಲ.
ಈ ಪ್ರಕರಣವನ್ನು ಕೂಗಲಾಯಿತು. ಖಾತೆದಾರರು ಏನಿದು ಖಾತೆದಾರರು ವಾಟ್ ಇಸ್ ದಟ್ ರಿಟರ್ನ್?
ಪ್ರಕರಣವನ್ನು ಕರೆಯಲಾಯಿತು. ಖಾತೆದಾರರು ಹಜಾರರು ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಒಪ್ಪಿಗೆ ಇರುವುದಿಲ್ಲ. After this, a detailed 28(3) order is passed, my lords.
Order passed. First, why is this contradictory? ದ್ರಾಕ್ಷಿ ಬೆಳೆದಿರೋದ್ರಿಂದ ಇದು ಕೈ ಬಿಡಲಾಗಿದೆ ಅಂತಿದೆ. ಆದೇಶಕ್ಕೆ ಕಾದಿಸಿ.
ಅಲ್ಲ, ಮತ್ತೆ
ದ್ರಾಕ್ಷಿ ಬೆಳೆಯೋದ್ರಿಂದ ಕೈ
ಅಲ್ಲ, ದ್ರಾಕ್ಷಿ ಬೆಳೆದಿರೋದ್ರಿಂದ ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಬರುವುದಿಲ್ಲ
ಆದೇಶಕ್ಕೆ ಅಂತ
ಅಕ್ವಿಸಿಷನ್ ಬರೋದಿಲ್ಲ, ದ್ರಾಕ್ಷಿ ಇದೆ ಅಂತ.
These are proceedings.
All right. After that, why is this contradictory thing?
Again, next hearing has happened, my lords. Again, he has made another submission. There have been more than one date of hearing.
Correct. 28/1. What is this? 28/1.
24/122. ಅದು 19 ಇದೆ. ಅದು 19 ಇದೆ, ಇದು 22 ಇದೆ.
3 ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ?
My lords, this has been answered by the coordinate bench. Because my lords,
3 ವರ್ಷ ಅಲ್ಲಿ ದ್ರಾಕ್ಷಿ ಇಲ್ವಾ ಈಗ?
No, my lords, 600 acres has been acquired. Phase by phase we have heard.
ಅಲ್ಲಿ ದ್ರಾಕ್ಷಿ ಇಲ್ವಾ ಈಗ?
In 22 it was not there, my lords. In 19 it was there.
Where did you find that it is not there?
28(3) detailed order is there.
ಎಲ್ಲಿದೆ? Where is that?
ಫೋಟೋಗ್ರಾಫ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ನಲ್ಲ, ಮೈ
28(3) order I have not filed. I'll file it. I'll file it.
28(3) objection ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ?
That contention was not taken, my lords. 28(3) order ಬಗ್ಗೆ ಅದಕ್ಕೆ ನಾನು ಹಾಕಿಲ್ಲ. There is a detailed order not to mention, my lords.
One minute, Patil. Between 28(2) and 28(4) there should be 28(3).
Please.
If 28(2) and 28(2) ಅಲ್ಲಿ, if there are divergent things here, when did you pass the 28(3) order?
Lords, ಇದು 28(2) ಅಲ್ಲ ಇದು. This is a 28(2) is
These
at
are the
page number.
proceedings drawn pursuant to his representation. Correct.
Proceedings.
Now 28(3) ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
After 22, my lords.
After 24/122.
Please.
In all the cases you have done that, or only in this case?
All cases commonly passed, and his own brother has challenged it, has met out. The coordinate bench of this court has dealt with all these issues.
Which judgment?
Annexure
R13 ತಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, even there, my lords.
belongs to
Now,
this land.
let me complete. My lords, what I was saying is all this issue of delay, inordinate delay between notifications, all of that has been
I am
dealt
not
with.
on delay. Why did you take those 3 years?
My lords, this is.
And in those 3 years, the problem is that you have drawn up something else in the middle.
No, my lords,
That
what
is
we were
considered
saying is.
by the coordinate bench.
Please.
Murali Babu, ಇದು coordinate bench ಆಗೋಗಿದ್ರೆ
My lords, in this regard, Reliance is sought and so and so wherein it was held.
ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ 1 kilometer ದೂರದಲ್ಲಿರೋ ಜಮೀನು ಬೇರೆ ಎಲ್ಲ ಸರ್ವೆ ನಂಬರ್ಸ್ ಇದು 63, 64 ಪಟನ್ಸ್ 63, 64 ಸರ್ವೆ ನಂಬರ್ ನಾಟ್ ಬಿಲಾಂಗ್ಸ್ 67. ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅವರು. pertaining to 64.
You give the 28(3) order in respect of this
ಅಲ್ಲ,
survey
ತಾವು
number.
ಒಂದ್ಸಲ R8 ಒಂದ್ಸಲ ನೋಡಿ ಸ್ವಾಮಿ, ಮತ್ತೆ ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರೆ.
R8 ಅಲ್ಲ,
R8 ಅಲ್ಲಿ
page
ಪೇಜ್ ನಂಬರ್ 54.
That is 9 and 10 award notice, not 28.
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರೆ. 87 ಗೆ
award proceedings.
ಅವಾರ್ಡ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ.
9 and 10.
ಮತ್ತೆ ತಾವು ಒಂದ್ಸಲ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 55 11/7 ಗೆ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ. ಆದೇಶಕ್ಕೆ ಕಾಯ್ದಿರಿಸಿದೆ. ಏನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಲ್ಲ ಈ ಆರ್ಡರ್ ಮೇಲೆ, ಈ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ.
Award proceedings are going on as of now.
Get the records.
And more, I'll secure the original records.
The learned counsel B.B. Patil is directed to place the original records concerning the acquisition only insofar as it pertains to the petitioner's land by the next date of hearing. Tuesday?
Please.
List on Tuesday. Interim order subsisting would continue.
ಇದೆ ಅದೇನೆ ಗ್ರಾಂಟೆಡ್ ಟೈಮ್ ಫಿಕ್ಸ್ ಇಲ್ಲ.
Oh, absolute ಇದೆಯಾ? ಯಾರು ಕೊಡ absolute?
Not to dispose ಅಂತಿದೆ.
Shall not.
Dispose.
All right, not.
Please.
Yes, list on Tuesday, preliminary hearing.
Preliminary. Oblige.
Petition files rejoinder, same is taken on record.
Complaints of the annexed, the eligible office objection.
Is complied with the office objection.
Vacate ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ ಮಾಡಿದ್ದೀನಿ ಇವತ್ತು
ಸರಿ, ಆಯ್ತು.
ಕೊಟ್ಟಿದ್ದೀನಿ.
Oblige.
Submits of office objections have been complied with. Office to verify. Next.
Oblige.
14.
Case. Petitioners consider filed some documents from the office may direct to put up those documents.
What put up, sir?
Some documents the
Surface proceedings na ಇಲ್ಲಿ challenge ಮಾಡಕ್ ಬಿಡಲ್ಲ sir. I will not do that.
But in this case,
No,
but
sir.
he has borrowed loan that has spent near 11 lakhs.
ಅದೆಲ್ಲ entire pleading is DRT ಲಿ ಏನ್ ಹಾಕ್ಬೇಕು ಇಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ before the suit, not maintainable at all. Nothing.
Direct to put up those
No put up.
documents and call.
No, this is abuse. I will not do that. ಎಲ್ಲ repayment schedule, everything. What? How is the suit even maintainable? Suit is not maintainable for invoking surface proceedings there.
No, the respondents have suppressed these things with regard to
ಅದೆಲ್ಲ ಅಲ್ಲೇ ಎಲ್ಲ DRT ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ.
suppress those things and made me to purchase.
ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ? What is under challenge?
No, the notice issued by the advocate Millard with regard
Sir,
to.
what is under challenge ಇಲ್ಲಿ ಅಂದ್ರೆ?
Possession notice that they have issued.
Possession notice civil suit civil court ಚಾಲೆಂಜ್ ಮಾಡಕ್ ಆಗುತ್ತಾ? ನೀವ್ ಹೇಳಿ ಕಾನೂನು.
Injunction
ಅಲ್ಲ,
civil suit.
whatever ಏನ್ ಇಂಜಂಕ್ಷನ್ ಹಾಕ್ಬೋದಾ? Possession notice surface act ಅಲ್ಲಿ issue ಮಾಡಿ go before the civil court. Where is the law, sir?
Declaration of permanent injunction ಕೇಳಿದ್ದಾರೆ.
No declaration
Civil
permanent
suit,
injunction
civil-
ಅಷ್ಟೇ ಬಿಟ್ರೆ ಆಮೇಲೆ ಎಲ್ಲ
Civil
civil
suit ಅಲ್ಲಿ they
ಅಲ್ಲಿ
have
DRT ಲಿ ಒಂದು civil proceedings ಒಂದು. Anything else? ಅಲ್ಲ ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಏನ್ ಹೇಳಿ?
ಇದರಲ್ಲಿ ISO they have not considered IA ಅಂತ.
Reject temporary injunction.
Temporary injunction no.
ಇದು
They have issued notice Millard. They have not considered. At least let them consider IS Millard.
ಅದು ನೀವು ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ. If you invite an order from me, then suit maintainable ಅಲ್ಲ ಅಂತ ಬರೀತೀನಿ ನಾನು. ಅಲ್ಲಿ ಯಾರಿದ್ದಾರೆ?
ಇಲ್ಲ ಪಾರ್ಟಿ
ಈ ಕಡೆ ಆ ಕಡೆ ಎಲ್ಲ ನೋಡ್ತಾ ಇದ್ದೀರಾ?
I will seek instruction to.
No instruction. You withdraw this and urge the applications there. Learned counsel for the petitioner, after arguing the matter at length, would seek leave of this court to file necessary application before the concerned court to consider his grievance. In the light of the said submission, reserving such liberty, petition stands disposed. Yes. ಇನ್ನು ಬರೆದ್ರೆ ಆಮೇಲೆ ಅಲ್ಲಿ ಸೂಟು ಹೋಯ್ತು ನಿಮ್ದು. Yes.
15.
For respondent 1 and 2.
Now we have received instructions.
Reserved?
Instructions from the client. We are ready to refund to them 10 lakh, my lord, out of the 14 lakh that was paid as advance.
When?
22nd. Within 2 weeks, my lord.
My lord, entire 14 lakh advance. I have expressed intent to purchase the plot. They refer me to the bank. I have approached Nationalized Bank. Nationalized Bank rejects my loan, stating that insufficient documents. I asked for documents. They reply that there is no documents available. And hence I was forced to cancel the purchase of plots, my lord. Now I am asking for
14
full
lakhs
refund
they
of
are
amount.
paying.
If
We are ready to refund 10 lakhs, my lord.
Why?
My lord, the defamatory reviews that they have posted about us has already caused.
Oh,
us
ಅದಕ್ಕೆ
in amount of-
compensation, huh?
My lord, there is no defamation, my lord. What we have experienced, that is all what has been posted.
First you refund 10 lakhs.
Please.
I will consider it on the next date. List the matter on 25th. The learned count, 25th or what? 1st August.
1st August.
List the matter on August the 1st, 2025. The learned counsel for the petitioner instructions would submit that 10 lakhs would be refunded by the said date. And the remainder 4 lakhs and would make submissions with regard to the remainder 4 lakhs. List the matter on 1st August. 14 lakhs, 10 lakhs be refunded by the said date. Manu yav kade? Neev yarige?
I have no role. Google is implicated, my lords. I really have no role to play.
You're all over, sir. ಏನು ಮಾಡಕ್ಕೆ?
But in fact, I may be deleted because.
ಬೇಡ ಇರ್ಲಿ. Well, Manu Kulkarni be there. Yes.
Stream.
Yes, Manin sir.
a simple suit for rendition of accounts by the legal representative of a deceased partner. An order is flouted with impunity, accounts are not shown. It's a statutory right vested in me under Section 9 of the Partnership Act. Now,
What is under challenge?
now what has happened is, we have, with whatever material we have, are trying to show the court, the presumption, the adverse presumption is that we have claimed.
Oh, this adverse.
Yes, yes. And now you cannot withhold accounts and then come and cross-examine me.
Adverse inference only at the end.
That's right. The question posed by the court was wrong, with due respect, my lord. Question posed is not at what stage adverse inference. The question to be posed is, having withheld the accounts which is in your possession, can you now cross-examine the party who is in need of the accounts? I mean, that is like an abuse of the process of court. Now you're tying my hands up, and then you have been given a liberty now to question me with the little scant information I have to establish the profits.
Let's see. Yes, it's a legal issue that should be answered. Whether cross-examination would be dependent upon.
My lord, we'll argue this matter because in my respect.
No. Ashte, inneniದೆ?
Yes.
Really?
Yes.
I'll only
And
pass
there
on
is
my-
one judgment of, because we did some research.
Yes.
Of our High Court, it's a judgment of Justice Adananda Swami on what adverse, we filed it with a memo, paragraphs 11 and 12.
It's here, you have given it.
No, I don't think it's on.
Oh,
the
yeah,
record.
not, this is something is,
One we found yesterday. Paragraphs 11 and 12.
this is by the respondent, sorry.
Yes. Paragraphs 11 and 12 would cover the position in law.
Para 11 and 12 is.
That's right. And then the general proposition in prestige lights.
Oh.
That, I mean,
yes.
That is paragraphs 24 and 26.
Yes, counsel.
Well, it's the para number 12 is not applicable. Malas. I have produced two judgments, Ibrahimuddin Malas, on the point, which says that when the adverse inference has to be taken, that is after the trial. And one
Why
more.
have you given my judgment?
Malas, that I'm just producing. Malas, that was a judgment wherein my lords has taken a view that.
No, it's here. But why have you given it?
Malas, that is in the criminal.
That is 143, yes, sir. 138 proceedings.
I'm giving the separate. set of
Adverse
judgments.
inference will be drawn. Anta.
No. My lords has said that adverse inference will be drawn, but the right to cross-examination cannot be taken away.
So that will answer, no problem. He
have now
also has a point, will answer it.
Please,
Legal issue.
Now I have produced Ibrahimuddin Malats.
Anything else, Pani?
Ibrahimuddin has been dealt with by the court, but he's ignored what Ibrahimuddin says. My lord, may kindly read the extract in the judgment itself.
Ibrahimuddin.
Yes, and the court ignores it.
Ah.
At, my lord, at paragraph 10 of the judgment, the learned commercial court refers to the judgment, but ignores what the judgment says in extract. Kindly see, my lord has that impugned order, page
yes.
35 of the running
That's
page.
cited there.
They have cited,
Yes,
but he
yes.
ignores the principle.
I have cited that judgment.
Yes,
Let's see.
but it is in my favor.
It says that after the trial, the adverse inference has to be taken.
We'll answer it, yes.
Because he has produced evidence, I have to cross-examine them. Otherwise, his evidence also goes.
Heard, reserved.
I have produced one more judgment of the Bombay High Court,
Yes,
which
we'll
says
see.
that once the evidence is produced, the cross-examination has to be taken, please.
What's the
Matters
next-
on
what is the
Wednesday,
next
we'll
date?
inform the court that it is reserved.
Yes, that's enough.
Grateful.
23rd, it's posted.
Heard so and so, reserved. Yes, next.
Petition in this case. Identified this petition, my lord.
Chief Secretary ಯಾಕೆ GMCPC ಲಿ?
Trial court ಅಲ್ಲಿ party ಮಾಡಿದ. Government, DC is the.
ಏನು, what is the order and challenge?
The trial court granted status quo order, my lord. Directed both the parties to maintain status quo. Because I am produced the photographs to show that the construction is going on.
ಏನಾಗಿದೆ
Within
ಹೇಳಿ?
2 years, in 2 days, my lord, after filing the defendants advance the case, advance the case and file the return statement. The trial court vacated the status quo without considering my application under 39 rule 1 and 2, my lord. My lord, the annexure K for a moment, last week, kindly see page number 7.
Appeal ಹಾಕಿ.
Application is still pending. Annexure K.
Where is the order? Application is still pending.
Application is still pending.
Where is the order, impugned order for?
Please. Page number 86, my lord.
86? Where is the order granting you injunction?
That is in page number 50, my lord. Typed copy is 50.
ಇದ್ಯಾವ್ದು ಹೈ ಈ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಯಾವ್ದು ಹಾಕಿದ್ದೀರಾ 17/20/25 ಏನದು
Annexure K, my lord. The Annexure K, your lordship may kindly see. My lord, the deputy commissioner reserved this land, my land, for the village quarter, my lord. My lord, without that is without hearing me, they passed the said order.
that is also stayed.
That is also stayed. On the basis of said order, my lord, the respondents are making construction in my property, my lord. And
ಅಲ್ಲ ಅದು ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ ಈಗ
stay agide.
ಯು ಆರ್ ದಿ petitioner there.
I am the petitioner there. Your lordship may kindly see.
ಈಗ
This order is
order
put before
ಕೊಡಿ.
the trial court.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕೊಡಿ
Trial
ಹೇಳಿ.
court, my lord, page number 86, my lord. The trial court initially records that, my lord, all the written statement and objection filed with
On
respondents.
hearing both sides, peruse the documents, produce both sides, photo, status quo order is vacated.
Okay. My
ಅಲ್ಲ
lord,
ಫಸ್ಟ್ ಕೊಟ್ಟಿದ್ದು ಎಲ್ಲಿದೆ ಸರ್
first quoted page number 50, my lord.
ಅದು ಕೇಳ್ತಾ ಇದೀನಿ.
Typed copy, page number 50. As to avoid multiplicity of proceedings, status quo is necessary to further proceedings on perusal of the photo. Both the parties are directed to maintain the social property till filing of the objections. For objection, WS. For objection, WS posted to 24/7, my lord. But the respondents, the defendants advanced it case to 8/7. And
The petitioner, the plaintiff is before this court, calling in question an order of the concerned court vacating the order of status quo that was granted at the time of issuance of notice to the defendant. It transpires that the deputy commissioner had cancelled ಏನ್ ಆರ್ಡರ್ ಆಗಿತ್ತು
Annexure K, my lord. Reserve my land, my lord, for
the deputy commissioner had passed certain orders detrimental to the interests of the petitioner, which comes to be challenged by the petitioner before this court in writ petition 18404 of 2025. Initially, the first time stay kotra, the coordinate bench passes the following order, page 82-83. Notwithstanding the interim order granted, the concerned court records that there is no stay granted by the coordinate bench, and on the ground that there is no stay granted, the deputy commissioner has passed the aforesaid order, vacates the status quo order that was in subsistence as on that day. Prima facie, the concerned court has lost sight of the fact that the interim order is granted by the coordinate bench, as the operation and execution of the order challenged therein was stayed till the next date of hearing. In that light, the parties to maintain status quo till the next date of hearing. Emergent notice to the respondent returnable by the 6th. The petitioner is also at liberty to serve on the counsel who represents the respondent in the trial proceedings.
may start seek for handler.
ಕೊಡಿ. Yes, next.
Admission. Sitting.
My lord, this is the third time 482 petition has been filed in the
Wait,
same
sir.
crime.
One moment. ಏನಿದು?
My lord, I had filed a petition to quashment. Now the de facto complainant has filed 67 pages of objection. I had to take note of it.
ಅಲ್ಲ, earlier two complaints ಏನಾಯ್ತು?
This still pending.
Still pending? Which petitions are those?
One is 3870.
Number ಕೊಡು ನಿಮಿಷ. WP
3870.
ಆಮೇಲೆ
of 22.
ಆಮೇಲೆ
The other one is handling by the other counsel.
ಈ ಹ್ಯಾಂಡ್ಲಿಂಗ್ ಇದು ಕೊಡಿ, ನಂಬರ್ ಕೊಡಿ ಅಷ್ಟೇ.
ಅಲ್ಲ ಅದು
ಎಸ್ ರವಿಕುಮಾರ್, ನಂಬರ್ ಇನ್ನೊಂದು
My lord,
ಎರಡನೇ 482 ಯಾವುದು?
ಅಲ್ಲ ಇದ್ರಲ್ಲೇ I have attached it here itself.
ಅದು ಯಾವುದು ಅಂತ ಹೇಳಿ.
Page number 39. my lord. Page number 39 and 56.
ಒಂದ್ ನಿಮಿಷ. 39 ಯಾವುದು? ಡಿಸ್ಪೋಸ್ ಆಗಿರೋ ಮ್ಯಾಟ್ರಾ?
ಹೌದು.
ಪೆಂಡಿಂಗ್ ಇರೋದು ಎಷ್ಟಿದೆ?
ಪೆಂಡಿಂಗ್ ಯಾವುದಿಲ್ಲ ಸ್ವಾಮಿ. This amount
to
one
ನಿಮಿಷ ಸರ್. 3870 ಏನು?
3870 the other petition.
ಅದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, still pending.
ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
That is on the IA.
ಒಂದ್ ನಿಮಿಷ ಸರ್.
Not, it is an independent thing. It is not an IA at all.
Wait. Tag this petition along with WP 3870 of 2022 The learned counsel for the petitioner submits that the respondent party in person has now raised his statement of objections, has now served a copy of his statement of objections and would want to file would want to go through the same and make his submissions. List the matter on 24th. Submissions be made on the said date. Next.
My lord, this case has nothing to do with that.
This is the third answer.
ಸ್ವಾಮಿ ಎರಡು ಪೆಟಿಷನ್ ಆಗ್ಲೇ ಫೈಲ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
ಟ್ಯಾಗ್ ಬಿಟ್ಬಿಡಿ 24th.
Both the petition 482 petitions were rejected.
Dismissed.
For other reasons.
Whatever reason it was disposed, this is the third time he is filing.
Same cause of action.
I'll file my
Same
objection.
cause of action hakirada ide.
Yes.
My lord, anyhow he has given, he has submitted his objections. I'll file my objection.
Wait.
Supreme Court says that.
Don't go to Supreme Court.
My lord, Allah, it is abuse of process.
Hold what you submit. Wait. Which is the
page number 39, my lord.
Of your objections.
Yes. 39, annexure D.
What was the challenge? PCR. ಇನ್ನೊಂದು ಯಾವುದು?
ಇನ್ನೊಂದು 56 my lord, ನೀವೇ ಪಾಸ್ ಮಾಡಿರೋದು.
ಒಂದು ನಿಮಿಷ.
Page number 56.
One moment.
Annexure F.
One moment, sir.
Yes.
Supreme Court ಯಾವ್ದು ಹೋಗಿದ್ದು?
My lord, Allah, Supreme Court says that repeated 482 petitions amounts to abuse of process and also criminal contempt. My lord,
ಈ ಸೆಕೆಂಡ್ ಪೆಟಿಷನ್ ವಿಡ್ರಾ ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ, ಅದು ಎಫ್ಲೆಕ್ಸ್ ಆಫ್ ಟೈಮ್ ಗೆ ಅದ್ರ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು. ಅದು
ಎಫ್ಲೆಕ್ಸ್ ಆಫ್ ಟೈಮ್ ಗೆ ಯಾಕೆ?
ಇಲ್ಲಿ ಬಂದ್ರಿ ನೋಡಿ.
ಕಮ್ ಟು ದಿ, ನೀವು ಒಂದ್ ಸ್ವಲ್ಪ ಸುಮ್ನೆ ಇದ್ರೆ ಕೂತ್ಕೊಳ್ಳಿ. Sit down.
My lord, the order portion I'll read out.
1 minute, leave it. First petition, come to page 40.
13 and 40, yes. Yes, my lord.
FIR is challenged. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿತ್ತು ಆವಾಗ?
One second, my lord. It was at the stage of PCR only.
1 minute.
It was not special CC at that time.
Correct. All right. One is dismissed. When did the charge sheet come about?
there was no charge sheet, my lord. The
Either
police
trial-
filed
Is it PCR?
PCR, that 204 route, yes.
156 of 3L refer ಆಗಿತ್ತು. Police filed
B report.
B report.
B report is rejected and cognizance is taken.
Yes,
Special CC is registered.
yes. I've submitted 60, more than 60 documents, including electronic.
Wait. Yes, sir.
Anyhow, he has given.
Anyhow,
My lord, kindly listen to me. He has filed detailed objection. I'll come to this honorable court with my detailed objection to that effect.
there is no
Rejoinder.
there is no
Rejoinder.
concept of rejoinder here, sir. Criminal petition is
My lord, kindly look
writ
at,
petition alla.
well, I pray for some time.
That I will give till 24th ಅಷ್ಟೇ. List on 24th for admission. Stay ಇದೆಯಾ ಇಲ್ಲಿ?
Stay there, persisting.
ಸಮಯ 2 ವರ್ಷದಿಂದ ಸ್ಟೇ ಇದೆ.
ಸುಮ್ಮನೆ ಇದ್ರೆ ಸರ್. ಎಸ್. (20/7, 2024). The learned counsel appearing for the petitioner submits that copy of the statement of objections is served upon him just now. Would seek a week's time to go through the same and make his submissions. List on 24th. Admission. Entry order subsisting would continue till the next date of hearing.
My lord, statement of objections file ಮಾಡಿದೀನಿ record.
The party in person files a statement of objections, the same is taken on record. ಆಮೇಲೆ ಇದು ಬರೀರಿ. Yes, next.
I appear for the respond number 2 to 6, my lord.
For the
One number
petitioner,
3,
my lord. I was respondent was supposed to file objections, my lord.
I'll file it on the next date, my lord, for the respond. There's no objection.
My lord, I only want to bring to your notice that already more than 3 weeks' time has been granted, my lord.
The learned counsel seeks time, yet again to file his statement of objections. This,
First time, my lord. I think on the last date I'd undertaken to file my wakalat.
Oh,
Any which ways, my lord, I'll file my
anyway,
statement of
the learned counsel, ಸುಮ್ನೆ ಹೇಳ್ಬೇಡಿ. The learned counsel for the respondent seeks time to file statement of objections. List the matter on 25th beda. List the matter on 1st August. Objections, if any, by then interim order
3rd or
subsisting.
4th August, my lord, if I may suggest.
First, only Fridays, yes. Interim order subsisting will continue. Next.
There's no interim order.
No interim order. That will continue, yes.
20.
Petitioner will. Sought for the quashing of the entire proceedings, my lord, instead by the second respondent, first respondent, on the basis of the complaint lodged by the second respondent, my lord. Initially, my lord, the police have, the complaint was filed the complaint before the.
Will continue at 2:30. Yes.
One number submission, my lords.
I'll just call the list. Within 2:30 again.
Hearing on,
Yes.
hearing on IA 21.
Short point, my lord, counterclaim, counterclaim.
My lord, it's a short point. Two judgments, my lord, last time.
Now, what is under challenge, sir?
Sir, the order passed by the learned judge rejecting my counterclaim on the ground that the pre-institution.
Rejecting your counterclaim?
Yes, my lord, entire counterclaim is rejected.
Why?
He says the pre-institution mediation, which is mandatory for a suit, is also mandatory for a counterclaim also.
Counterclaim rejected ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಮಾಡಿದ್ದಾರೆ. ನಾನು 1 lakh rupees court fee have paid. ನಾನು counterclaim ಕೂಡ ಹಾಕಿಲ್ಲ. And my lord, even with regard to one point, wherein my lord, even as far as the suit is concerned also, the Honorable Supreme Court is also seized of the matter wherein Supreme Court is considering whether, even in a suit, in absence of pre-institution mediation, whether the matter could be kept in abeyance and could be sent to the parties. Only one daily order, Lordship may see that. Even that is also under consideration.
I have relied on that, sir.
Please. Now, my lord, my only difficulty
I
is this.
relied on that in the 12A where pre-institution mediation is not necessary if it is already done
Yes,
in a collateral proceeding.
Yes, in the same proceedings between the same parties. One PM was initially done. I participated, my lord, and it was a failure. Now, along with the written statement, my lord, I filed my counter.
What new you will mediate? ನಿಮ್ದ್ರಲ್ಲಿ ಆಗೋಗಿದೆಯಲ್ಲ
My
mediation.
lords, what has happened is simple. There are two parts for this present suit, my lords. One was with respect to eviction as well as arrears of rent. The other, my lords, they claim for recovery of their security deposit.
That's on merit of the matter.
I understand, my lords.
It is only on rejection of counterclaim on the score that 12A is not complied.
True, my lords.
Correct.
True, my lords. That apart, whether they're entitled to receive the entire 27 lakhs, my lords, has to be looked into.
ಅದು ಕೌಂಟರ್ ಕ್ಲೈಮ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ.
ಮಾಡ್ಲಿ,
ಈಗ
but at least-
issue ಇರೋದು ಅಷ್ಟೇ.
Please,
Don't
my lords.
expand the scope of this petition.
Please, my lords.
Now the issue is his counter claim is rejected. On what ground? That it is not preceded by compliance with 12A.
12A.
Whether
Please, my lords.
12A is necessary for counter claim or not is the only answer that is
Yes,
to be
my lords,
given.
it is.
Whether he has tried to receive, not receive,
I'll restrict myself, my lords. If that is the case, my lords may kindly.
Delhi
peruse-
High Court judgment could.
Yes, my lords.
And two judgments that I gave,
Right, sir.
latest ones.
This is the first decision, my lords, laid down by in this country, my lords. This is the
Country.
Honorable High Court of Delhi.
This is SEC ಇದೆ.
Either, my lords. The same thing, the parties had filed an SLP before the Honorable Apex
Correct.
Court.
Apex Court has
Yes, my
rejected
lords.
it. In limine.
In limine. Yes, my lords. The same thing, if my lords may kindly peruse, the ambit of such kind of an order will also be looked into, my lords, in the different proceedings.
Hmm.
If I may bring to my Lord's attention to page number 10,
Hmm.
the Honorable Apex Court's decision, my Lords.
Hmm.
Para number 30. They have referred the other decisions, my Lord. But to be precise, this paragraph holds good, my Lords.
Hmm.
If I may be permitted to read, my Lords.
Hmm.
Please. Further, while explaining the position that emerges on the grant of leave to the appeal by this court, it was observed once leave petition has been granted, the doors for the exercise of appellate jurisdiction of this court has been let open. The order impugned before the Supreme Court becomes an order appealed against. Any order passed thereafter would be an appellate order and would attract the applicability of doctrine of merger. It would not make a difference whether the order is one of the reversal or of modification or of dismissal, affirming the order appealed against. My Lord, the last sentence. It would also not make a difference if the order is a speaking or a non-speaking one, my Lords. It would still.
Come to para 34, sir.
Please, my Lords.
There, in the second appeal, the order was passed by this court. Therefore, the doctrine of merger had already taken place with regard to the order and decree that is affirmed in the RSA.
True, my Lords.
That went to the Supreme Court.
True, my Lords.
Supreme Court dismissed it. But there is already a merger here. It will not make any difference. Where is the merger here?
The merger here, my Lords, the order, if my Lords may kindly peruse, again at para number 30, my Lords.
Sir, Kode, Kunay Ahmad, all that we are aware.
Yes, my Lords. The order which was passed already by the Honorable High Court at Delhi was challenged before the Honorable Apex Court, my Lords.
Oh, sir.
That order, my Lords, that I'm referring to. I understand, my Lords. Wherein once an order is already passed by the Honorable High Court at Delhi, my Lords, the said appeal which was filed before the Honorable Apex Court and the same was dismissed, my Lords.
No, that's why I'm telling.
Please, my Lord.
What else do you mediate now? You already mediated for 3 months under 12A when it was at the stage of the
I
suit.
agree, my Lords.
Now he registers his counterclaim.
Please, my Lords.
Why should the parties be sent again, all over again?
What happens, my Lords? Apart
What happens? ಅದರಲ್ಲಿ ಇನ್ನು 2 ವರ್ಷ ನಡೆಯುತ್ತೆ.
In fact, I'm the plaintiff, my Lords, in the present suit.
The counterclaim will now, the problem has come after the counterclaim. You are safe till now.
No, my Lords. What had happened? There was one more suit pending before the said parties, my Lord, with respect to injunction. That, my Lords, is also before the same honorable trial court. When all the suits are already pending, the question of counterclaim does not arise in the first instance. Even otherwise, even if it arises, my Lord, they'll have to go through this procedure.
I'll dictate in the afternoon.
Please, my Lords. Please. Because Order 8, Rule 6A, Sub-Rule 4, my Lords, clearly says the aspect of a counterclaim should be taken along with that of a plaint.
No problem. Counterclaim
Please, my
is a separate suit by itself.
Please, my Lords.
No worries about it. Between the same parties, twice over 12A will answer.
Please. It was only once, my Lord, but please. Please, correct.
Yes. Actually, that's all the issue here.
Please, my Lord, that's a short point.
And then time for lunch. Cover it.
My Lord, I'm moving a memo.
My Lord, one humble submission before your Lordship.
My Lord, serial number 22, my Lord. Sorry, 23, my Lord. The Advocate Clerks Association. my Lord.
Yes. Yes, Jafar?
Yes, my Lord. 23. The Bar Council has to answer. I am told the
Murthy, sir. ಎಲ್ಲ ಹೇಳಿ ಪರವಾಗಿಲ್ಲ. ಏನದು ಆಯ್ತು ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ. You have some other work ಮಧ್ಯಾಹ್ನ.
My Lord, one submission, my lords.
ನೀವಿದ್ದೀರಾ ವೇಟ್ ಸರ್ ಒಂದು ನಿಮಿಷ. ಧರಣೇಶ್ ಸಾಯಂಕಾಲ ಬರುತ್ತೆ.
Please, my lords. Why is it got urgent because of want of your Lordship's judgment?
ಸಾಯಂಕಾಲ sir. Yes.
Please.
Just seek notes, 2 weeks accommodation in so far this particular case is concerned. For my answer, notes of the submission of a memo, notes we have written notes we have communicated to various bar councils throughout the state, including bar council of Supreme Court.
Time ಬೇಕಾ?
Time ಬೇಕಾ? ಯಾಕಂದ್ರೆ ಅವರಲ್ಲಿ what is the basis notes for coming to such a conclusion?
ಅಲ್ಲ, then I'll look into it and then grant time if it is grantable. Yes. You come at 3:30. Yes. ಅಷ್ಟಲ್ಲಿ ಬೇರೆ ಕೆಲಸ ಇದೆ.
My Lord, I may.
ಒಂದು ನಿಮಿಷ ವಸಂತ್ ಸರ್ ಒಂದು ನಿಮಿಷ.
Petition 3078 has reached the stage of settlement.
ಯಾವುದು ಟೌನ್ ಪ್ಲಾನಿಂಗ್? ಇನ್ನೊಂದು
ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ 17A
ಆಯ್ತು ಕೊಡಿ,
ಮಂಡೇ
ಮಂಡೆಗೆ ಸೆಟಲ್ಮೆಂಟ್ಗೆ ಅಂತ ಹಾಕಿ.
2 days ago ಮೆಮೊ ಲಿಸ್ಟ್ ಆಗಬೇಕು ಅಂತ ಹೇಳಿ ಲಿಸ್ಟ್ ಆಗಿ
ಇವತ್ತು ಮಂಡೆಗೆ ಬರುತ್ತೆ ಕೊಡಿ.
ನಾಳೆನೇ ಜಡ್ಜ್ಮೆಂಟ್ ಪೋಸ್ಟ್ ಆಗಬೇಕು.
ಆಯ್ತು, ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಕೊಡಿ. ಬಟ್ ನೀವು ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಬೇಕಲ್ಲ ಹೋಗಿ. ಎಸ್. ಕೊಡಿ ಟ್ರಾನ್ಸ್ಫರ್. ಎಸ್, ಗಿವ್ ಇಟ್. ಗಿವ್ ಇಟ್.
One matter, end of the list.
ಕೊಡಿ
Transfer matter, end of.
ಕೊಡಿ ಕೊಡಿ ಕೊಡಿ.
My lord, a memo morning I given the memo. My lord, my site is being proposed to be accident on 23rd by BDA.
21ಕ್ಕೆ ಬರ್ಬೋದಲ್ಲ?
21ಕ್ಕೆ ಬರ್ಬೋದು.
ಬರುತ್ತೆ ಬಿಡಿ.
ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ, ಮೆಮೊ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಕೊಟ್ಟಿದ್ದೀರಾ, 21ಕ್ಕೆ ಬರುತ್ತೆ.
May I seek indulgence of this, my lords, my lords? I have only one request, my lords.
Don't mention. Why do you want? Madhyana.
I have one submission.
Lordship, kindly, my lord, I filed a memo for BDA matter, my lord, set of disposition, my lord. Memo is not reached the registry, my lord.
FR ನಂಬರ್ ಇದೆಯಾ?
FR ನಂಬರ್ ಇದೆ.
ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಹೋಗಿರುತ್ತೆ.
ಇಲ್ಲ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಅದಕ್ಕೋಸ್ಕರ.
No, court officer would have sent everything. Don't. ಮಂಡೆ ಏನು?
Section 10 application dismiss ಆಗಿದೆ.
So what? ಅದರಲ್ಲಿ ಏನಾಗಲ್ಲ ಬಿಡಿ. ಕೊಡಿ ನೋಡಿ, ಕೊಡಿ.
I have one submission, my lords.
ಒಂದ್ ನಿಮಿಷ. ನಿಮ್ದೇನಾ? ಏನು ಹೇಳಿ.
My lords, in pursuance of my lords, your lordship's order, in that matter, ADLR was supposed to be, my lords, appointed as court commissioner. ತಾವು clear cut ಆಗಿ ಹೇಳಿದಿರಿ. But instead, my lords, the trial court has appointed Tahsildar.
Being
spoken to, it was clarified ADLR has to conduct this survey.
Correct.
That, however, the plaintiff made a memo to appoint Tahsildar. We objected and we filed an application to seeking modification. ADLR is the right person with equipment and expertise. However, the court has ordered for Tahsildar and 21st Monday ge 12 ಗಂಟೆಗೆ.
End of the list. End of the list.
End of the list.
ಮಾಡೋದಲ್ಲ, you should get it posted. Yes.
Please, ma'am. Please, ma'am.
Yes.
ವಾಯ್ಸ್ ಹೋಗ್ತಾ ಇಲ್ಲ.
ಮೆಮೊಗಳು ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಟಿದ್ವಿ.
ನಾನು ಇಲ್ಲಿಂದ ಮೈಕ್ ಆನ್ ಆಗಿಲ್ಲ. ಮೈಕ್ ಇದು ಬರ್ತಾ ಇರಲಿಲ್ಲ, ಇಲ್ಲಿ ಆನ್ ಆಗಿದ್ದು.
End of the list, move now.
Serial number 2 ಏನಾದ್ರು ಹೇಳಿದ್ರೆ ಸರ್, serial number 2 ಇದನ್ನ ಸಿಟ್ಟಿಂಗ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ. ಇದೆ ಸಿಟ್ಟಿಂಗ್ ಇದೆ.
ಆಯ್ತು ಗೊತ್ತು, ನಾನು ನೋಡ್ತೀನಿ ಬಿಡಿ. ಯಾಕೆ ಟೈಮ್ ಬೇಡವಾ ಬರೆಯಕ್ ನಂಗೆ?
Hello? Hello, court officer. Hello? Hello, court officer? Court officer?
Sir?
Court officer? Court officer?
Sir, 3:15 ಗೆ sitting.
Okay, madam. Thank you.
ವಾಪಸ್ ಬನ್ನಿ ಅಂತ ಹೇಳ್ಬೇಕು.
ಬಂದಿಲ್ವಾ? ಅಲ್ವಾ? ಅಲ್ಲ, have you challenged any civil court order? ಹಾ ಹಾ GMA ಆಗತ್ತೆ. ಇಲ್ಲ, ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ, ಅಲ್ಲಿಗೆ ಹೋಗ್ಲಿ.
Lord, I'm Casey Butt, if you remember.
I don't remember.
In that earlier atrocity case, you were there.
Earlier atrocity?
Yeah, you had.
What is earlier
given a
atrocity
very
and
good
now present atrocity?
No, now it's serial number 44 to RFA 2018 from the other court.
RFA, that is the other court. I'm not taking that.
Can an early date be given?
No, you can ask that court on Monday.
On Monday, is it?
Yes,
Oh,
yes.
it is
No,
function.
you can ask that court on Monday.
Okay, okay.
Milord, serial number 33, matter settled, parties have come.
Second list.
Second list, serial number 33.
What is the issue?
RFA matter has been settled.
RFA na?
RFA 589 of 2008, Milord.
ಆಯ್ತು, ಅದು ನೋಡೋಣ, wait.
No, make a request.
Second.
Let it go to the court.
ಅಲ್ಲ, ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ? ಅದು ಲಿಸ್ಟೇ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗುತ್ತೆ ಅದು. ದಟ್ಸ್ ದಿ ಆಫೀಸ್
ಹೋಗ್ಲಿ ಅಂತ ಅಷ್ಟೇ.
ಇವತ್ತು ಅಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಬೇಕು, ಆ ಕೋರ್ಟ್ಗೆ ನಾವೇನ್ ಕಳ್ಸಕ್ಕಾಗತ್ತೆ?
ಇಲ್ಲ, ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಕಳಿಸಿ ಅಂದ್ರೆ ಆಗುತ್ತೆ.
ಸೀನಿಯರ್ ಜಡ್ಜ್ ಅವರು GM
ಇಲ್ಲ, ಬೋರ್ಡ್ ಬ್ರಾಂಚ್
ಬ್ರಾಂಚ್ಗೆ ಹೇಳ್ತಾರೆ. ಎಸ್,
one submission for the end of the list.
ಲಿಸ್ಟ್ ಎಂಡ್ ಡೇ ಎಂಡ್ ಆಗಕ್ಕೆ ಬಂತು. ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
No, madam, ಅದರಲ್ಲಿ ಸೋಮವಾರದಿಂದ ಇಂಟರ್ವ್ಯೂ ಫಾರ್ ದ ಫಸ್ಟ್
ಗೋಫಾ
ಪ್ಲಸ್ ಮಂಡೆಯಿಂದ ಫಾರ್ ದ ಪೋಸ್ಟ್ ಆಫ್ ಟೈಪಿಸ್ಟ್ ಮೇಲರ್ ಇಂಟರ್ವ್ಯೂಸ್ ಕಮೆನ್ಸಿಂಗ್ ಮೇಲರ್. Petitioner is here in scored more marks than the candidate selected for the list.
ಏನ್ ಬೇಕು ಸರ್? ಸೋಮವಾರ ಆಗ್ಬೋದಾ?
ಸೋಮವಾರ ಇದು ಕಮೆನ್ಸ್ ಆಗುತ್ತೆ ಮೇಡಮ್. ಇಂಟರ್ವ್ಯೂ
ಏನ್ ಕಮೆನ್ಸ್ ಆಗುತ್ತೆ?
ಟೈಪಿಸ್ಟ್ ಪೋಸ್ಟ್ ಗೆ ಇಂಟರ್ವ್ಯೂ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಾ ಇದೆ ಸೋಮವಾರ.
ಆ ಕೋರ್ಟ್ ದ 8th ಕೋರ್ಟ್ ದ ಯಾವತ್ ಕಮೆನ್ಸ್ ಆಗುತ್ತೆ ಇಂಟರ್ವ್ಯೂ?
ಸೋಮವಾರದಿಂದ 5 ದಿವಸ ಇದೆ.
ಸೋಮವಾರ ಮೂವ್ ಮಾಡ್ಬೋದಲ್ಲ ಮತ್ತೆ ಬೆಳಗ್ಗೆ 2:30ಗೆ?
ಸೋಮವಾರ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಾ ಇದೆಯಲ್ಲ, ಅದಕ್ಕೆ ರಿಕ್ವೆಸ್ಟ್ ಮೇಡಮ್.
ಬಟ್ ಈಗ ಎಲ್ಲಾಗುತ್ತೆ? ನೀವು ಮಧ್ಯಾಹ್ನ ಹೇಳಿದ್ರೆ ನಾನು ಏನಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಬಂದೆ, ನಾನು ಲೇಟ್ ಆಗಿ. ಎಸ್
ಮೈ ಲಾರ್ಡ್,
ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್
ಎಲ್ಲ ಸೋಮವಾರಕ್ಕೆ.
ಇವತ್ತೇ ಮೂವ್ ಮಾಡ್ಬೋದು.
ಸೋಮವಾರ ಆ ಕೋರ್ಟಲ್ಲಿ ಮೂವ್ ಮಾಡಿ.
ಸೋಮವಾರ
ನೀವು ಅದೇ ಮಾಡಿ ಬೆಳಗ್ಗೆ. ಅವ್ರಿಲ್ಲ ಅಂದ್ರೆ 2:30ಗೆ ನಾ ತಗೊಂತೀನಿ.
List number 2.
Serial number.
List number 2 ತಗೊಳ್ಳಿ.
Number 2, seal number 10, preliminary hearing.
Lordship, serial number 10 and 20.
My lords, serial number 1, my lords.
Wait. Other matters all next week.
Well, it's only a small submission in serial number 1, my lords.
Serial number.
Sir, ಎಲ್ಲ next week. Except preliminary hearing. Every day I'm doing that only. I will not take anything else.
Serial number 4,
ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಎಲ್ಲ 2 weeks ಅಂತ ಹೇಳಿದಾರಂತೆ. ಎಸ್,
ಎಲ್ಲಾರ್ಸ್ ಟು ಬಿ ಬ್ರಾಟ್
ಮೂವ್ ಮಾಡಿ ಎಲ್ಲ. ಇಂಟರ್ಮೋಟರ್ ಎಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. That will
number 4, my lordship. I am for the R3, my lord. I filing the undertaking to
my ವಕಾಲತ್ ಮಾತಾಡ್ಸಿ.
ಮಾಡಿ ಸರ್, ರಿಜಿಸ್ಟ್ರಿಲ್ ಮಾಡಿ, ಅಂಡರ್ಟೇಕಿಂಗ್ ಯಾಕೆ ಬೇಕು?
Please madam.
You file it.
2 weeks or so.
ಎಲ್ಲ after 2 weeks.
Serial number 22 ಮೇಡಮ್.
ಯಾವ ಲಿಸ್ಟ್?
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
ಹಾ,
ಡೇಟ್ ಕೊಟ್ರೆ ಬರುತ್ತಿಲ್ಲ ಬರೋದು.
ಇಲ್ಲ ಆ ಕೋರ್ಟ್ನೇ ಕೇಳಿ ಸರ್.
ಅಲ್ಲ ಅದು ಡೇಟ್ ಅಂತಾನೆ ಇದೆ. ಫಾರ್ ಡೇಟ್ ಅಂತ.
ಆ ಕೋರ್ಟ್ನೇ ಕೇಳಿ ಮತ್ತೆ ಡೇಟ್.
Serial number 29.
Next week
Lordship heard it a little bit. ಅದೇ that 4 days transfer. BWS
ಅಲ್ಲೇ ಕೇಳಿ ಸರ್. ಎರಡು ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ ಹೆಂಗೋ?
ಅದು ಸ್ಟೇ ಆಗಿದೆ.
ಅಲ್ಲ ಇದು ಆಗಿದೆ, ಇದನ್ನು ಮಾಡಿದ್ದೀನಿ.
ಇಲ್ಲ ಇದಾಗಿಲ್ಲ.
ನೋ ಇದನ್ನ ಐ ಸೆಡ್ ನಾಟ್ ಟು ಪ್ರೆಸಿಪಿಟೇಟ್ ಏನೋ ಮಾಡಿದ್ದೀನಿ.
ಅದು ಬೇರೆ.
ಅದು ಬೇರೆ. ಸೋಮವಾರ ಬರ್ತಾರಂತ ಅವ್ರನ್ನ ಅಲ್ಲಿ ಕೇಳಿ.
ಆಯ್ತು, ಮಂಡೆಗೆ ಟ್ಯೂಸ್ಡೇ ಅದೇನ್ ಶಾರ್ಟ್ ಪಾಯಿಂಟ್
ಅಲ್ಲೇ ಮೂವ್ ಮಾಡ್ಬಿಡಿ. ಬಿಕಾಸ್ ಬೇರೆ ಎಲ್ಲ ಹಂಗೆ ಮಾಡಿದ್ದೀನಿ. ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ನೋ ಪ್ರಾಬ್ಲಮ್. ಅದು ಸರ್ವಿಸ್ ತಾನೆ,
ಸರ್ವಿಸ್ ಪಾಯಿಂಟ್
ಟೇಕ್ಸ್ 1 minute ಅಷ್ಟೇ, ಬಟ್ ಎಲ್ಲ ತಗೋಬೇಕಾಗಿತ್ತು.
I was transferred within 1.5 years. Then
ಅದು ಗೊತ್ತು. 4 days ಅಲ್ಲಿ ಕ್ಯಾನ್ಸಲ್ ಆಯ್ತು, ಕ್ಯಾನ್ಸಲೇಷನ್ ಸ್ಟೇ ಆಗಿದೆ, ಕ್ಯಾನ್ಸಲ್ ಆದ್ಮೇಲೆ ನೀವು ವಾಪಸ್ ಹೋಗಿಲ್ಲ ಅಷ್ಟೇ. ವಿಲ್ ಸಿ. His contention is cancellation amounts to transfer.
But 4 days. ನಂದು 1.5 years within premature.
ಗೊತ್ತಾಯ್ತು. ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ 4 days also becomes transfer. ಅಲ್ಲ ಇದಾರೆ ನೋಡಿ, ಅವ್ರದೇ ಇರ್ಬೇಕು, ಸತೀಶ್ ದೇ ಇರ್ಬೇಕು ಅದು.
4 days before that he came to another position. 16th.
4 ದಿವಸದಲ್ಲಿ ಹೋಗಿ ಚೇಂಜ್ ಮಾಡ್ಸ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ? You appear to be very powerful in the government. ಅಲ್ಲ 1.5 ವರ್ಷ ಇದ್ದು ಅಲ್ಲ ಅವರು ಏನೋ ಮಾಡಿಸ್ಕೊಳ್ಳೋದ್ರಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ 4 ದಿನದಲ್ಲಿ ಮಾಡಿಸ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟು
4 days ಫಸ್ಟ್ ಇವ್ರು ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ ಇದು ಮಾಡಿದ್ರು. ಗೊತ್ತಾ? 16th ಎಲ್ಲೋ ಟೆಕ್ನಿಕಲ್ ಡೈರೆಕ್ಟರ್ ಪೊಸಿಷನ್ ಹಾಕಿದ್ರು.
ಅಲ್ಲ ಅದು ರೆಗ್ಯುಲರ್ ಆಗಿದ್ದಿದ್ರೆ ಅವ್ರಿಗೆ ಗೊತ್ತು ಏನಾಗ್ತಾ ಇತ್ತು ಅಂತ.
ಬಚಾವಾಗಿದೆ
ಅಷ್ಟೇ. ಇವೆಲ್ಲ ತುಂಬಾ ನೋಡ್ಬಿಟ್ಟಿದೀವಿ ನಾವು. 48 hours ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ಸ್ ಚೇಂಜ್ ಆಗುತ್ತೆ. ಏನು
ಕ್ಯಾನ್ಸಲ್ ಆಗುತ್ತೆ ಅಂತ ನಮ್ಗೆ ಗೊತ್ತು.
ಹೌದಾ, ಅದು ಗೊತ್ತು.
ಅವ್ರಿಗೆ ಇದು ಅವ್ರ ಕ್ಲೈಂಟ್ಗೆ ವಿ ಶುಡ್ acknowledge his prowess because within 10 days 3 times he has got it transferred.
Very powerful.
Before this he went to somebody else.
ಅಲ್ಲ ವೆರಿ ಪವರ್ಫುಲ್. ಎಸ್, ಅಲ್ಲೇ ಮೂವ್ ಮಾಡ್ಬಿಡಿ.
ಟ್ಯೂಸ್ಡೇ ಒಂದು ಡೇಟ್.
ಆ ಡೇಟ್ ಬೇಡ, ನೀವು ಮೂವ್ ಮಾಡ್ಬಿಡಿ. ಸಾಹೇಬ್ರು ಸೋಮವಾರ ಬರ್ತಾರಂತೆ.
ಅದೇ ನಮ್ ಡೇಟ್ ಒಂದು ಕೊಟ್ಟು.
ಅಲ್ಲ ಅವರೇ ಕೊಡ್ತಾರೆ, ಸೋಮವಾರ ಮೂವ್ ಮಾಡ್ಬಿಟ್ರೆ ಕೊಡ್ತಾರೆ.
ಅರ್ಜೆಂಟ್ ನಾನು ವರ್ಕಿಂಗ್ ಹೋಗ್ದಿರಾ ಇದೀನಿ.
ಅಲ್ಲೇ ಮೂವ್ ಮಾಡಿ.
Lord, list 1 serial
interim order man, 5 and 6.
ಲಿಸ್ಟ್ 1 ಅಲ್ಲ,
It's number 2 man.
ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡೋದೇ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Please.
Serial number 10
ಹೇಳಿದಾರಲ್ಲ, ಏನಿದು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್?
No, sorry my lord, on submission my lord. Sorry. Court may be directed to list on Monday. Sorry.
ಮಂಡೇ ತಗೊಳ್ಳೆ ಮೇಡಮ್.
Otherwise
ಅರ್ಜೆನ್ಸಿ ಇದೆ.
if possible my lord, end of the
ಕೊಡಿ, ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಕೊಡಿ ನೋಡೋಣ. ಬಂದ್ರೆ ಸರಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
Monday.
ಮತ್ತೆ FR ನಂಬರ್ ಎಲ್ಲಿ ಬರುತ್ತಪ್ಪ? 4 ಒಳಗೆ ಬರಲ್ಲ. ಸೋಮವಾರಕ್ಕೆ ಹಾಕ. ಮೆಮೊ ಹೋಗಿರುತ್ತೆ, ಎನಿವೇ ಯು ಕಂಪ್ಲೈ ಮಾಡಿ. ಎಸ್, ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಏನಿದೆ?
Preliminary hearing, serial number 10.
ಲಿಸ್ಟ್ ಮ್ಯಾಟರ್ 18/7 ಅಂದೆ.
Trace time madam.
Trace time.
Serial number 10.
Trace time grants all time. Yes. List after 2 weeks.
11.
Trace time grants time. List the matter after 2 weeks at the request of the counsel appearing for the petitioner.
Lord, in this matter, I've questioned the order at annexure A, my lord, page 18, wherein my request to lead evidence.
Madam, departmental inquiry ಅಲ್ಲಿ ಪ್ರತಿಯೊಂದು ಸ್ಟೇಜ್ ಅಲ್ಲೂ ಮತ್ತೆ ಇಂಟರ್ಫಿಯರ್ ಆಗಕ್ಕಾಗುತ್ತಾ? ಕ್ರಿಮಿನಲ್
Not only
GMCPC ತರ ಆಯ್ತಿದ್ದು.
No, my lord, the reason being I've at that earlier stage, I've clearly made an application stating that I will examine 3 witnesses, out of which I've examined 2 witnesses, my lord, and that all these witnesses are working in the very office of KRID.
ಈಗ ಏನ್ ಕೊಟ್ಟಿಲ್ಲ ನಿಮ್ಗೆ?
Permission ಕೊಟ್ಟಿಲ್ಲ. They've closed the stage, my lord, and they've proceeded for written arguments.
Where is your request and where is the rejection?
Please, my lord, annexure A, page 18, my lord.
Page 18.
Please. May I read out, my lord?
Yes.
Second para in the 28th sitting, 7.
ಮೇಲ್ಕಂಡ ದಾಖಲಾತಿಗಳು ಪ್ರತಿಗಳಿಸು ಒದಗಿಸಲು ಕೋರಿರುತ್ತಾರೆ. ಆಮೇಲೆ
1ನೇ ಆಪಾದಿತ ಅಧಿಕಾರಿ ಶ್ರೀ ಎಲ್ so and so ರವರು 2 ಅರ್ಜಿಗಳನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. 1ನೇ ಅರ್ಜಿನಲ್ಲಿ ವಿಚಾರಣೆ ಹಂತವನ್ನು ಹಿಂಪಡೆದು ಉಳಿದ ಸಾಕ್ಷಿಗಳನ್ನು ಕರೆಸಿ ವಿಚಾರಣೆ ಮಾಡಲು ಕಾಲಾವಕಾಶ ನೀಡಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ.
ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಕೇಳಿದ್ರಿ ಮೇಡಮ್?
At the serial numbers mentioned below, one is the attendance register extract, memo of works, then my lord, books of account for April, May, June 2017.
How is it relevant?
The reason being, if your lordship comes to the articles of charge issued at annexure E, my lord, page 45.
Why anta helbidi?
Lord, the main allegations is with regard to financial irregularities committed during the.
How is this attendance book relevant?
Because they are specifically told my request for 28 days of leave has been rejected and have not handed over the memo of works.
But the learned counsel appearing for the petitioner. The petitioner challenges the proceedings of a departmental inquiry instituted against him. The allegation that brings the petitioner at this juncture to the court is that the documents that the petitioner sought for in his defense during the said inquiry are denied on the score that the inquiry has already had 28 sittings and therefore the documents would not be given. Documents would not be given. In that, the learned counsel submits that the documents were relevant as the charge against the petitioner is, the defense of the petitioner is that he had applied for leave and was not, he had applied for leave. The allegation is that the leave stood cancelled.
28 days converted leave was cancelled.
The 28 days converted leave was cancelled. In the light of the entire issue revolving on the said documents, the documents ought to have been furnished to the petitioner by the inquiry officer. Who only on the score that it is getting delayed denies these documents. Therefore, there is prima facie violation of principles of natural justice. Thus there shall be an interim order of stay of the further inquiry till the next date of hearing. List the matter on 1st August. Respondent yaru?
KRIDL, my lord, if I may be
Yaru
permitted.
appear petitioner
Pavan sir appears.
Petitioner to serve set of papers upon counsel Shri Pavan Kumar.
Please.
ನೀವು one HCG
Formal party government.
notice ಕೊಡೋದು ಬೇಡವಾದರೆ
Please,
1 HCGP 2 Pavan Kumar.
Respondent number 3 is the other delinquent officer, my lord.
That leave it, don't worry. Yes.
Obliged.
ಅಷ್ಟೇ, ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ. ಅವ್ರು ಬಂದ ತಕ್ಷಣ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿ ಅಂತ 2 ದಿವಸದಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಕ್ಲೋಸ್
That
ಮಾಡಕ್ಕೆ.
is also even we want.
That is the only thing that should be done.
Please, my
It's
lord,
a temporary.
Fair opportunity.
Temporary reprieve.
Please, some breathing time so that once the documents. Tomorrow, once we suffer an order, my lord, then we can't take.
That's the best ground for you to set aside the order of penalty. Yes. Next.
12.
12.
Revishing.
Time ಬೇಕಾ? ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
ಬೇಡವಾ?
ಬೇಕು, ಸೀನಿಯರ್ ಹುಷಾರಿಲ್ಲ ಸ್ವಾಮಿ.
ಏನ್ ಫೈಲ್ ತೆಗೀರಿ.
ಫೈಲ್ ಸರ್ ಕಡೆ.
ಫೈಲು ಅವ್ರ ಹತ್ರನೇ ಇದೆಯಾ? ಯಾರ್ದೋ ಒಂದು ಫೈಲ್ ಇಸ್ಕೊಳ್ಳಿ ಮತ್ತೆ. ಫೈಲ್ ಇಲ್ದೆ ನಿಂತ್ಕೋಬಾರ್ದು, ತೊಗೊಳ್ಳಿ. ಯಾರ್ದು ಫೈಲ್ ಇಸ್ಕೊಳ್ಳಿ. ಇದೆಯಾ? ಆ ಫೈಲ್ ತೆಗಿಬೇಡಿ, ಪರವಾಗಿಲ್ಲ. ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ಸ್ ಮತ್ತೆ ಯಾಕೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ಮೇಡಮ್, ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ಸ್ ನೆನ್ನೆ ಆರ್ಡರ್ ಸೇಮ್ ಆರ್ಡರ್ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ. ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ಸ್ ನಿಮ್ ಸಾಹೇಬ್ರು ಮಾಡಿದ್ದಾರೆ ಸೇಮ್. ಎಸ್, ಈಗ ಫೈಲ್ ವಾಪಸ್ ಕೊಡಿ. ಯಾರ್ದು ಬಿಗ್ ಗ್ರೂಪ್ ಬೇಡ. ಸೆಟಲ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ.
33.
Discuss I'm for opinion, my lord.
ವಯಸ್ಸಾದನಿಗೆ both the parties are present.
Present.
ಏನದು?
Authorization ಐತೆ, respondent ಇಲ್ಲ.
Company.
The appellants are before this court, calling in question an order of the concerned court dated 15th December 2007, 2007 in OS 8468 of 1995. During the subsistence of this petition, the parties to the list have settled the dispute amongst themselves by drawing up certain terms of settlement. The petition of compromise filed under Order 23 Rule 3, read with 151 of the CPC, reads as follows. Madam, compromise petition. In the light of the settlement of the dispute between the parties, I deem it appropriate to close the suit by directing drawing up of a decree in terms of the compromise. The petitioners, in the light of the settlement arriving at between the parties, the petitioner, the plaintiff would become entitled to, the appellant would become entitled to the refund of court fee as obtaining under Section 69A of the Karnataka Court Fees and Suits Evaluation Act 1958. The 1958, which should be a refund of the entire court fee that is deposited by the appellant. Decree to be drawn according.
TD handed over.
ಅದರಲ್ಲಿ ಹೇಳಿದಿರಲ್ಲ ಕೊಡಿ. Yes.
Order sheet signature.
ಅಷ್ಟೇ ಮೇಡಮ್. ನೀವು ಕೊಡ್ರಿ. ಕೊಡ್ತಾರೆ. ಆ ಡಿಕ್ಟೇಷನ್ ಒಂದು ಕೊಡ್ತೀನಿ ನಾನು ಸುನಿಲ್ ಕುಮಾರ್ ತಗೊಳ್ಳಿ. ಅದಕ್ಕೆ ಮುಂಚೆ ಯಾವುದು?
Mode matters. Orders, seal number 1. Manu P. Kulkarni.
ಪಾಸ್ ಅವರಿಬ್ರು ಬರ್ಲಿ ತಾಳಿ ಸರ್ ಕ್ವಾಟ್ಲೆ ಕಿಚನ್.
Number 2, Vamshi Krishna C.
The petitioner, my lord, in this, the respondent was one of the partners of the petitioner firm. Personal risk due to mismanage on the allegation of mismanagement of the funds of the firm, our suit was filed.
All right. Why are you here? Recovery of 7 crores.
Please, my lord. My lord, the entire principal amount has been paid. The same by way of joint memo before this honorable court, the respondent has agreed.
Where?
Page number 33, my lord. 33. Learned counsel for the petitioner and respondent filed a joint memo reporting that the petitioner accused has paid the entire fine amount as ordered by the trial court. Even after receiving the entire principal amount, my lord, now he has sought to again in the execution petition to recover the entire principal amount.
The petitioner, the judgment debtor, is before the court calling in question the continuance of the execution proceedings against him, against the resort. The learned counsel would take this court through the order passed in a criminal revision petition, CRP 834 of 2022, in which the settlement between the parties and the receipt of the amount is recorded by the coordinate bench. The order reads as follows, page 33. Notwithstanding the same, the allegation now is that the respondent is pursuing the execution proceedings and the concerned court has not stalled it despite the order being brought to its notice. In that light, there shall be an interim order of stay as prayed for till the next date of hearing. Yes, next. Emergent notice, respond.
Preliminary hearing, seal number 3, Lakshmikant K.
For the petitioner, my lord. But in this case, my lord, I have challenged the impugned order 10 E, my lord. Filed IA number 9, my lord, under 26 rule 9, seeking appointment of court commissioner in a suit for injunction, my lord.
Injunction court commissioner ಏನ್ ಮಾಡ್ತಾರೆ ಸರ್?
Because my lord,
ಡ್ರ್ಯಾಗ್ ಮಾಡಕ್ ಬಿಟ್ಟು ಬೇರೆ ಏನ್ ಕೆಲಸ ಇದೆ?
They claim that, my lord, site number 77 and 37, my lord. May kindly see the.
You are the plaintiff.
I am the plaintiff.
ನಿಮ್ಗೆ ಎಲ್ಲಿದ್ದಾರೆ ಅಂತ ಎಲ್ಲಿದೆ ಅಂತ
So
ಗೊತ್ತಿಲ್ಲ
we are in the possession of the property.
ಬಿಡಿ
The
ಮತ್ತೆ what
defendant
court commissioner will come and say that you are in possession?
Defendant is, please.
ಯಾವಾಗ ಹಾಕಿದ್ರಿ ಅಪ್ಲಿಕೇಶನ್?
My lord, you have filed application, my lord. After the
ಅದು
evidence, my lord.
ಎವಿಡೆನ್ಸ್ ಸ್ಟೇಜ್.
Evidence ಆದ್ಮೇಲೆ, evidence ಎಲ್ಲ.
ಅದು ಆದ್ಮೇಲೆ ಬಿಡಿ ಬರೋದು ಇವೆಲ್ಲ. ಎಸ್, ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್?
On 4/3/25, my lord. Because, my lord, they are claiming that their property is 37 and 77, my lord.
Injunction only on the basis of documents. It's your burden to prove that you are in possession. Court commissioner ಬಂದು ಏನ್ ಮಾಡಲ್ಲ.
Let the court
ಸುಮ್ನೆ ಇನ್ನೊಂದು 6 ತಿಂಗಳು ನಡೆಯುತ್ತೆ ಇಲ್ಲೇ court commissioner. Nothing else. Anything else?
Only that point, my lord. Tomorrow is handover.
Only that point.
Please.
ನಾಳೆ ಏನಿದೆ?
It is listed for judgment.
Let the judgment be pronounced. Appeal ಹಾಕೊಳ್ಳಿ.
Argument ಗೆ opportunity they have not given.
Argument ಗೆ opportunity ಎಲ್ಲ ಕೊಟ್ಟಿದಾರಲ್ಲ ಸರ್.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
ಬರೀ 26(9) ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನ್ ಬೇಕು?
26(9) ಮೇಲೆ ಆಯ್ತು, ಆರ್ಡರ್ ಆದ್ಮೇಲೆ they are not provided opportunity.
No.
We have filed a petition and day to day, my lord.
ಕ್ಯಾ ವಿನಯ್. ಎಸ್. ಅಷ್ಟೇನಾ?
Only that.
26(9) unless it is necessary. Injunction suit alladu ಬೇಕೇ ಆಗಲ್ಲ.
Because
burden is on you to prove, sir. You don't need the commissioner to fetch evidence for you and come and give. Anything else? The petitioner is before this court calling in question an order dated 2/6/2025 passed in OS 730 of 2025, rejecting an application filed under in IA 17 of 2025, filed seeking appointment of a court commissioner under Order 26 Rule 9 of the CPC. The petition The petitioner is the plaintiff, institutes a suit for injunction in the aforesaid OS. The issue in the list is not with regard to the merit of the matter before the concerned court. Before the concerned court, after the conclusion of the evidence, the petitioner comes up with an application -IA 17 under Order 26 Rule 9 seeking appointment of a court commissioner. The concerned court rejects the application on the score that it is only a ruse to drag the proceedings. The order of the concerned court reads as follows. Page 39 to 40. The concerned court holds that the commissioner cannot be appointed to collect evidence in a suit for injunction. It is for the petitioner to prove possession and not take the assistance of a commissioner to fetch evidence. There is the reason so rendered by the concerned court is in tune with law, and not tune with law. Finding no perversity in the order, this court would not entertain the petition under Article 227 of the Constitution of India to obliterate the same. Finding no merit, petition stands rejected.
Number 4, Kirti Krishna Reddy.
Guest lecturer.
No, my lord, that BDA allotment alternate.
BDA, sorry.
Please, my lord.
Specific. Yes, madam.
The preliminary notification of the year 2000.
Arkavati layout.
Please, my lord.
E-auction yavattu nim property na?
So, my lord, now the original land owner was landowners, my lord, the land was acquired to another survey number was identified. In that site number 103 is now the present petitioner it's his.
Site number 103.
1003.
1003.
Please. Now, my lord, they say that we've given representations, no response, have not been put in physical possession. They say sites are not available. Now it's come to my.
Where is your allotment letter? You have sought so many sites.
My lord?
There are so many sites in the prayer.
That is with respect to the e-auction, my lord, with respect
which
to
is yours, madam?
My lord, in this, now the site that site, the 1033 is not part of this. But paper allotment, my lord, it was given. I'm not been put in physical possession is my concern.
No. How are you seeking quashing of e-notification issued insofar as it pertains to including sites so and so? Are these your sites?
No, but these are the alternate sites that are available. alternate side.
How many
then
sites you want?
One.
So one saku, ಎಲ್ಲದಕ್ಕೂ ಯಾಕೆ?
Let that observation be.
Which best of the lot ಯಾವುದು?
My lord.
Which is the best of the lot? We'll ask them to keep one.
Please, my lord. My lord.
ಅವ್ರಿಗೆ ಕೇಳಿ best of the lot ಯಾವುದು?
1058.
ಓ ಅದು ಚೆನ್ನಾಗಿದೆ ಅಂತ. ಹಾಗಾದ್ರೆ we'll give something else. The petitioner is before this court calling in question an e-auction notification dated 1/7/2025 insofar as it pertains to auction of several sites. Ask him to stand there. Auction of several sites. The learned counsel, Srimati Kirti Reddy, appearing for the petitioner, would contend that the allotment is made in favor of the petitioner. The allotment would become a paper allotment if all the sites that are now auctioned would be sold, now put to auction would be sold, as the right of the petitioner under an allotment would be jeopardized. In that light, the respondent BDA, yeah, allot agid site ಎಷ್ಟು dimension?
3040 site, my lord.
3040.
3040. 1200 square feet. 1200 square feet.
Therefore, the BDA shall not auction the property as obtaining in the prayer, shall not auction a property as obtaining in the prayer which measures 1200 square feet till the next date of hearing. Two. Ajay Kumar, counsel Ajay Kumar is directed to accept notice for the respondent petitioner to serve set of papers upon the aforesaid counsel. Place the matter on 5th August.
I'm so grateful.
Yes. Next.
Number 5.
Guest lecture.
Please, my lord.
ನೆನ್ನೆ ಕೊಟ್ಟನಲ್ಲ ಯಾವುದು?
My
ಎಲ್ಲ
lords,
ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಟ್ಟು ನೆನ್ನೆ ಒಂದು ಸುಮಾರು ಗೆಸ್ಟ್ ಲೆಕ್ಚರ್ಸ್
My lords, that is actually, it has to be tracked with writ petition 18658.
ಯಾವುದು ಕೊಡಿ ಮೇಡಮ್, ನಂಬರ್ ಬರ್ಕೊಡಿ. ಅದ್ರಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಆಗಿದೆ ಅದು ಸೇಮ್ ಮಾಡ್ರಿ.
My lords, yesterday what has happened is, this is those matters
Tagged
are,
with something else, is it?
they're all previous matters, my lords, the previous
ಆಯ್ತು,
notification.
ಅದು ಯಾವ್ದು ನಿಮ್ದ್ರಲ್ಲಿ
I'll
ಯಾವ್ದಕ್ಕೆ
give
ಟ್ಯಾಗ್
the-
ಹಾಕ್ಬೇಕು ಕೊಡಿ, ಅದನ್ನೇ
Please, my
ಮಾಡಿ.
lords,
ಸೈನ್
I'll-
ಮಾಡಿ ಅಪ್ಲೋಡ್ ಆಗೋಗಿದ್ಯಾ?
Please, my lords.
ಓಕೆ, ಲೆಟ್ ಮಿ ಸಿ, ಅದು ಕರೆಕ್ಷನ್ ಮಾಡ್ತೀನಿ.
Please, my lords, much obliged.
Seal number 6. CS Vinod.
ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ
Lords, on the last occasion, my lords.
CPC.
CPC, my lords. Last occasion, the respondent had come before this honorable court, appointment of commissioner.
Now why have you come?
I have come on the guys, like on the premise, the commercial court, my lords.
ಅಲ್ಲ, ಅವ್ರು ಬಂದ್ರು ಅಂದ ತಕ್ಷಣ ನೀವು ಬರ್ಬೇಕು ಅಂತೆಲ್ಲ ಯಾಕೆ ಬಂದಿದ್ದೀರಾ?
ಇಲ್ಲ, ತಹಸೀಲ್ದಾರ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾರೆ. ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀನಿ. ಸ್ವಾಮಿ ಹೈಕೋರ್ಟ್ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ತಾವು ಆಕ್ಚುಲಿ ಅಟ್ ಪೇಜ್ ನಂಬರ್ 81 my lords.
38
81 my lords.
81 ಮೈ ಆರ್ಡರ್.
ಹೌದು ಸರ್, ತಮ್ಮ ಆರ್ಡರ್.
ಓ, ಇದೇನಾಯ್ತು ಇದು ಮತ್ತೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಮಾಡಿದ್ನಲ್ಲ?
ಕ್ಲಾರಿಫಿಕೇಶನ್ ಮಾಡಿದ್ರಿ, ADLR
ಹೌದು
ಸರ್ವೆ ಹಾಗೂ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಮಾಡಕ್ ಬರಲ್ಲ, ಹಂಗಾಗಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಇನ್ನೊಂದು ಅರ್ಜಿ ಹಾಕೊಳ್ಳಿ.
ಅದು
ಸರ್ವೆ ಬಂದು ADLR ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ನಾಟ್ ಇನ್ ಸ್ಪೆಸಿಫಿಕ್ ಟರ್ಮ್ಸ್ ADLR ಮಾಡ್ಬೇಕು ಅಂತ
ಬೀಯಿಂಗ್
ಏನಿಲ್ಲ.
ಸ್ಪೋಕನ್ ಟೋಲ್ ಮಾಡಿದೆ ಅದು.
ಹೌದು, ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟೋಲ್ ಮಾಡಿದಿರಾ? ಅವರು ಮೆಮೋ ಹಾಕ್ತಾರೆ ಸ್ವಾಮಿ, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ತಹಸೀಲ್ದಾರ್, ಟು ವಿಚ್ ಐ ಫೈಲ್ IA ನಂಬರ್ 22.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ, ಯಾರು ಮುಂಚೆ
ಸರ್ವ್ ಮಾಡ್ತೀನಿ ಸರ್. 21st ಗೆ
the petitioner to serve on the counsel who represented the respondent in ನೀವು petitioner ತಾನೇ ಅದರಲ್ಲಿ?
ನಾವು ಡಿಫರೆನ್ಸ್ 1 to 4
ಡಿಫೆಂಡೆಂಟ್ ಅಲ್ಲ ಅದರಲ್ಲಿ
ಅದರಲ್ಲಿ
who represented the petitioner therein, petitioner in page 69 madam. There shall be an interim order of stay of further proceedings before the concerned.
for the execution of warrant ಮಾತಾ ಕೇಳಿ.
There shall be an interim order of stay of the impugned order till the next date of hearing.
Handsome. 21st
21st ತಾನೇ ಇರೋದು, ನಾಳೆ ಬೆಳಗ್ಗೆ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ.
ಮಚ್ obliged.
ನಾಳೆ ಬೆಳಗ್ಗೆ ಅಪ್ಲೋಡ್ ಮಾಡಿಸಿ.
ಮಚ್
Petitioner and respondent number 2 are the employees of my lord first respondent board. My lord, based on the minute of my lord, the honorable chief minister, transfer is effected. Posting me to my lord head office. Third respondent is posted to my lord Mysore. We both of us were promoted by order dated my lord 31/7/2024.
ಏನು ಪ್ರಾಬ್ಲಮ್ ಇದೆ?
Lord, the petitioner and respondent number 3 were promoted as executive engineer on 31/7/2024.
Posting is given on promotion?
Yes, my lord.
All right, Ellie.
I am posted to Mysore. She is posted to my lord Ramnagar.
31/7/2024.
1
ವರ್ಷ ಆಗಿದೆ.
1 ವರ್ಷ ಆಗಿದೆ. Lord, now she is posted to my place. I am posted to head office against.
So what exchange ತಾನೆ?
1 ವರ್ಷ. Lord, based on the minute of my lord.
ಪರವಾಗಿಲ್ಲ. So exchange ಅಷ್ಟೇ ತಾನೆ?
That matters a lot.
ಏನ್ ಸತೀಶ್ ಇವೆಲ್ಲ ಹಿಂಗಂದ್ರೆ?
That Lord.
ಇಲ್ಲ ಅದು ಇಟ್ಕೊಳ್ಳಿ.
For a government servant, Lord, place matters.
ಏನಿಲ್ಲ. Placement matters. Yes. The petitioner is before this court calling in question an order of transfer. The petitioner and the third respondent as executive engineers were promoted on the same day, i.e. on 31/7/2024. The petitioner is said to have been retained at Bangalore and the third respondent to Mysore. Barely after 1 year of the posting, on a minute of the Honorable Chief Minister, there is a swapping of place. The third respondent comes to the place of the petitioner and the petitioner moves to the place of the third respondent.
Head office.
Moves to the head office without showing any posting. The order of transfer is thus premature and is hit by several illegalities. One such is that a government servant should not be transferred without showing a posting. The said issue stands covered by the judgment of the division bench of this court in the case of ILR 2020 Karnataka 4511 H Kantepa versus so and so, in which the division bench follows the earlier judgment of H Seema versus State of Karnataka, AIR 2017 Karnataka, page 59. Therefore, there shall be an interim order of stay of further proceedings, stay of the impugned order till the next date of hearing.
Annexure F and G both.
Stay of annexure F and G till the next date of hearing. ಅದು ಕರೆಕ್ಟ್ ಅಲ್ವಾ? AIR 2017 Karnataka, AIR 2017-2 Karnataka, page 59. Seema versus State of
H Seema.
H Seema. This is Jayant Patel.
Yes.
Yes. Yes, sir. ಇನ್ನೇನ್ ಬೇಕು?
ಏನು?
ಮತ್ತೊಂದು ಪ್ರಮೋಷನ್ ಬೇಕಾ? ಇಲ್ಲ.
ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ.
ಎಸ್. ಅದು ಯಾರ್ಯಾರಿಗೆ? ಕೇವೇಟ್ ಯಾರಿದ್ದಾರೆ? ಸತೀಶ್ ಕೇವೇಟ್ ಇದ್ದಾರೆ. ಸರ್ 230 ಮೂವ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ಮತ್ತೆ?
I have informed, not I have served. Acknowledgement is also not pasted.
ನೀವು ಇಬ್ರು ಒಟ್ಟಿಗೆ ಪ್ರಮೋಷನ್ ಆಗಿದ್ದಲ್ವಾ?
Acknowledgement is also there.
All right.
I have informed.
ಈಗಲೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬಿಡಿ ಏನಾಯ್ತು. ಅವನೆಂಟು ಎಲ್ಲ ನೋಟಿಸ್. ಥರ್ಡ್ ಕೇವೇಟು 1 and 2 HCGP is direct. HCGP ಅಲ್ಲ, ಯಾರು ಗವರ್ಮೆಂಟ್?
Mr. T Nataraju appears for
1 and 2.
Yes, I'll serve.
T Nataraju is directed to accept notice for 1 and 2. ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ
ಎಸ್
ಒಂದು ಸುಮ್ಮನೆ ನಮ್ಗೆ ಇದು ಮಾಡ್ತೀರ. 230 ಮೂವ್ ಮಾಡ್ಬಿಟ್ಟು ತಗೊಂಡ್ಬಿಟ್ಟು ಅವ್ರು ಕೇವೇಟ್ ತಗೊಂಡಿದ್ರು. ಕೇವೇಟ್ ಕರ್ಕೊಂಡ್ಬರ್ಬೇಕು ತಾನೆ?
ನೋಡ, I have informed, Lord, he said.
ಈಗ ಒಂದು ಫೋನ್ ಮಾಡಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ
ಎಸ್
ತಗೊಂತಾರಂತೆ ಅಂತ ಹೇಳಿ.
ಆಯ್ತು, ಈಗೂ ಮಾಡ್ತೀನಿ.
ಮಾಡಿ. ಡಿಕ್ಟೇಟಿಂಗ್ ಯಾವ್ದು ಮೇಡಮ್? ಡಿಕ್ಟೇಟಿಂಗ್ ವಿಲ್ ರಿಸರ್ವ್ ಇಟ್. ಡೆಫಮೇಷನ್ ತಾನೆ?
Prepared a synopsis. May I just pass it on?
I know, will reserve it. Yes. Reserved.
No, I'm saying, my lord, I've prepared a synopsis. Can I just pass it on?
Give it. Reserved. ನೀವು ಹಾಕಿದ್ದೀರಾ ಚೇತನ್? ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ದೀರಾ? ಏನ್ ಬೇಡಲ್ಲ.
To Delhi High Court and authorities and additional list of authorities are placed.
With kind leave, my lords. Hand delivery, my lords. I'll take it tomorrow. Please, my lords.
Other hearing 23.
Em Pradeep?
Matter is there. Seal number.
ಫಾಸ್ಟ್ ಓವರ್ ಯಾವುದು?
Seal number 3. ಅಲ್ಲಿ ನಾಡಿದ್ದು ಹಾಕು, ಮಂಗಳವಾರಕ್ಕೆ ಹಾಕು.
ಮಂಗಳವಾರಕ್ಕೆ ಹಾಕಿದ್ದೀನ?
ಅಲ್ಲಿ ಹಾಕ್ಬಿಡಿ ಸರ್. ಇದೆ. Ravishankar, senior counsel is also, Lord, is not.
One second.
Seal number 3.
So,
ಅದೇ ವೈ ಅನಿಲ್.
Yes, ma'am. Short passover.
Short passover.
Portal number 12, ma'am. In the middle of the argument.
ನಾಡಿದ್ದು ಮಂಗಳವಾರಕ್ಕೆ ಹಾಕು.
ಮಂಗಳವಾರ ಮೊದಲೇ ಜಾಸ್ತಿ ಇದೆ ಪ್ರದೀಪ್.
ಗುರುವಾರ
ಹಾಕೋಣ 24.
24th. Much obliged, ma'am.
ನಿಮ್ದು ಯಾವುದು?
23. Next. 23, serial number 23.
Service.
It is a short question of refixation of salary on the basis of the 7th Central Pay Commission.
ಹಾಕೌಟ್ ಐ ಆಮ್ ನಾಟ್ ಟೇಕಿಂಗ್ ಎಕ್ಸೆಪ್ಟ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಬೇರೆ ಯಾವ್ದು ತೊಗೊಳಲ್ಲ. ನೀವು ಹಾಕೌಟ್ ಅಲ್ಲೇ ಕೇಳಬೇಕು. ಇದು ಇನ್ಚಾರ್ಜ್ ಕೋರ್ಟ್.
ಒಂದು ಡೇಟ್
ಸರ್ವಿಸ್ ಲಾಲ್ ಇನ್ಚಾರ್ಜ್ ಇದ್ರೆ ಏನು ಮಾಡಂಗಿಲ್ಲ, ಬರೀ ಡೇ ಟು ಡೇ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಮಾತ್ರ.
Date, is it possible?
23 list 1 23 further hearing.
ಅಲ್ಲ ಅವ್ರು ತಗೊಂಡ್ಬಿಟ್ಟು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ಬಿಟ್ಟು.
21.
Will dictate it.
May I make a humble submission, my lords?
What?
If I may be permitted, make a humble
sir,
submission.
do it. Yes.
Please, my lords. Much obliged. In fact, the writ petition is not maintainable, my lords. The reason being,
lunch hour.
Yes, my lords. My lords gave me sufficient time to read the file as well. If I may bring to my lords' attention.
Why not maintainable?
Yes, my lords. If my lords may kindly peruse.
Yes.
In page number 42, my lords. The order, my lords.
Yes, sir.
The last paragraph. IA number 5, filed by the plaintiff, is allowed exercising power under order 7 rule 11D of CPC read with section with order 8 rule 6A4 of CPC. The counterclaim filed by the defendants is hereby rejected as barred by law under section 12A of the Commercial Courts Act, since it is filed without complying the mandatory requirement of pre-institution mediation. My lords, which means order 7 rule 11 application is allowed. An appeal has to be filed.
Commercial OS ಅಲ್ಲ?
Yes, my lords. My lords, that I agree. My lords are also well aware of the fact.
Jurisdiction ವಿಷಯವಾಗಿರೋದು. Yes, Sunil Kumar.
Lord, now the application that they filed is under order 8 rule 6C. That is not under order 7 rule 11.
Application ಯಾವ್ದ್ರಲ್ಲಿ?
ಅವ್ರು ಹಾಕಿರೋ application to remove the counter claim under order 8 rule 6C, my lord.
Then how is it passed under order 7 rule 11?
That was at para number 18, my lords. Para number 18.
So it was not an application under order 7 rule 11.
No, it is not, my lords. It is an application under order 8 rule 6C. But the trial court, my lords, at para number 18, if I may bring to my lord's attention at ink page number 28.
That is another illegality which I should interfere.
Please, my lord.
I agree, my lords, but only humble submission is this.
You agree, then
No, I said I have to bow down to my lord's observations, but I may be permitted to also submit, my lords, wherein.
Submit, sir.
Please, my lords.
Yes.
My lords, this honorable court is very well aware of the fact the non-mentioning of a provision, correct provision, should not disentitle me from seeking the relief sought for. If I were seeking an order 7 rule 11 rejection, is the same as order 8 rule 6C, which is also rejection of the counterclaim itself. And moreover, at para number 18, if my lords may kindly peruse the highlighted portion, my lords, at ink page number 28. The observation, my lords, is that therefore it is clear that even in respect of a counterclaim, the court can exercise its power under order 7 rule 11 of CPC to reject the counterclaim in case it is barred by law. Despite whether I invoke order 7 rule 11 or not, my lords, the court has an inherent power when the counterclaim itself is not maintainable, when it's barred by law.
Counterclaim was not, it's not that it's meant, or because of
that way. Yes, my lords, because of section 12A of the Commercial Courts Act. Let them file an appeal, my lords.
Why, sir?
Because the writ petition is not maintainable, my lords.
The application is filed, my lord, under order 8 rule 6C, and the learned judge, as lordship rightly observed, he makes an error there. He
goes into different jurisdiction or under Order 7 Rule 11. Now, my lord, along with the written statement, I have filed my counterclaim. There's no procedure prescribed even under the Commercial Codes Act states that for a counterclaim, you'll have to go back there, finish your process and come back and file written statement. So that will be against the statute itself. And next, the very purpose of the Commercial Codes Act for a speedy disposal. Now they want me to relegate for another 4 months for again mediation process. Very initial process, we both have appeared. It is a failure. And 2 judgments.
No, if I permit him another half an hour to drink coffee and come, he'll come up with another point.
I have to be humble before my lord.
Yes.
But at least
2 judgments which I produced, my lord. Lordship.
The petitioner is before this court calling in question an order dated, what date is that? Order dated 25/1/2025 by which the counterclaim registered by the petitioner comes to be rejected by the concerned court on the score that the counterclaim has not preceded by a pre-institution mediation and as obtaining under section 12A of the Commercial Codes Act 2015, hereinafter referred to as the Act for short. Heard so and so. The respondent is the plaintiff, the petitioners, the defendants. The plaintiff institutes a commercial OS in Commercial OS 1127 of 2024 seeking recovery of money.
Illa, my lords. Is seeking arrears of rent as well as eviction, my lord.
No, only arrears of rent. No,
Seeking arrears of rent from the hands of the defendants. The defendants, hands of the defendant. At the time when the after the institution of the commercial OS and before the commercial OS could be registered, it transpires that the parties were directed to complete the process with regard to pre-institution mediation as obtaining under section 12A of the Act. After the said failure of the mediation, the concerned court registers Commercial OS 1127 of 2024. The respondent, the petitioner's defendants then register a counterclaim. The concerned court was of the opinion that another 3 months should be spent in the pre-institution mediation qua the counterclaim, and therefore answers an application filed by the plaintiff under Order 8 Rule 6C, Order 8 Rule 6C of the CPC, seeking the plaint to be kept in the counterclaim to be kept in abeyance or rejected as the case would be until the pre-institution mediation as obtaining under section 12A would be completed. The rejection of the plaint on the score that the pre-institution mediation has not taken place qua the counterclaim is what has driven the defendants to this court in the subject petition. The learned counsel H. Sunil Kumar, appearing for the petitioner, would vehemently contend that the process of mediation did take place prior to the registration of the commercial OS as obtaining under section 12 of the Act. Therefore, all over again, the counterclaim, when the counterclaim is registered, notwithstanding the fact that it is an independent suit by itself, need not refer the matter for pre-institution mediation as obtaining under section 12A. He would submit that the very process, the very object behind institution of the commercial codes was expeditious disposal. The petitioners would submit, the learned counsel would submit that the petitioners have filed the written statement along with the counterclaim. Now, after filing of the written statement and sending the parties to mediation all over again is not the purport of the Act. He would seek to place reliance upon 2 judgments of the Calcutta High Court, one of the Calcutta High Court and the other
Delhi High Court.
And the other of the High Court of Delhi. Per contra, the learned counsel appearing for the respondent would refute the submission in contending that the counterclaim so registered by the defendant was in itself a suit, and if it is to be treated as an independent suit, section 12 compliance with section 12A is mandatory. He would seek to place reliance upon the judgment of the High Court of Delhi in Saroj Tandon, Aditya Birla fashion. Aditya Birla fashion so and so. Aditya Birla fashion so and so. Reported in 2024 SSC Online Delhi 6099. To buttress his submission. He would further contend the judgment in the case of Aditya Birla versus Sarosh Tandon was tossed before the apex court only to be rejected in limine. He would thus contend that it is the affirmation of the apex court of the finding rendered by the High Court of Delhi, and therefore it is to be followed. I have given my source. Therefore, narrated facts are not in dispute. The issue now lies in a narrow compass as to whether the narrow compass. The issue would be whether on a counterclaim registered by the defendant, Section 12A should all over be followed. Section 12A should be followed all over again, notwithstanding the fact that Section 12A had been complied when prior to the institution of the suit. The afore narrated facts link in the chain of events, and the facts link in the chain of events are not in dispute. Section 12A of the Commercial Code of the Act reads as follows. Section 12A mandates that that parties before the institution of the suit should be mandatorily referred for mediation, which would be pre-institution mediation within bracket PIM. It is not in dispute when the respondent wanted to institute this suit, the parties were referred to PIM, and after the failure of mediation, the aforesaid commercial OS is registered. Therefore, it is a fact where both the parties being the same, have already mediated and have failed in such mediation. The defendants file a written statement along with their counterclaim. The plaintiff now uses this to file an application under Order 8 Rule 6C, seeking the counterclaim to be kept in abeyance or rejected. The reason that the counsel projected before the concerned court was that the pre-institution mediation the counterclaim has not happened, and therefore the counterclaim should not be accepted. The concerned court accedes to the contention of the respondent and rejects the counterclaim on an altogether different provision, i.e. invoking Order 7 Rule 11 of the CPC, and the application was never filed under Order 7 Rule 11 of the CPC. The next para. The reference made by the learned counsel for the petitioner respondent to buttress his submission in Aditya Birla fashion and retail so-and-so has been subsequently considered by the High Court of Delhi and High Court of Calcutta respectively to be distinguished. The two judgments that distinguish the earlier judgment are as follows. The High Court of Delhi and Calcutta take a common view that the purpose of the establishment of the commercial court is for expeditious disposal with an outer limit of 1 year. Once the pre-institution mediation has happened, when the plaintiff wanted to institute the suit, need not happen all over again, notwithstanding the fact that the counterclaim is an independent suit by itself. Therefore, both the courts have, after considering Delhi HC. Both the courts, after considering the issue, have held as follows. One second. The division bench of the High Court of Delhi in 2024 SSC Online Delhi 9272 has held as follows. Para 21 to 26.1. The division bench holds that notwithstanding the fact that the counterclaim is an independent suit, the pre-institution mediation on a counterclaim need not be held all over again, as it was preceded before the institution of the suit. The same view is taken by the High Court of Calcutta in so-and-so, para 8 and 9. Yes. The submission of the learned counsel for the respondent now is that the judgment of the High Court of Delhi, against the judgment of the High Court of Delhi, the apex court, against the judgment of the High Court of Delhi, the apex court has not interfered. Not interfered in the sense that it is the SLP is dismissed in limine. He would seek to buttress his submission by placing reliance upon the judgment of the apex court in the case of Balbir Singh versus so-and-so. the principles so laid down by the apex court in Balbir Singh, there can be no qualm about the principles so laid down by the apex court in the case of Balbir Singh. Para 34 therein reads as follows. Para 34 would indicate that the doctrine of merger had already taken place in this case before it, while the regular second appeal before the High Court had affirmed the view of the concerned court. Therefore, that doctrine having the doctrine of merger having taken place, whether the apex court has dismissed the SLP in limine or otherwise would not matter, is what the apex court has held. The said judgment is distinguishable with the facts obtaining in the case at hand without much ado, as in the case at hand there is no merger that has taken place of an order of the concerned court by the hands of this court. Therefore, on all the aforesaid score, the court that has rejected the plaint on the score that section 12A is not complied with is on the face of it erroneous, which would lead to its obliteration. For the aforesaid reasons, the allowed quashed. The counterclaim is directed to be registered and the procedure to be regulated thereafter.
May I make a humble submission, my lords? Apologies on intervening. My lords, at least the aspect of the writ being not maintainable as contended,
yes. The learned counsel,
that could also be recorded.
Learned counsel for the petitioner, counsel for the petitioner would also contend that the writ petition,
Please,
plaintiff, counsel for the plaintiff would contend that the writ petition is not maintainable as the order of rejection of the plaint is an appealable order and the court should not entertain. The said submission is noted only to be rejected for the reason that the court has committed a further illegality in taking recourse to Order 7 Rule 11 in an application filed under Order 8 Rule 6C, and therefore the submission would not merit any acceptance as it is not the issue at hand.
Please, sir. Much obliged. May I seek for a direction, my lords?
For what?
The trial court to expedite the proceedings.
Now ready this.
Adada nange santosha swami. Please.
Grateful, grateful.
Much obliged.
Who is the answer waiting? Assets. Oh, yes.
You've just given us your objection state.
ಅದು ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಾಗಿತ್ತು ಅಂತ ಮೂವ್ ಮಾಡಿದೀರಾ? ನಾಳೆ ಇದೆಯಾ?
Recollection the last occasion.
ಅಲ್ಲ, it is even prior to the grant of an order, it was aired.
Insofar as what they have engaged him before the order, there is no difficulty in them hearing. But after the Lordship also clarified that the order continues insofar as defendant number 1 is concerned. They are continued to engage him. Our submission is there cannot be any aiding and abetting of the contempt of court. If he is committing contempt, then he cannot be aiding and abetting.
Who is committing contempt?
The defendant number 1. And I have filed an application also.
So maybe a party to
but
the
now,
proceedings.
Defendant number 1 is represented here?
No, he is not a party here because he is not challenged.
Not a party.
Sorry, he is a party here, but he is not challenged the order. Now, I have insofar as that
They will
is,
not commit the same mistake which the court had committed.
no, all I would request is this. The Honorable Court may note. Now they have come and sought the aid of this court and they have had a stay of the order. Your Lordship has also clarified that the stay is insofar as they are concerned. Now it is as if let us proceed on the basis, it is as if there is no order as against them, no difficulty. But tomorrow, if I have to make an allegation there, he should not use this order that he is aiding and abetting the contempt. He should not use this order to say that proceeding cannot go on. At least let that be clarified. Because if defendant number 1, I have now.
You are defendant number 2, right?
I am not a defendant. That's
No,
the
you are
Not a party, correct?
He's not
I'm
a
not
party.
a party to the suit, but what they do is after the interim order is granted, the right to me saying you have to ensure compliance.
That
Which
is-
means 1 minute.
Correct.
Which means that they knew everything is about me.
That is as per the law. It is
ಕೇವೇಟ್ ಹಾಕಿದ್ದೀರಾ ಅದಕ್ಕೆ? ಕೇವೇಟ್ ಹಾಕಿದ್ದೀರಾ? ಅವ್ರು ಕೇವೇಟ್ ಸರ್ವ್
ಅಲ್ಲ,
ಮಾಡಿದ್ದೀರಾ?
no difficulty insofar as
ನಾನ್ ಕೇವಿಟ್ ಹಾಕಿದ್ದೆ trial court ಅಲ್ಲಿ.
ಪ್ರಾಬ್ಲಮ್ ಅದೇ ಅದೆಲ್ಲ ಮಾಡ್ಬೇಕಾದ್ರೆ ಒಂದು ಪಾರ್ಟಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತಲ್ಲ?
Allah, because my relief is
Party
against
ಮಾಡಿದ್ರೆ interim order
D1.
ಸಿಗ್ತಾ ಇರ್ಲಿಲ್ಲ.
My relief is against the first defendant. I have a contract with him. I have intimated them of this contract. I have told them that he is in violation. Then I filed the suit. I am entitled to file the suit. I am not bound to make him a party. Now, insofar as the order of the trial court also, order of the trial court says it is against the defendant. Now, the question is whether, if this honorable court has clarified that insofar as him, there is no order, that the order continues as against first defendant is the defendant is
already
concerned.
clarified that.
Correct. My only request is if this order of stay is there and he aids and abets defendant number 1, first defendant to continue to violate, then I have got.
Wait, sir.
Oh, I'm sorry. Oh,
Mic is on.
mic is on.
Yes.
Fortunately, I did not hear you. I could only hear some
ಅಂತದೇನು
disturbance.
ಹೇಳಿಲ್ಲ ಬಿಡಿ ಅವ್ರು.
He always pulls my leg, so I take it in the right spirit. There's no difficulty.
I have never seen him cross his limits in speaking.
No,
He
no,
will
no.
not do that.
With me especially, he takes more liberty than with others.
Anybody.
But I have also not taken it the same
None of you
spirit.
do that. Yes.
Between us, brother, there's nothing. So, therefore, not my sub.
ಇದು ಈ ಪ್ರೋಗ್ರಾಮು ಹೀಗೆನಾ?
That is, I believe, but there is.
Because name is Kotle Kitchen.
Mine is Burgery Bachelor.
Burgery Bachelor. What's that? That's also a program.
Some reality program.
not seen
I have
either.
not- So, perhaps some finding a bride or something, perhaps for a suitable bachelor. It appears to be Burgery Bachelor.
That's why problem ಆಗ್ತಿರೋದು.
Exactly.
Bachelor
But,
is in what like-
so
You have been signed in this Burgery Bachelor. How can you go
I'm
into the
suitable
kitchen?
groom na ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಹೋಗಿ.
How can you go into the kitchen?
ಅವರು ಭರ್ಜರಿ ಬ್ಯಾಚಲರ್ ಆಗಿರೋದ್ರಿಂದ ವಾಟ್ಲೆ ಕಿಚನ್ ಬಂದಿದ್ದಾರೆ.
ಅದೇ ನಮ್ಮ ಬ್ಯಾಚಲರ್ ಎತ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ. Well, there are people finding him as the suitable
ಅಲ್ಲ,
groom.
ನೀವು ಅವಾಗ-
He's already been.
You already thrown him out of the show.
My submission is this: insofar as I have already filed an
All right,
application for
humor
contempt.
apart, but now tell me, see, I've already clarified that whatever order that
I'm
is
only
passed,
requesting for one.
whatever order is passed is only in respect of.
There is one issue there.
He's
Your Lordship
not
takes
a
the order.
party there.
ಅಲ್ಲ, there is one issue in the order.
ಏನ್ ಹೇಳಿ?
It's a bit ambiguous because your Lordship has said interim order granted is continued. The interim order is as regards defendant.
Defendant number one. Oh,
That is should be clarified. The interim order granted here or the interim, your Lordship may say interim order granted by the trial court is against defendant. Either way, it will clarify. But my only request is
I'll clarify it by
that portion is
detailed order, not a problem.
very good.
But should we keep it? You make him a party and hear it there.
I have no, insofar as he is concerned, my contract is a defendant. If he seeks to implead, it's a different matter. He is not choosing to implead. And my submission is, first, my submission is if he was agreed with by the order of the trial
ಇದು
court.
ಭರ್ಜರಿ ಸಬ್ಮಿಷನ್ ಆಗೋಯ್ತು ಆಗಿಲ್ಲ.
ಒಂದು ಕ್ವಾಲಿಟಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಅದು ಕ್ವಾಟ್ಲೆ ಸಬ್ಮಿಷನ್.
ಅದಕ್ಕೆ para 8 ಅಲ್ಲಿ they say apparently my lord in their objections they say it is also submitted as respondent number one's consistent stand across litigations of similar nature that the broadcaster or owner of the show like the petitioner need not be arraigned for breach of artist service agreement. Therefore, how can your lordships not pass such orders? Because they've already taken a decision, being Z, that they will not make them parties.
No, my submission is insofar
but
as
the prayer will be against Z.
as the plaintiff and the dominant litigant.
Raghavan sir, see, now there is an order here. You implead him in the proceeding. I will close this proceeding and continue this order for some time. Let him secure an order from the hands.
My request is this. Your Lordship has now said the interim order is insofar as D1 is defendant, main defendant is concerned. Now the difficulty is
The main defendant Allah. Main defendant you are
the only defendant who is there.
The only defendant who is there.
Correct.
Now I have granted an interim order.
Insofar as they are
for the
concerned.
petitioner. He is
Correct.
neither a defendant nor
Correct.
a plaintiff there.
All that I am saying now is, after taking this order, they have continued, in my humble submission, they have continued to engage with him in violation of the interim order which binds him. I am not saying about them.
Binds
but
whom?
binds the defendant.
How can I pass an order?
No, therefore
on
all that I am
defendant number
requesting.
one who is not here.
No, therefore I am not, I have already filed an application there for under order 39 rule 2A insofar as violation of the welfare disabilities of the order is concerned. Now my submission is insofar as this petitioner is concerned, my grievance is he is aiding and abetting him to violate the order. I have a cause of action insofar as making him a party in the contempt proceedings also.
Precisely why you should implead him.
No, a person who aids and abets a disobedience of the order need not be a party. Then so far, if I were to proceed against him for contempt, in the contempt proceedings, in the miscellaneous proceedings, he'll be a party. Kindly may I just place reliance on just.
No problem. You then
Therefore,
carry on with
my
filing
difficulty is,
contempt against
then if
defendant
the
number
petitioner
one.
will say, there is an order of stay and therefore that should not need to. Therefore, the honorable court
I
may only
will-
clarify
I will
that this will not
clarify-
come in the way of any proceedings of
This is getting
contempt.
an injunction in the reverse way by getting a clarification saying now he is aiding and abetting, therefore let me punish him for contempt. Therefore,
That is permissible under law.
1 minute, Raman, please. I am not going to narrate all that. I am only going to clarify my order that it is qua the present petitioner who is not a party to the proceedings there. It is not binding on any other defendant who is a defendant or who is a defendant there in the concerned court.
It is not binding in the trial court order. Not binding.
Is not binding
order,
on the
this
defendant that is there. This order. This order would not be binding on the
This order.
defendant there. Yes.
Because ಅದರ ಸ್ವಲ್ಪ wording ನಲ್ಲಿ became a bit
I'll
ambiguous which they are going to. And my request is this: Your Lordship may also clarify that this order will not come to the aid of anybody who is aiding and abetting to the defendant. That's sufficient for me. Because now he will, if I will make it, I'm going to make an, I'm stating so. I'm going to make an application for the, for taking action against the petitioner for aiding and abetting the defendant. But the Honorable Court may clarify that the stay order will not come in those proceedings, because I should not be, then if I make the application, I should not be accused that I am doing something contrary to the court's order. That should also not be said. Then I will be said, I will be held in contempt of this Honorable Court's order. Therefore, my request is that should be clarified, because the law is clear insofar as a person who, against whom an injunction is not granted and who is not bound by the order, still he is expected not to aid and abet a person who is bound by the order. That's all I would just place one judgment of our High Court and one judgment of the Supreme Court on this aspect. That therefore,
1 minute, he is the petitioner. You are wanting to take your order in his petition?
Allah, now because the stay order is granted, my
I'll clarify that.
It will not come in the way of my application.
Aid, abet, it will amount to you taking an order in his petition.
No. All that I would say is I should also not be held in disobedience of this.
No, that's all right. You cannot perform your marriage in somebody else's family.
Point not.
Okay, but I should not be, because the order of stay which is granted should not then the court or he will complain that I have committed contempt by filing the application. That's the only.
That you are committing very soon. I'll tell you. Your Lordship have found fault with them.
Friday evening repartee.
Your Lordship
Yes.
Your Lordships have found fault with them for not making a party and asking for practically a relief against me, because the prayer says Your Lordship had noticed specifically.
No, that I saw.
And the trial court is granted the defendant.
1 minute, I understood.
Now,
mic off ಮಾಡಿ.
ಅದು ಅವ್ರ ಪ್ರೋಗ್ರಾಮ್ ಪ್ರಾಬ್ಲಮ್.
ಮೈಕ್ ಅವ್ರ ವಾಯ್ಸ್ ಎರಡು ಜೋರಿದೆ. ನಮ್ಮ ವಾಯ್ಸ್ ಇಲ್ಲ, ಮೈಕ್ ಬೇಕು.
You should give voice to the voiceless.
Yes, but his prayer, as your Lordships had noticed last time, it says, including but not limited to Quartley Kitchen.
Correct, yes.
And so basically you are asking for a relief against me indirectly. Therefore, if you have done that, then necessarily you must make me a party.
Correct.
What your Lordships found fault is with them not making him a party and getting this interim order from the court. Now, if that is the case, he cannot come to your Lordship and say, now leave it open on the question as to whether I can proceed against him on contempt or not. Because
this order would bind you.
Yes, this would bind me.
And would equally bind him. Pay you.
Correct.
Pay others, how can it be?
Not others. He wants to say.
No, I only heard him.
Yes. Yes.
Nothing is in writing still.
No, I'm just pointing that. That's all.
I may submit that.
ಈಗ ನೀವು ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಲ್ವಾ?
I am not required to make them a party. Let me put it
to the petition be pending then, no problem.
Let me put it also and come back. But in the meanwhile, what is happening is every weekend they are continuing to engage him. He is violating the order despite having been informed of the court order. In the face of the court order which binds him, and after being clarified, he is brazenly participating and being aired even this Saturday or weekend also.
He is not participating in your program, is it?
No, I have called upon him to participate. And now he goes and no, this is clearly an instigation being made.
They removed him from that program fully.
If he does not do, what can I do? I have to carry on my program. That does not mean I am looking for him. He is still the eligible bachelor.
1 minute. How married is it?
No, he is still the eligible bachelor.
That bachelor program, they removed him fully.
If only he can be removed only if you are married.
Correct.
He became deemed ineligibility.
He is married in a different way. Commercially, he is married.
They've done something. They removed him from that program, but they don't want him to do any other program. That's the real idea.
I have written to him calling upon him to come.
He's terminated your contract.
The petitioner, this court on 4/7/2025 had passed the following order. The learned counsel for the respondent submits that the order is generating certain obfuscation with regard to its applicability to other defendants or defendant/S. Yes. Therefore, I deem it appropriate to clarify that the order dated 4/7/2025 is passed in the wake of the present petitioner not being made a party to the suit in OS 907 of 2025. Ada? 907 of 2025. The learned counsel appearing for the respondent submits that he is wanting to take certain proceedings further against the other defendants. If that be so, it is.
Defendant and those who are aiding and abetting him. That's my statement.
No. The
that is my statement.
ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಲಿಬರ್ಟಿ ಕೊಟ್ಟಂಗೆ ಆಗ್ಬಿಡುತ್ತೆ ಆಮೇಲೆ ಅದಲ್ಲ. So it submits that he's
Then your lordship
wanting
may just say for violation of the order. That's all.
he is wanting to take proceedings against the other defendant/defendant. This order, it is needless to observe that this order would not come in the way of any further proceedings being taken by the plaintiff before the concerned court. The order dated 4/7/2025 is passed in the wake of the petitioner not being made a party and all rights of the petitioner being stifled pursuant to the interim order so granted by the concerned court in OS 907 of 2025, in which the present petitioner was not a party. Therefore, I again iterate that the order is confined only to the present petitioner.
Meanwhile, I have filed my objections. Lordship, counter on hakittu. I think it has been filed today. We have served a copy on them also. Your lordship may have it next week so that I'll take instructions also on what your lordship, what fell from your lordship on that.
Yes.
So that
Party ಮಾಡ್ಬಿಟ್ರೆ ಅಲ್ಲೇ ಕಳಿಸ್ತೀನಿ.
I'll take
All of you
instructions.
fight together.
This interim order is to be
The interim
As
order
clarified.
as clarified today stands extended till the next date of hearing.
great. Lordship may some day.
Date of hearing, yes. Yes, answer.
after 6 weeks.
ಪ್ರೋಗ್ರಾಮ್ ಯಾವ ಪ್ರೋಗ್ರಾಮ್ ಮುಗ್ದಿರುತ್ತೆ ಅಷ್ಟೊತ್ತಿಗೆ ಎರಡು ಮುಗ್ದೋಗಿರುತ್ತಾ?
Next week.
Next week, 1st August. 15 days.
No.
Sorry, 30th August. 30th July.
30th. Very well. Grateful.
Yes.
Further hearing 23.
Yes. ನಟರಾಜ್ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ.
Actually, on the last occasion when they filed a memo, notes we have communicated note to various notes bar councils with respect to notes either apportionment of notes stamps are concerned, and we found note that there are certain places notes where note there is a separate stamps notes being printed with respect to the clerks. For example, notes we are here notes we are paying 30 rupees for the 20 rupees for the application. Their note it says 20 rupees we have to pay to the advocates. Plus 2 rupees notes to the clerks are concerned. They are separately printed. And Andhra Pradesh notes and
ಆಯ್ತು, ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ?
ಇದರಲ್ಲಿ ನನಗೆ 2 weeks time. So that notes will get a clarifications with respect to notes. What is the basis for coming to such a conclusion? If it is so, then we'll
2 weeks ಇಲ್ಲ, I'll take it on 31st.
Please.
List on 31st at the request of Nataraj.
Please.
Representing the Bar Council of Karnataka.
Please.
Yes. ಇದೆಯಾ ಕೊಡಿ. ಶ್ರೀನಿವಾಸ್ ಎಲ್ಲಿ ಗುಲ್ಬರ್ಗ ಹೋಗ್ತೀರಾ ಬೀದರ್ಗೆ ಹೋಗ್ತೀರಾ? ಫೈಲ್ ಮಾಡ್ದೇನೆ ಮೆಮೊ ಮಾಡಿದ್ರೆ ಹೆಂಗ? Not given, not shown posting. From where to where? BBMP regulations ಬೇರೆ ಇದೆ. 76/2013 ಗೈಡ್ಲೈನ್ಸ್ ಅದಕ್ಕೆ ಅಪ್ಲಿಕಬಲ್ ಆಗಲ್ಲ. ಬೇರೆ ಗೈಡ್ಲೈನ್ಸ್ ಎಲ್ಲಿ? Where is that? 13/6/25 is the ಮಾರ್ಗಸೂಚಿ. ಇದು